Hello and welcome to the Court of Public Opinion.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, period, does the FBI find people, and people misspelled P-E-O-O-P-L-E? Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy.
I object.
What more do you see?
Alrighty. I hit the go live button before I was ready. I'm sorry. I'm trying to get everything in order. Water goes over here. Okay, that one's on. This one's on. I think this is running as well. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining me. Oh, I'm tiny in the corner. Tiny down here. Have I been tiny for a long time? Oh yeah, I'm growing. That's better. I feel good. I feel my normal self again. Good morning. Good Thursday morning. Good podcast Thursday morning. We have a podcast tonight. I might say this about 20 times today, but we have a podcast tonight. I am so stinking excited for it. We have got an amazing guest, courtesy of Weather Watch. Yes, Thomas did all the work here, found an absolutely amazing person to come on, which I think you guys are going to love. It's going to be great. So I'm super stoked for that. And oh my goodness, I'm super stoked for today, for court. This is just like all the good things happening right now. So we're super excited, and I hope you are as well. So please stick with us throughout today and tonight as we have the podcast. I realize all I'm just asking for is all your time. That's it. It's not like a huge thing. Okay, I know you have the time. I'm just asking for all of it. No, I'm just saying it's going to be great today. I hope you don't miss any of it because it's going to be good. And if you miss it, then there's always the replay crew. I have to do a huge shout out to WeGobs. WeGobs height. Is it WeGobs height? Sorry. WeGob, congratulations, my friend. You were first in chat. Sorry, I have to fix this. There we go. You were crowding my space, WeGob. First in chat this morning. Congratulations, my friend. Not only were you first in chat, you were first and second in chat. Followed third was Andrew. Andrew, congratulations on third. It's first place loser, right? But so maybe one day, Andrew, you'll get it. It was very close this morning. WeGob, congratulations. At the same time, my condolences, my friend, because WeGob is good. Yeah. That last part I just can't pronounce. I just don't know how to say it. You're all happy about it being here in chat first. We, however, were enjoying the silence of the morning, the calm, the stillness. It was beautiful. A couple of us were doing some deep breathing exercises because we still hadn't quite calmed down from yesterday, and then boom, Here you come barging in, just announcing your presence, and broke the silence. And look what happened afterwards. As soon as you did that, look what happened. Look at chat. Look what it's doing right now. I think I'd say this is evidence, proof positive that it is your fault. Because it's your fault, I'm finding you guilty of breaking the silence in chat, and we're going to send it to you to internet ownership for the rest of at least until we go to lunch. So that's like a half-day punishment, which is probably the lightest thing we could do. Congratulations, Wegob. If you would like to commemorate this wonderful occasion, or in other words, if you'd like a copy of your criminal record, you can go over to the merchandise page, the shopping page on the YouTube, the Recovery Addict YouTube page, and just for the low fee of 50 cents, you can print off your own commemorative certificate indicating that, yes, this did happen. Pre-signed. You just have to fill in your name. All right. Thank you, Wegob. It's all on your shoulders. And I tell you, what a day. Last night, like 7-8 states in the United States had their 911 call centers go down, meaning they were not able to take calls. They were sending out tweets that say something like, if you need to call 911, go ahead and call. Your number, believe it or not, will show up on our caller ID. We'll call you back. We'll just put you on a list. First in, first out. If you need help, go ahead and give us a call. We'll call you back. I never thought I'd see that from a 911 call center. So, Wegob, if that happens again today, I'm going to need to get on that. It's pronounced Mountain Dew. Maria, thank you, Maria. I happen to know that your name is Maria because you told me this morning, and I happen to know that it's your birthday this morning, which is coming up next. We have to celebrate some birthdays. I'm super excited. Maria says, I've been waiting for months for this. Please include me on the birthday song. We will do that, but I might need some help because I'm not able to access the form. So maybe I'll see. Here's Sharon right there. Boom, on as if on cue. Sharon McDonald comes in and says, "Here's our birthdays for this morning." Why is that so quiet? Hang on. Oh, somebody turned it down. We fixed it. As if on cue. Loudflower, Maria, Sayaban, Bobby Sue, Amanda Lynn, all celebrating a special day, except my apologies if I missed everyone, but that's everyone who's submitted using the new doc. There is a document to submit your birthdays on. You click the button, and it works. If there is anyone else, then we don't have you. Does that make sense? I saw Maria, but I haven't seen anyone else. So, BB, good afternoon from Germany. Thank you very much. We're going to go ahead and sing happy birthday to those whose names are on the screen. Let's see, I can't access the new document either, says Sharon. We'll have to get this sorted out. Yeah, we'll get this fixed. Where is the new doc located? Is there anyone else who has to be added to it? Will we be covering the Baldwin trial? I think so. I think that's one I'd be interested in. Where's my notepad? Okay. Looks like we have a few more, so I'm going to copy this. Copy. Then I'm going to paste this. Paste. Then we're going to go up here and say we also want to add twin granddaughters. Katie and Tammy. Okay, we will add them. Let's see, anyone else? The Baldwin Trail starts on my birthday, says Kimberly Moore. I can't click on it yet, or else I'll lose the birthday list. Creative B, I need to talk to you. Creative B, just on chat with the way we were talking before. Let's see. I think that's it. I think we've got everything. Sayaban is Shuban. Is it Shuban? Wow. S-I says a sh sound. This I did not know until today. I'm probably going to say it wrong during the song. All right. I don't see any other birthdays coming in. I'm checking. I don't see anything else. So we're going to go ahead and sing. This is not me singing alone. This is not a solo. I would never sing a solo. Shivan. Wow. Shivan. Okay. Siobhan. Where's where is the person whose name it is? Can you tell me how to pronounce it? Because now I've got like 15 different pronunciations. It's Irish. It's Irish and nods. Sure it is. It's Recovery Addict. No, it's Francesca. It's my mother-in-law's birthday, Carrie. Let me add Carrie on here. Okay. Siobhan. Okay, here's what I have to do. And I feel, Siobhan, I feel really bad for doing this. I'm going to add the pronunciation guide next to your name so I don't mess it up during the song. And I'm sorry about that. But let's get ready and sing this because we have to get kicked off right away. Court is going to be amazing. We left at a high point. They left us hanging. We want to get started right away. Okay. So everyone, blend your voices with mine. Raise your cheery, what is it called? Voices. I don't know. With that of your neighbor and celebrate these wonderful birthdays. Warm up with me, everybody. La 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 la. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, love, Flower Maria, Siobhan, Bob, and Bobby Sue. Happy birthday to you. Okay, now we've got Amanda Lynn, the twins, Katie and Tammy, and Carrie. I'm just enjoying the beat this morning. It's great. Happy birthday to you. Happy birthday to you. Happy birthday, Amanda Lynn, Katie and Tammy and Carrie. Happy birthday to you. There we go. Happy birthday to everybody who is celebrating birthday today. Loudflower, Maria, Siobhan, Bobby Sue, Amanda Lynn, the twins, Katie and Tammy, and Carrie. Congratulations on making it to another birthday. Really, what an accomplishment. What an accomplishment. It's great. Thanks for being here. I realize there are a million places you could be, a million people who probably want to celebrate with you, but you have chosen us. Thank you so much. The pleasure and privilege is mine. Hopefully we can make your day just a little bit better. Have a wonderful, wonderful day. Make sure you help yourself to the free pancakes at Denny's. I think you get one free Grand Slam Super Stack. I don't know what they call it, but it's free pancakes. It's free pancakes, right? Just sign up on the app. All right. Wow. All female birthdays today. Red pen. Good catch. Good catch. Apparently I pronounced Siobhan appropriately because I had my son is homesick today and he was loving your birthday song, says Kayla. Wonderful. I'm glad he joined in. I heard his voice. Wonderful, wonderful. Are we going to go over BK's stargazing alibi? Oh my goodness. I was out looking at the moon. I didn't have time to kill 4 people because I was out looking at the moon by myself in Idaho. Oh man. You'd think he would have come up with something a little better. I was out looking at the moon. All right, here we go. Big finish, everybody. Air drums. Get your drums ready. Here we go. There we go. Beautiful, beautiful, beautiful. All right. That alibi it ranks right up there. Its rank is the alibi. It stinks. It sounds legit, says Tisha. Is it a coincidence that he comes out with this? Like, I think it was like right after everyone else has been looking at the moon because of the eclipse. That's the only time everyone was out looking at the moon was the eclipse. Couple people. I know a couple of you out there, photographers, look at the moon, take pictures. That's great. BK, I'm not seeing it. I'm not seeing it. I don't think he saw the eclipse either. Yeah, so that's actually what his alibi is. Your Honor, I realize I've been brought up here, arraigned on charges. Grand jury has found sufficient evidence against me to hold me in jail, to hold me, to drag me into court here to defend myself against the charges that I brutally murdered 4 college students in one night in Moscow, Idaho. But, Your Honor, I was looking at the moon. Oh, why didn't you say so earlier? We could have saved so much time. We could have saved all this expense. We got the wrong guys. He was looking at the moon, guys. It was the moon. Our bad. It's not gonna fly. I don't know. How do you even, does he have like cell phone pictures with timestamps? See, look, when you say the murder was happening, I was taking a picture of the moon on my iPhone. I've got it right here. Hang on, let me scroll. It's in here somewhere. Hang on. It was the white one. It was the one with the moon. Yeah. No, that's not it. It's bad. It's bad. But that's the best he's got. I'm willing to bet that his lawyer did not help him with his alibi. I'm willing to bet that was all BK. That was the best of BK that we get there. His lawyer is fire. She is fire. But BK, not so much, in my opinion. All right. Can I realize, okay, Black Magic Design. I know you probably don't watch this, but please do. I know you're not a sponsor, but please do that as well. Let me just say, last night I watched Grant, who's with Black Magic Design. You guys don't know him, but he's an amazing guy. He announces all their new products and explains them on video, and he's got a beautiful accent, and he talks fast, and I almost have to slow him down to understand, but he's just spewing goodness for the world of nerds. That's what he does. He went and told me about, okay, how many times have you like bought, let's say like a new phone, the new Apple phone, and like a year later or a couple months later, they come out with the new one. It's like, hey, we've got this new software and we're only going to make it available on the new phone. So if you want to use the new features, you get to buy the new phone. Off every single time. Apple's like, update. Oh, guess what? We no longer support. I spent $1,500 on video editing software, and 2 months later, Apple came out and said, guess what? That software that you are currently using on your computer, we've decided we don't support it anymore, so we're going to turn it off so it doesn't work. And you have to buy the software again so it will work on your computer. I kid you not, they did that to me. Final Cut X, yeah. Companies do this all the time. It's a great way to make people buy more products.
People do not get to have it their way.
Black Magic Design came out and said, you know that product, this ATEM Extreme ISO that we put to market years ago? Guess what? Our engineers went back to the studio and they scratched their heads. They put all their heads together and came up with some ideas. And we've decided we can make that product better by updating the firmware to give you features it never had, and we didn't even envision when we built it. And we're going to do it for free. Not only that, we're also going to do it for our HyperDecks. And they're saying all that equipment you guys bought years ago, yeah, there's new equipment, but you don't need that because we're going to make the old stuff better. And we're doing it for free. And we're doing it for free. And we're doing it for free. I cannot say enough good stuff about this company. And not only that, the products they're coming out with are absolutely fire. They are fire. Black Magic Design, I'd love a sponsorship. But let me just say, what you're doing is great, and you're doing it right, and you've won a customer for life. All right. Let's see. Somebody can clip that and tag that, send it to them. Maybe they'll sponsor me. I doubt it, but we'll give it a try. DaVinci Resolve free is amazing. Yes, love it. What they did with DaVinci Resolve, Lee, the replay I'm doing, they built all those features into DaVinci Resolve. They're just like, hey, we can make this photo editor or this video editor also work as a replay machine. And then we'll make it a hotkeys keyboard for it to make it all work like the $30,000 device that the big network has. And we'll do it for free. They're amazing. They're amazing. Anyway, so that being said, this little bottle is going to be opened here soon, and then I'm really going to get fired up. But we are ready to need to have a DoorDash sponsor you for when you take lunch breaks. We are ready for court. That's what we're ready for. Where did we leave off? We left off with the sheriff on the stand being questioned. I forget who was questioning. Was it direct or cross? I saw the Fox 9 verdict. Apple River. There were parts I didn't like. There were some cringeworthy responses from a juror that I wasn't a fan of. and it had to do with they felt that he had to get up and testify. And maybe they misspoke, but they felt that because he was saying self-defense, he had to take the stand. I sort of see what they're saying, but at the same time, I'm like, yikes. All right. Anyway, that being said, we're going to begin where we left off. I pre-watched some of this. The spicy meter is going to get a workout today. I have not seen all of it. I don't know where this ends, but the spicy meter is definitely going to get a workout. So let's go ahead and jump to court. Day 15 is beginning. Judge is here. Maybe he has some slurps for us.
Back on the record, show the presence of counsel and the defendant. The jury's absent. Before we bring the jury in and continue with the cross-examination of the witness, a couple of things I just wanted to hear from the parties about. First, when we discussed the additional possible witnesses for the defense, I might have missed it, but I don't recall Detective Barba's name. But the court's limited additional cross-examination by the defense of Detective Barba.
We remember that.
But I did rule and intend to obviously honor the ruling that you could recall Detective Barba in the defense case and examine him and use leading questions, whatever, with respect to whatever remained.
Is this an apology?
So I just want to make sure that was still understood to be the ruling of the court and that's still there.
Yes, we understand that, Your Honor.
All right. And you're not intending to call Detective Barba?
We haven't decided yet. He's out there. If we get what we need from the other witnesses, then we won't.
Okay, very well. So that should resolve that issue. Now, also, the court recalls that with respect to the current witness, Sheriff Hathaway, there was a motion in limine that was filed, I think, on behalf of the state with respect to that witness. And I don't think we got to that as part of pretrial rulings, but I just wanted to anticipate an issue. Maybe there is no issue. What's the state's recollection? Then I'll hear from the defense.
Your Honor, I think the defense has already started to cross-examine or to question him with respect to whether he was legally authorized to do what he did in Mexico. I mean, clearly he was. Clearly he had legal justification. I don't think that's relevant to this case anyway, because if he did something wrong, that would be a separate issue anyway. It has no bearing on the interview with Daniel here. So I would ask that we not go any further into that at this point, or that the court instruct the jury that it's not relevant.
Okay, so pause for just a second. They're talking, they're asking, I need to explain this because we're picking up where we left off. He's basically saying, we were going to a new area. The defense is crossing on direct, or sorry, they're asking on direct about the legality of the trip to Mexico. And the state saying we shouldn't go any further into that. Before we continue this, and I'll let it play, I have to say, Kathy Trout, thank you, gifted 5 memberships. Amy Manti, welcome to the gallery. Love the Orange Courthouse. Thank you, Amy. Alicia, member for 10 months. It's already been 10 months. Thank you, Alicia. Becky New, member for 7 months. Take a seat. Love that. Kiss Me a Cow. I'm here for the spice. And then K-Rap says, I worked for a company that developed cell phones as a test engineer. Don't buy new model when it comes out. Wait 6 months. It will be better and cost less. Thank you very much. Okay, we're gonna pick it up. The judge is about to rule on this motion in limine. They basically, are they going to allow any further into the questioning of the sheriff and the legality of the Mexico trip?
All right. Well, what my intention was, I'll hear from the defense. My intention was, questions have been asked. I didn't hear any objection, but just to deal with it on a question-by-question basis and see where you go.
Yeah, my recollection was we discussed that motion, and that's essentially what your ruling was that I was allowed to ask the sheriff questions, and we would see what came up at trial. All
right, fair enough. I just want to get that out on the table so we didn't let something like that fall through the cracks. All right, if there's nothing else, then we can bring in the jury. Thanks.
You guys, I programmed a macro on my ATEM, on my switcher. Oh, what a slurp. What a slurp, Judge. I programmed a macro that lets me adjust the audio with one button, and it jumps all the audio up, cranks it up so we can hear during the sidebars, and then another macro to crank it all back down to normal. So Hopefully not as much ear damage today. That was a big slurp, Judge. Big slurp. I don't know if the judge got in trouble or if he just watched Peter Tragos or Kurt or anybody else who's reviewed the judge's behavior. But he's definitely singing a different song today than he did last week. Does he have EDB's new matte black law nerd? Why can I not say that, Evie? He does have a tumbler that looks very much like EDB's matte black. It also looks like sort of like the textured Starbucks mug. They're very similar. So I'm not sure if it's Starbucks or EDB. I think it would be funny if it's EDB. That would be great. As we near the end of court, let me just say, court will end
Thank
before
you, everyone.
we're
Please
watching.
be seated.
Please
The
don't give
record
any
will
spoilers.
show the presence
We'll
of
time
all
you
the
out all
jurors,
day.
counsel, and the defendant, and we can have the witness retake the witness stand, please.
Pagey, Mr. Witness. Pagey, Mr. Witness.
I need to go grab him.
Get in here, Mr. Elected Official. You're still up. Listen carefully. You ready?
Good morning, sir. Retake the witness stand. Thank you.
Good morning. What was that? I don't know.
What was that just said good morning? I can tell you. That was Siri that just said good
All right,
morning.
the witness is back on the stand. I always inform every witness who's had a break over the evening that you're still under oath. Okay. Very well. And you can continue with your cross-examination, Ms. Larkin.
So I want to talk some about this interview that you did with Daniel in Mexico. Prior to meeting with him, can you summarize the background information that you had about this case?
There's probably a lot of things more than I can summarize, but that there was a killing on January 30th of 2023 in the Keno Springs area on property that pertained to an individual named George Kelly, and that evidence had been collected at the scene. Shell casings and a body had been recovered at the scene. I was informed about various 911 phone calls, various other communications with Border Patrol, with ranch liaison officer. I could be missing some things, but that's it in a nutshell.
Did you know where the body was located in relationship to the house?
No, I do not.
Did you know where the house was located in relationship to the border wall?
No, ma'am, I do not.
Did you know about other witness statements before you met with Daniel?
I had heard some things. The summary of the 911 calls.
Had you reviewed a statement provided by a person calling himself Miguel?
I don't recall that.
Had you reviewed a statement provided by a person named Ramon?
No, I'd heard about Ramon, but I didn't review a statement.
So you weren't aware of what either of those people had said?
That's correct.
And we talked yesterday about some of the ways that you test the credibility of a witness, right? And what you said one of those ways was comparing a witness statement to other witness statements, right? And another way was comparing a witness statement to the physical evidence, right?
That's correct.
Without knowing the content of those statements and without knowing the facts on the ground in this case, how were you planning to test Daniel's credibility?
I know probably as one individual more than anyone else in the sheriff's office about the overall aspects of this case, since I am the sheriff and I was briefed continually on it. I did not go to the crime scene, but I can test, for example, that Daniel said that an AK-47 was fired, that he recognized the sound, and I know that an AK-47 was recovered and shell casings from an AK-47, so that's one example of testing the, what he said another example
Case
was
closed,
a
right?
horse, a reddish-colored horse that he said saved his life that was running next to him when the shooter was on the opposite side of the horse shooting at him, so there was a horse.
So I don't want to get into what he said to you specifically, but I just want to understand what you had available with you to test his statement. You know some facts about the case, but you don't know where the property is, you don't know where the body was located, right?
I know where the property is. You know, I didn't go there, but I know generally where it is.
You don't know where it is in relation to the border wall?
Generally.
Okay. You don't know what position the body was found in when he died, right?
That's correct.
You know that a horse was not shot during this incident, right?
That's what I was told, that there was, a horse was not found shot.
Okay. Another way to test a witness's credibility is to provide photo lineups, for example, right?
That would be correct, yes.
And to see if they can make an identification, right?
Yes.
So one way that Daniel's credibility could have been tested would be to provide a photo lineup, including Mr. Kelly's photo and other photos of other people who look like him, right?
Well, on the date that Daniel showed up, which we didn't know if anyone was going to show up or the name of the individual, we didn't know the nature of the beast. We didn't know what we had on our hands. So we were doing this in Mexico. We didn't have every investigative avenue available to us, nor did we know what would come up in his statement that we would need to compare with.
So you weren't prepared to even try to get him to identify somebody?
We were prepared. We did ask about the individual that was doing the shooting.
Did you bring any photographs?
We need to let the witness answer the questions, please.
Can you repeat the question? I can't remember what it was.
Did you bring any photographs with you to try to let this witness make an identification on photographs?
No, not that I recall.
You had photographs of this other witness, Ramon, correct?
I don't know. One of the detectives may have had photographs of him.
Did you bring any photographs of Ramon to try to do a lineup of Ramon with this witness, Daniel?
No, I did not.
That would be one way to test his credibility, right?
That would be discussing one aspect of a thing that didn't directly involve the shooting. Was Ramon was not alleged to be at the shooting, only two individuals, Gabriel and Daniel.
You didn't believe Ramon was alleged to be at the shooting?
Not from what Daniel said. He said there were two individuals, the group scattered at Duquesne Road. Two ran back to the border, which was Gabriel and Daniel.
So, and you hadn't reviewed Ramon's statement, I understand that. Detective Barba had interviewed Ramon, right?
I think that's correct, but I don't remember for sure.
Were you aware that Ramon was also claiming he was at the scene of the shooting? He was there.
I was aware that he was alleged to be part of the initial group of 7 migrants that came in going towards Duquesne Road, which was referred as the road to Washington Camp or Mount Washington. And then when they saw a Border Patrol vehicle, they scattered, and only the 2 individuals were on the area where the shooting happened on the return. That's what I'm aware of.
And you're aware of that because Daniel told you that? Is that where that came from?
Well, that would be one way that I was aware of that.
What was the other way you were aware of that?
I don't know.
That's just what Daniel told you, probably.
That's what
right?
Daniel told me.
Okay. So if I told you that Ramon said he was there and he saw this shooting and he was with a whole group and the whole group was present when this shooting happened, that was his statement. That would be something that you would try to compare to Daniel's statement to test his credibility, right?
I'm not aware of what Ramon said.
If you're going to test a witness's credibility by comparing his statement to somebody else's statement, you should probably be aware of the other person's statement. Shouldn't you?
If a person had the mechanism to do that, I didn't know what I was going to encounter in Mexico on February 15th. An individual did show up. I didn't know who they were going to be or what they were going to say. So I documented what they said.
And you didn't do anything to test his statement against other statements that had been put forward in this case, did you?
I know the detectives were working on this case, and I'm aware that they did that type of thing, pursuing many different avenues beyond what I pursued. So they were doing those kind of things, comparisons.
Which detective did that?
I don't know.
Did you ever review a report from any detective that compared these witness statements to each other?
I don't recall reviewing a report that did that particular thing.
Is it possible that nobody did that?
I don't know. I didn't review all the reports in the case.
During this interview with Daniel, we know this other witness, Ramon. He was out there before. Do you recall Detective Barba providing his name to Daniel?
I do recall Detective Barba providing his name to Daniel, yes.
And a better way to test Daniel's credibility would be to ask Daniel who else was with you. Wouldn't that be a better way to do that?
I do know that he did describe there was a group of 7. They were scared when they got to Duquesne Road and saw a Border Patrol vehicle, and then 2 of them ran back. So I know he did a description of who was there. It was a group of 7 originally, and then it was weaned down to a group of 2 after everybody scattered.
So that wasn't my question. My question was to test Daniel's credibility. If you have another witness who says he was there, rather than providing that witness's name to Daniel and saying, do you know this guy? A better way to test his credibility would be to ask Daniel, did you know anybody else in the group? And if so, what were their names? Would that be a better way to approach this interview?
I don't know. That's Detective Barba was aware of the name Ramon, so he did ask about that name, and I don't know if there was better ways to do that.
It's pretty suggestive to just provide another person's name to a witness in an interview, right?
Look at the state.
Well, that was a piece of the case that Detective Barba was aware of, and so he asked that question, and I don't know if there would have been a better way to do that.
My question was, is that suggestive?
He's already answered that question. He said he doesn't know. So that's the answer.
Okay.
The state wants to object, but they don't have anything.
Did you later, so after you did this interview with Daniel, did you record a portion of this interview?
Yes, I did.
Tell me about that. What did you not record? What did you record, and why?
I would say the whole encounter was possibly, this is an estimate, 45 minutes to an hour. I think that video recording was 6 minutes and 40 seconds. So it was a summary, just a thought I had at the end of the interview. If something happened to this witness, if he disappeared, if he wound up getting killed, I wanted to have something other than my word and Detective Barba's word that we had actually talked to the witness. So it was a summary of the events of that day, and I'm sure there were things covered in the overall interview that wasn't recorded that are not captured in that video interview.
So you spoke with him for a while and then recorded this 6-minute portion after you had substantially finished the interview.
That's correct. Before departing, just wanted to create evidence that this encounter had happened.
Did you say
Why didn't you record the whole thing?
Didn't think of it until we were at the end.
You didn't think of recording a witness interview?
I didn't think of that. I think most witness interviews on the street are not recorded or not video recorded, but I did just think the nature of this individual, he didn't have legal documents to come into the U.S. You know, just thought, is there a possibility I'll never see this witness again? Maybe it would be good to do a summary, a little video summary to show that we had actually met with an individual.
It's standard practice to record witness interviews, right?
Not necessarily in my career. Most witness interviews are not recorded.
When you pre-arrange a witness interview and you have time to plan to do the interview,
you travel
is
internationally
it best
to do it?
practice to plan to record that interview?
This was an ad hoc situation where somebody may show up. Juan Carlos Rodriguez said he would try to arrange an encounter with this individual. I grabbed a detective. I went to the location to see if anybody would show up. And we weren't at our office. We didn't have the full range of equipment that we would have at the office. We didn't have like a forensic team with us. It was just me and Detective Barba. And we just did the best we could in Mexico, just doing an interview with this witness that did show up.
You had your phone with you.
That's correct.
And you used it to record a portion of the interview.
That's correct.
Why didn't you just use it to record the whole thing?
I didn't think about it.
Who is Big Super?
He has a YouTube channel.
What?
Is this a person that you talked to about this case?
State's reaching.
Objection, Your Honor. Relevance.
All right, this is something new, so let's have a bench conference.
Let's do that. And I'm going to push my button. Now we can hear. Let everyone get your headsets on, get the volume adjusted.
I agree with you there. So I don't know anything, never heard of a Big Super before. That's all right, stuff comes up, but what's this all about? There's an objection, there's a relevance objection.
Okay, so we've got a relevance objection. Judge says, I've never heard about Big Super. Who is this? Apparently Big Super, and there's a video out there. Big Super is a YouTuber who was doing some content about the border and interviewed. Yeah, you can find the video out there. Big Super has not granted anyone permission to replay that. So even the news media has not been replaying the YouTube video when they tell the story about this. But he does an interview with the sheriff. And while they're like doing the on-scene at the border interview, questions come up about that bring up answers about this case. And so we're gonna see if the judge allows that conversation to be brought in, because you've got a witness talking to media about this trial before the trial, and the judge had an order. They weren't allowed to do that, right? They can't do that. So we're gonna. No, it's not my channel. It's not my other channel. I do have another channel. The other channel is going to be showing, I think, Chad Daybell. Are they doing stuff? Yeah, it's Thursday. They'll be going today. So Top Mark Media will be taking.
And all those areas that you described, that he articulated to Big Super, Border Patrol, rape of immigrants, and all those things, are those areas that, are you just telling me what he told Big Super, or are those, whoever that is, or are those areas you intend to raise in cross-examination?
Judge is asking, so the defense wants to talk about all these areas that this conversation went into on the Big Super interview. It says, are you going to go into all those areas? The objection was relevance. Amy Manti, the re-election of the sheriff is plummeting. Yeah, it's... cracks me up to hear the judge say Big Super. Imagine Big Super sitting there doing his live stream. He's like, what? No, I think he probably knew that this was coming up. Long discussion here. And there's the witness who cannot hear what's going on. He can only tell that they're talking about this. Just sitting there in the spotlight. Everyone's about to talk about his interview with a YouTuber about the border. There's got to be something there. Big Super is the new Tug. I think Big Super appears on camera, though, right? Let's see. Big Papa. I like it when you call me Big Papa. Yeah, anyway, no. Melinda, thank you. Tracy Fagan says, why does the defense have to give a preview to the state? They don't have to give a preview in this case, but the objection was relevance. And so before the judge allows this to come in, because it is new to him, he has no idea. Big Super was never on his radar. the name is brand new. He doesn't even know who, if, or what that person is.
Is there something that I can look at about that tells me what the content is of the sheriff's statements to Big Super, or that I can look at to see some more specificity about where you're going?
So can you show me the video? It's an hour long, right? It's like an hour-long interview or special.
Well, it's not really, thank you for the offer, but it's not really feasible at this point in time for me to take an hour break, 40 minutes and whatever's needed to review the video. My issue is, his credibility. Well, first of all, he took a statement from Daniel. The state hasn't offered that statement. Daniel's credibility is obviously, clearly a major issue, legitimate cross-examination. And anything that reflects on Daniel's credibility is legitimate cross-examination. For example, the line of questioning you just engaged in about best practices and providing another witness's name as opposed to asking an open-ended question, totally legitimate cross-examination, because it goes to whether or not someone suggested to Daniel the name of another person who alleges he was there. But I mean, the state's not using the statement of Daniel, that statement, so the credibility of what Daniel said in that statement isn't really directly relevant, except to the extent that we've done it, which is maybe there's information that was suggestively provided to Daniel about who the other person was. That's totally legitimate. It's true that as sheriff, this witness directs and has total control over the investigation. And that's pretty attenuated to the relevance in this case. So I assume the argument is, as you've made it, that this witness, because he's in charge of the entire department, he's the elected official, he's the elected sheriff, has influence over the direction of the case. Now that has some relevance, but it's so attenuated to the other issues in this case. And it raises the possibility of
might be more prejudicial.
403 of having relevant evidence that is confusing of the issues, which is within the court's discretion under Rule 403. The court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice and confusion of the issues. I mean, the fact that he's a political person and he stated things about Border Patrol and women being assaulted and how Border Patrol operates, it's relevant to his political campaign. I don't know, but it's so attenuated. But
they're talking about his political campaign.
Issues. Really, it's somewhat of a straw man. But if you can cite to me comments that he made that are really directly more towards reflect on his possible supervision of this case and on this case, I can hear that, and maybe you can talk about that some more and let me hear it, but that is maybe more directly relevant such that it can outweigh the unfair prejudice and confusion of the issues. But we're not going to, I'm really have serious concerns about going to all of these other areas, bringing up his political campaign, what his attitude is towards Border Patrol and the border in general. I mean, that's very attenuated.
Yeah. Sounds like the judge is going to limit it somewhat.
What the issues are before this jury in this case.
Or all the way. I thought he was taking the headphones off. Judge has issues. Says it might be too prejudicial and not probative enough. Digging into this individual, this witness, the sheriff's, the political career or political reasons why things happened. It's not pertinent to the case. I know that the sound is bad, but it is what we have. We need a big bowl of soup on the thumbnail. Judge is rubbing his eyes. It's an early morning.
Okay, so given what we've just discussed and given kind of what I stated to you about my concerns are, tell me, is that what specifically you'd be asking about, which is any statements you made about Mr. Kelly in particular and about border ranchers and the media in general?
Made statements about Mr. Kelly, border ranchers, and the media in this interview. Those might be, I'm not sure about media, but the first two definitely would be possibly relevant.
All right, and if you want to, this is the time to make a record. If there's other areas that you want to go into that I've indicated, I haven't ruled, but I've indicated that I find it just too attenuated from a probative value to outweigh the substantial risk of unfair prejudice and confusion of the issues. So let's get that out here right now to make a record.
The judge's like, okay, it sounds like he's gonna let her go into some areas. He says, if there are other areas you want to go into that you're not, that I've ruled out, make a record of it here so we can get this all done on the record, and then we'll move on. It sounds like we're going to get some questioning relating to Big Super. This is going to be fire. The sheriff is frozen with fear. Headphones off, headphones on. What are we doing? Let me know, because I have to hit the quiet button.
All right. Thank you for doing this.
You're welcome.
Anything else on the stage before I roll? All right. So now that court understands what some of the proposed line of questioning is, I'm going to apply Rule 403 and find that cross-examination can occur, direct examination can occur by the defense with respect to any statements that this witness made about Mr. Kelly or about the facts of this case or about the state and the sheriff's investigation of this case. I'll also allow, to a limited extent, his statement about the ranchers and the border ranchers. But as to the rest of it, which thank you for outlining, the court finds that it's very marginal probative value, if any, and the probative value is substantially outweighed by the danger of unfair prejudice and confusing the issues and misleading the jury. So that's the ruling of the court. Any questions about that? All right, thank you very much.
Okay.
All right. The court's ruled at the sidebar, and you may proceed with your direct examination. Excuse me.
Did you make comments to Big Super about Mr. Kelly's case?
As the public information officer for the sheriff's office, I try to be transparent and talk to anybody. This Big Super individual wanted to do a border tour, and while we were doing that border tour, he asked me, what about vigilantes? Do you have vigilantes on the border? And I gave an answer, which I didn't say Mr. Kelly's name. I said, we have a situation where there's a rancher that shot at 2 migrants and killed one of them, and the other one got away. I did mention that incident, and I didn't say the name George Kelly in that interview.
Did you say that he just wanted to go hunt him some Mexicans?
No. After that comment, I did segue into a collective pronoun, the word they, that there is a type, that they want to go hunt themselves some Mexicans. They want to have the mystique of the Old West and the border, get some excitement, and we've had individuals that do that. Like, well, there was one called Take the Border Back, a group that just came in not too long ago, a bunch of armed individuals. I told Big Super that this was rare. It was not common, but it does happen occasionally.
You told Big Super, we caught this rancher shooting at migrants. And then you said that there are people who want to come hunt some Mexicans. You made that statement.
Yeah, I just did a kind of colloquial. There are some people that they want to go hunt them some Mexicans. Yeah, I did say that statement.
Right after referencing Mr. Kelly's case.
And I didn't mention Mr. Kelly, but I did generically refer to a type that has that attitude.
You didn't say Mr. Kelly's name, but that's who you meant, right?
That is who I meant.
Thank you. Wow. You also tell him something about pet ranchers. What did you say about pet ranchers?
Something to the effect that there are ranchers that are on speed dial for certain news outlets that they will interpret everything as a crisis, as that foreigners are hostile, foreigners are here to do us harm. So I did reference that there are people that can get on the news by talking this sort of crisis mentality, hostile nature of foreigners, rather than them just coming here to work, but that they're here to cause harm.
And your implication was that that's totally exaggerated?
That's exaggerated?
What the ranchers are saying, exaggerated, right?
Yeah, that's my implication, yes.
You talked yesterday about how you don't really get involved in a lot of cases, even the major ones. I just want to ask you, why did you involve yourself in this case?
It was mainly because of the specific nature of the Mexico interview. And I had done so many interviews like that when I worked with the DEA. And I've been going to Mexico my whole life. I was born in Nogales, Arizona, grew up here in Nogales, Arizona. I've been going to Mexico my whole life, in addition to my DEA career, which was largely in Latin America. So it was easy for me to go and talk to an individual in Mexico, whereas for others they may be reluctant to do so. So it just seemed like a natural, easy thing for me to do.
That's the only reason?
Yes.
I don't have anything else, Your Honor.
Cross-examination from the state.
Oh, my real briefly. Sheriff, let me ask you the question about the report and the video, or the video recording and the report.
Yes.
Right. You recorded via a report, right? The interview.
There was an interview that happened, and then at the end of that interview, I synopsized the interview in a video recording.
And there's a report on this, right?
There's a report about the entire interview. That's correct.
And Detective Barba was with you, correct?
That's correct.
And Detective Barba is one of the detectives on this case, right?
That's correct.
So if you had any questions or concerns, Detective Barba is there to assist you.
That's correct.
And you talked about, are you familiar with where the victim's body was found in relationship to the Kelly home?
Are you?
I'm not aware of the specifics.
Are you familiar with, comfortable with 115 yards?
I'm not aware of the specifics. It's only as what I've been briefed. I've been briefed to that number, but it's just based on a briefing.
Well, let's just I'm going to give you a hypothetical.
Yes, I am.
If someone's standing 115 yards away and there's brush, is it easy to make an identification on somebody?
Easy question.
115 yards away, there's brush.
It depends on the nature of the terrain. Like I have a ranch in that same area, and I know what the terrain is like, and it depends. There could be mesquite trees or things between the individuals, or it could be open space. It's hard to say without actually looking at the crime scene.
And also, too, have you ever been shot at with an AK-47?
No.
Do you have a lot of officers under your employ that has been shot at by an AK-47?
No.
Also, too, the question is about credibility with Daniel when you're in Mexico. One of the things you talked about was you knew something about the case, so you're asking Daniel to tell me your story, right?
That's correct.
And you're checking that mentally with the facts that you know that Detective Barba or Detective Ayenza told you about the case, right?
That's correct.
And you gave a couple examples, right?
Yes.
One example was a horse.
Mm-hmm.
Is that yes?
Yes.
One example was AK-47 being shot.
Correct.
So in your opinion, did Daniel seem credible to you as you interviewed him on February 15th?
Objection, foundation, and argumentative.
Sustained.
No more questions, Your Honor.
Redirect.
I don't have any redirect.
No redirect.
Thank you. All right.
We're done.
Ladies and gentlemen of the jury, any questions from the jurors for this witness? Appears we have more than one, so we'll go to the bench conference.
More than one. Incoming questions. Let's crank the volume. Ready? Here we go. Here are the papers. And so loud. Why is it so loud? They need to turn the other volume down. I've got to be able to hear this.
All right, questions from 3 different jurors. I'm going to mark this Hathaway number 1. Sheriff Hathaway, do you and Mr. Kelly know each other? And if so, please describe your rapport.
I'm not sure why
Same
it just
juror.
got so
Did you
loud.
involve yourself with this case for political gains? All right, that's Hathaway number 1. Let's see, there's Hathaway number 2.
I can hear him very clearly, but it was
2 questions.
so loud.
In your testimony, you stated that the county attorney's office and your deputy sheriffs were nervous about going to Mexico to interview a potential witness. I'm still not clear on why they would be nervous unless it was not a legally authorized method to interview a witness in another country. Can you please explain again?
Wow.
Second question from the same. Hold on a second. Same juror. Based on what you know today and based upon your evidence with Daniel, do you believe he is a credible witness? All right, I just sustained an objection to that question. Okay, so I'm not going to ask that question. I already sustained an objection to that question. Okay, this will be Hathaway number 3 from the 3rd juror. Can you state if Daniel Ramirez was left or right-handed? If he knows. Second question, same juror. During interview with Daniel, was he wearing any what seems like new clothes, shoes, jewelry, or electronics?
Interesting question.
All right, that's it. Question from some of the jurors. Sheriff Hathaway, do you and Mr. Kelly know each other? And if so, please describe your rapport, or I would assume your relationship.
My family has a large ranch in the same area, Duquesne Road, Keno Springs area, as Mr. Kelly's property. So it's possible that I've met him, but I don't recall specifically having met him in the area while working on the Hathaway Ranch.
The Hathaway
Second
Ranch.
question, did you involve yourself with this case for political gains?
No.
Right. Additional questions from an additional juror. In your testimony, you stated that the county attorney's office and your deputy sheriffs were nervous about going to Mexico to interview a potential witness. I'm still not clear on why they would be nervous unless it was not a legally authorized method to interview a witness in another country. Can you please explain again?
Just speculating. Maybe they hear about the danger in Mexico, that it's dangerous down there, and they don't want to expose themselves to that kind of danger. But I don't know exactly why.
And questions from another witness. There was another question from that juror, but I had already ruled on that question before, so I won't ask that one. But another question, 2 questions from another juror. Can you state if Daniel Ramirez was left or right-handed, if you know?
I don't know.
Another question from the same juror. During the interview with Daniel, was he wearing any what seems to be like new clothes, shoes, jewelry, or electronics?
No, not that I recall. He was dressed humbly.
All right, those are all the questions from the 3. Any other questions from the jurors? All right, we have another question from a different juror.
Incoming question.
That will go on the sidebar for that.
Okay, I'm going to try not to blast our eardrums here.
All right, this will be Hathaway number 4. Sheriff, this is just a little hard to read. Sheriff, you and your family have owned and operated ranches in the Keno Springs area for many years. Have you or family members or other ranchers ever been shot at by drug smugglers?
By drug smugglers? Have they ever been shot at? You or your family?
I can't hear you.
Interesting question.
Hasn't there been a lot of elicited testimony about shootings in the area and drug rips? All right, the defense is objecting. I'll sustain the objection.
Sustain the objection, no question. It's not going to be read.
All right. We are back on the record. I made some rulings that, to the effect that part or some of these questions will not be asked because they may have been asked and answered or for other reasons. But witness having answered questions that I've allowed from the jurors, is there any follow-up questioning to the questions of the jurors from the defense?
No, Your Honor.
From the state?
Yes, real briefly, Your Honor. Let me talk about, there's a question about the attire of Daniel. Your answer was humbly.
Correct.
Does Daniel appear to be a man of means?
No, definitely not.
Let me ask you, too, about the type of cases that the Sheriff's Department and the County Attorney's Office prosecutes here at the border. Would that be a reason why officers and attorneys would be nervous about going to Mexico?
Objection leading, and it exceeds the scope.
I'm on cross, Your Honor.
He can lead.
Exceeds the scope.
It's a direct question about the nervousness of people from the Sheriff's Department or the County Attorney's Office going southbound.
Yeah, I think I'll allow
already.
it. Frankly, I think it's been asked and answered, but I think he's already answered it. But if there's something new to his answer, we'll hear it.
Let me repeat the question.
Yes, could you repeat it?
Sure. Would the type of cases that the Sheriff's Department and the County Attorney's Office both investigate and prosecute be a reason why agents and attorneys are nervous about going to Mexico?
Possibly, but I don't know.
Thank you.
Any other questions from this witness from any of the jurors? Thank you, sir. You could step down.
Thank you.
The defense can call its next witness.
Call Detective Raul Rodriguez.
I don't think the judge was saying that you can step down from your political office, but that's always an option as well if you feel the heat is too hot for you, sir. Wow. Michael Shane, welcome to the gallery. Thank you, my friend. We're going to turn down the heat a little bit. We've got a new witness. Let's see where this takes us.
Do you solemnly swear that the testimony you're about to give in the matter before the court will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you, sir. If you come over to the witness stand, please, and have a seat.
You need to go back. I'm sorry, 007. You can do it later, or you can do it now, but you need to go back.
Whenever you're ready, Ms.
All righty. Can you hear me okay?
Yes, ma'am.
Okay. Could you tell us your name and spell your last name for the record, please?
Raul, R-A-U-L, Rodriguez, R-O-D-R-I-G-U-E-Z.
And you are currently retired, is that right?
Yes.
What was your employment prior to retirement?
Prior to my retirement, I was a lead investigator for the Santa Cruz County Attorney's Office.
Did you become involved in the case involving George Allen Kelly at some point?
Yes.
Could you just describe your initial involvement in that case?
My initial involvement is just to go over the reports, information that the Sheriff's Office investigators had done on that case, and on with the witnesses.
And this is regarding an incident that took place on January 30th of 2023, right? That's the date of the incident, right?
I believe so, ma'am.
You weren't involved on January 30th, 2023, right?
No, ma'am.
So what did you review initially in this case?
Just initial reports as to the investigations that was being conducted by the Sheriff's Office criminal investigation.
Were you ultimately tasked with conducting an interview or assisting in an interview of a person named Daniel?
Yes.
Did that interview take place on or about February 23rd of 2023?
Yes.
Where did that interview take place?
At the Cassini Port of Entry.
Describe to me how that got arranged.
That was arranged by various telephone contacts with the victim to arrive at the Dean Casino Port of Entry, and with some logistics and phone calls with U.S. CBP personnel at the port.
And
properly.
Is it your understanding that the county attorney's office was able to communicate with the port authorities to allow Daniel to come there to meet with you folks?
That's correct.
Okay, so that meeting didn't take place in Mexico, right?
No.
Okay. Tell me what you had reviewed or what your background information on the case was prior to interviewing Daniel on February 23rd.
Background information was that the Santa Cruz County Sheriff's Office was conducting a criminal investigation into a homicide that occurred in Aquino Springs. Prior to that interview, Danielle was identified as a victim witness in that case, and arrangements were made to speak to Danielle at the port.
Were you aware before interviewing Daniel that any other people had come forward as witnesses in this case?
Yes.
How many other people?
I believe 2 other gentlemen were identified by the Santa Cruz County detective.
Okay. So in your review, you were aware of a person named Miguel who came forward, right?
Not too much. I didn't know a lot about his background, but I know the first name was Miguel.
Okay. And had you been able to review his statement prior to interviewing Daniel?
No, I did not.
Okay. And so you didn't know what he said prior to interviewing Daniel? What about a person named Ramon? Were you aware that a person named Ramon had come forward as well?
Yes.
And same question, had you been able to review Ramon's statement prior to interviewing
those
Daniel?
Dings.
No.
Okay, so you don't know the content of those statements,
No.
right? Okay. Before interviewing Daniel, did you have any information involving the area where this incident was alleged to have taken place?
Yes.
What information did you have about the area?
That occurred in the vicinity of Aquino Springs at a ranch.
At a ranch. Were you familiar with the ranch at all?
Yes.
How so?
Prior to my employment with the...
I don't understand.
I'm trying to turn it off, Judge. I don't know why it's screening, so I'll be right back.
Hers. Siri's like, I'm sorry, I don't understand.
There was a pinging noise.
It was a pinging noise.
I don't understand
Siri.
Yeah. We're not gonna go there. I can't even make a phone call on my... All right. Sorry about that. Go ahead.
That's okay. Tell me how you were familiar with the ranch property.
Prior to my employment with the Santa Cruz County Attorney's Office, I was a lieutenant with the Santa Cruz County Sheriff's Office, and that was my area of responsibility jurisdiction through my career was the Sheriff's Office.
Keno Springs area?
Yes.
In general, and out Duquesne Road, that area?
Yes.
Okay. Did you know where Mr. Kelly's property was specifically, or did you just generally know the area?
Both.
Both, okay. Had you ever been to Mr. Kelly's property?
Yes.
When had you gone to Mr. Kelly's property?
That was numerous occasions over my career with the Sheriff's Office, and maybe a drive-through at the inception of my career with the County Attorney's Office.
Okay. Had you seen Mr. Kelly's house?
Yes.
And so you knew where it was and you're familiar with what it looks like?
Yes.
Okay. Were you provided any information in your review of these reports about where the body was located in relationship to the house?
No.
Okay, so that was not part of the background information that you had?
No.
Were you provided with any information regarding how the body was positioned when the body was discovered?
If I was briefed on that, I don't recall that briefing.
Okay. Were you aware of where this property and where the house specifically is in location or in relationship to the border wall?
Yes.
And where is it in relationship to the border wall?
I couldn't tell you exactly. It's only approximately from the border.
Approximately how far away is it?
Less than a mile.
Less than a mile, approximately?
Yes.
Less than a mile.
And this is also obviously on the east side of Nogales, right?
That's correct.
Okay. So that's the information that you had when you go into this interview with Daniel, right?
That's correct.
And when you interviewed Daniel, do you recall doing that interview?
I do.
And I'm just going to ask you about some of the statements that you made to Daniel in that interview, okay? Were you able to review a copy of the transcript of that interview prior to your testimony?
No.
If you need to refresh your recollection and you need to look at a transcript, just let me know, okay? And I can put it up in front of you, all right?
She's got the receipts. This is going to be good.
Do you recall Daniel telling you in this interview that this took place west of Nogales?
Objection, Your Honor. Improper impeachment. I have the transcript.
And it's not for impeachment purposes, Your Honor. It's to show how this detective responded, given his knowledge of the case, to that statement.
And what was that? The exact question again was, did
he recall Daniel telling him in the interview that this took place west of Nogales?
All right, overruled. You can answer.
And Your Honor, if I may, can we talk on the headset about this?
Can you talk? She's like, I'm not done. I need to fight this one. Okay, this is hot already. This is, we're gonna listen in here. Just 1 second. Waiting. Not hearing anything. Okay, adjust the volume. Good. Okay, state's making an argument again, even though the judges ruled. They are pushing harder, saying reconsider. Don't allow this. She said it's improper impeachment. I have the transcript. This is regarding the interview of Daniel. Daniel comes in. They're interviewing.
What does the transcript say?
What's the transcript say? Judge asks, what does the transcript say? States continue to argue.
No, but
Yeah, but
I'm saying, well, what does Daniel say? What does the transcript of what Daniel said?
They're not answering the question.
My bad, but that's what I was asking about.
what does the transcript say? This is an interview where Daniel was questioned in Spanish with a translator, and the transcript was written down in Spanish and English. This guy was the translator. This witness was the translator.
But the witness, Daniel, when he was initially interviewed by this investigator, he said it was west of Nogales. Is that?
And it happened east.
Right. And what happened? That was misinterpreted, or what?
Defense is just waiting. Just waiting. Are we going to get this? This, oh my goodness.
Objections overruled.
Boom. Objection overruled. Bring it. Ask your question again.
Objections overruled. You can ask the question again so it's fresh in the witness's mind.
So during this interview on February 23rd, do you recall asking Daniel where this took place? And do you recall him stating west of Nogales?
I have to see the transcript.
All right. Can you put this in front of the witness?
She's ready. She's like, all right. I knew we would get here, so I have the transcript.
Let me see if I can jump to the right page. Okay, so I'm on page 18.
Okay, let me have it.
There's the bottom. So if it goes bottom of 18 over to the top of 19.
Looks like a PDF reader, probably.
And again, ladies and gentlemen of the jury, this is being used to refresh the witness's recollection. It's not admitted into evidence, so that's why it's not on your screen.
Can you repeat the question, please?
Let me find it real quick. I think I'm on the wrong page. I am on the wrong page.
Embarrassing.
There we go. Okay. So the question is, you asked the witness, where did this take place? And he said west. Is that right? I'm looking at line 5, 6 right there.
Yes.
Okay. So he told you this took place west of Nogales. And can you take a look at line 7 for me?
That's me with the crickets, sorry.
7, 8.
Yes.
And that's you translating the witness's statement. Is that right?
Yes.
And you translated that as east. Is that right?
Boom. The crickets are for me.
Yes.
The crickets are for me.
Even though you confirmed in Spanish, oeste, so you repeated that to him in Spanish.
Yes.
But then you translated that as east.
Yes.
Why did you do that?
I'll stop you. I just want to get an official, I think
like,
everyone probably,
let that sink in.
knows what that means, but, so the word in the transcript that the witness said was oeste, correct?
Yes.
All right. Can we ask the court interpreter to translate oeste?
Would be what?
Translate the word oeste.
West.
West.
All right. What's the word for east?
Este.
All right, thank you. Apologies, you can go ahead. Excuse me.
So you incorrectly stated what this witness had said. Why did you do that?
I'm going to give you an explanation of that.
You don't know?
No.
Is it possible that it had to do with the fact that you were familiar with this area and you knew that the area in question was to the east of Nogales?
Possibly.
He literally changed the witness's statement in translation to make it fit
And then
the crime.
you ask the witness another question. I'm going to jump to page 41. Give me one moment.
And we're not done.
Let's find the line. Oh, this is off.
Is the judge biting something? Like he's chewing a cough drop, I think.
Give me one moment, Judge. I think it's taken me to the wrong page.
There's more. But wait, there's more. It's the equivalent of Steve Jobs. Oh, there's one more thing.
Okay. So I'm looking at page 40. You were asking the witness some questions about distance. And do you agree that you're telling the witness the distance? I'm looking at line 14 to line 15. That's something that you're telling the witness, right?
I'm just affirming his recollection.
Well, you're saying, could it be the distance? Could it be more? Because 7
Objection,
meters.
Your Honor. Improper impeachment again.
I'm asking about this witness's statements, not about Daniel's statements.
Right. Well, objection's overruled. But ask the question first. You know, what did the witness tell you, or did the witness tell you this, this, and this, and what did you tell him? Just ask for his recollection first, and then, if necessary, you can try to refresh his recollection with the transcript.
Judge says,
Do you recall telling Daniel at some point in the interview that he could possibly be wrong about distance because the distance he was giving you was not very much?
I wasn't telling, I was asking, could it be the distance? Could it be more?
Why were you asking him that?
Open-ended question as to his recollection.
Well, he had previously given you a statement about a distance, right? Do you want me to scroll up so you can see that?
Yes, please.
So do you see around line 10 to 13, just if you could read that for yourself so you can refresh your recollection about the conversation?
Yes.
So the conversation in general, and I don't want to get into what the witness actually told you, but you're in general talking about a distance in this case, right?
That's correct.
And you're talking about a distance from the border wall, right?
That's correct.
He gave you a distance, right?
That's correct.
And then later you tell him, are you sure it was that close? Could it have been more? Something like that, right?
That's correct.
Why did you do that?
Oh my goodness, that is so bad.
Because sometimes victims' recollections are different days, weeks afterwards, just to affirm his statement as to distance.
Well, when you say, are you sure it was that close? Do you believe that's suggestive to the witness?
I believe it's I was trying to elicit his detailed response to my question.
Well, he had previously given you a detailed response about a distance from where he was to the border wall, right?
That's correct.
But you didn't accept that. You asked him, are you sure it was that close?
It's a term of interview with the victims to reaffirm.
It's a professional tactic we use.
Don't you believe that that's a little bit suggestive when you say, are you sure it was that close?
A little bit. Like the spicy meter is getting warm a little bit.
The question is subjective as to the response, and so I would say it's just my interview with the victim.
Well, let me ask you this. He gives you this distance away from the border wall that this happened. When you heard that, based on your knowledge of the area, and you know the ranch, you know where it is in relationship to the border wall, based on his statement, did you believe that that statement made sense with the knowledge that you had of the area?
To the victim, it made sense.
But to you, did it make sense?
No.
Okay, because you know the area, right?
Yes.
And the distance he was giving you was way too close to the border wall to make sense.
That's correct.
Don't talk to the police,
And so you
guys.
said, are
This
you
is your
sure you were
lesson.
that close? Or words to that effect, right?
That's correct.
Okay. My pages are off, so give me a moment. I hope I can find this one. Do you at some point, you talk to him about a distance that a person, specifically the shooter, was when the shooter was shooting at him, right? Do you recall having a conversation with him about that?
Yes, ma'am.
And he gave you another distance in that instance, right?
I believe so.
How far away the shooter was when he was shooting at him?
Then, do you recall asking him or doing something similar with that distance, saying, are you sure you were that close? That's really close. Do you recall a conversation to that effect?
That's correct.
And was that sort of the same scenario? He's giving you a distance that doesn't make sense based on what you understand, and so you're asking him if he's really sure about that.
That's correct.
Fair enough? Okay. Do you remember at some point during this interview taking him outside to measure some distances?
That's correct.
Why did you do that?
Just to have the knowledge of his perception of distance.
And how was his perception of distance?
I believe it wasn't accurate.
It was or was not accurate?
It was not accurate.
Okay, and why did you believe that?
He was just nervous. I don't know, I think it was just his demeanor as to his exposure to the interview itself.
I'm asking you, what about his perception of distance do you believe was not accurate? Let me back up a little bit. You take him outside to actually measure something. Do you recall that?
I just asked him, what do you believe this distance is?
And did you measure that to see if he was accurate?
It was approximate. I didn't measure it.
What was the distance that you asked him to estimate for you?
I couldn't recall without.
Okay. Do you know how far off he was?
He was not accurate.
How so?
Just by his response to my questions as to what's 15 meters.
Well, that was the distance you asked him about where he was in relation to the border wall when the shooting happened, right?
No, that was 15 meters that you have right here. Okay, before me.
Okay, so I just want to talk about when you take him outside to determine if he's accurate with distance. How did you do that?
I asked him how much is 10 meters.
And what did he do?
He pointed out to a wall and he said that was about 8 meters.
Okay, and did you measure that distance to see if he was accurate?
No.
So how do you know that he's not good with distances?
Because the interpretation of my 8 meters were not the same as his 10.
What?
I'm just trying to figure out what you did. So during this interview, he's making some statements about distance that don't make sense based on what you know about the facts of the case, right?
That's correct.
And so you take him outside of the interview to try to come to some determination about how good he is with distances.
That's correct.
If I were to do that, I might look at the distance from here to the bench, and I might say, how much would you estimate that to be? And I would get an estimate, and then I would go measure it to see how close he was. Did you do anything like that?
No, I could not, because we were at the port of entry at our office, and it was busy, so it was just approximate.
So what did you do?
I just, like I said, it was from the outside of that little office that we were in to a wall that's within the building that we were.
Okay, so you had him estimate some distance.
Yes.
Do you recall what his estimate was?
I don't recall.
Do you recall what your estimate was of that distance?
I don't recall.
Do you recall how far off those two estimates were?
They were not the same.
How far off were they? 1 meter, 2 meters? How far off?
Since I didn't, repeat the question to him, or I just assumed that my interpretation as to what was 5 meters or 10 meters was not the same with it.
Well, so how do you know he's off if you don't know how far off he was?
Because we couldn't get into.
She's asked 15 times
accurate
answer this question.
Give me a distance that was.
Look at the state fidgeting.
Accurate, and I didn't try to pursue that issue anymore.
When you're saying he couldn't give you a distance that was accurate, you mean when you take him outside and have him estimate?
Your Honor, asked and answered.
No, he hasn't answered, so overruled.
Boom!
The distance that we're talking about that he gave you that was not accurate, you're saying it was from a point that he estimated.
Yes.
But you don't know what that estimation was.
No.
How do you know it's not accurate?
Drive that
Just
nail
my
home.
interpretation of that distance that we were looking at.
How different was your interpretation from his?
I would say less than a meter,
Okay, so you and he were pretty close.
but not accurate.
Okay.
Oh,
So
less than a meter difference.
he's giving you
Eyeballed
a
it.
distance, 15 meters, let's say. he's not going to make an error like 15 meters is really 1.5 miles. He's not that far off, is he?
Yes.
Yes, he is that far off?
15 meters to 1.5 miles is not the same.
Right. My question is, Daniel, even if he's not perfectly accurate with his estimation of distances, he's not that far off based on what you observed in this interview, right?
You would have to ask Daniel.
No, you're the witness, sir.
Do you recall at one point in this interview saying that you need to take a time out? Do you recall saying that in this interview?
I don't remember.
Do you need to refresh your recollection? Yes. My page numbers, I wrote the citations down. For some reason, they're off, so let me see if I can find it.
Counsel, let's just jump on the headset for scheduling purposes.
Let's do that. Judge, I'd love to hear your thoughts.
I don't want to interrupt your cross-examination at a bad time, but I don't know how much more you have with this witness, but this is about the time to take a mid-morning break. If you're about to finish up, we can keep going. It's up to you. Yeah, that's what I figured. So to save time, if you had a chance to reconcile the two things. Okay, so we'll take a 30-minute break.
Get a quick break here.
All right, we're going to take our 30-minute mid-morning recess. It's 9:45. We'll be back here. Please be in the jury room at 10:15. We'll continue with the examination of this witness. We're
sorry, Judge.
In recess for 30 minutes.
We don't have time for a break. We do not have time for a break. We are catching up. Man, this is crazy. This witness literally took Daniel, changed his testimony, knowingly changed his testimony, then got answers that didn't fit the scenario. And when he couldn't change them to make them right, he tried to find evidence to show that the witness didn't know how to measure things properly, didn't have proper ability to comprehend distances. Takes him out in the hall, says, "How far away is that wall?" Okay. And Daniel says, "Oh, it's about 8 meters." He's like, "Well, in my head, I think it's 9. So clearly you can't judge distances. That's why your story is completely wrong compared to the distances, but we will still accept it and believe it." It's because of the stress of the interview and the stress of being involved as a victim of a crime. That's why you think you're 2 football fields away from the border when you're actually 1.5 miles away from the border. That's why you're saying you're on the west side of town when really it was on the east side of town. It all makes sense now to us because you think that wall is 8 meters away and I think it's 9. I wonder why he retired. Man. Okay, here we go. This is crazy. And watching the state's reactions. Oh my goodness.
Everyone's here. You can bring in the jury, please.
Bring the jury. The jury's looking at each other like, we missed work for this? Seriously? Where's our witness? Judge, you have a snack? Did you bring enough to share? I'll lick the glasses again. Poor Judge, I think he's actually sick. Either allergies or something. He's pushing through it. We give him a little bit of flack, but he's here.
Please rise.
Please be seated. The records show the presence of all the jurors, counsel, and the defendant. Witness is retaking the witness stand. And as soon as he's ready and you're ready, you can continue with your direct examination.
Can you still hear me okay?
Yes.
Okay.
Unfortunately. Yes,
just
I
going
can.
back to this interview, and I think we got the right pages figured out now. But do you recall at some point in this interview saying, hang on, time out? Do you recall that?
Yes.
And why did you say time out in this interview?
There's that Morse code phone ringer again, the buzzer.
Just to take a break.
Did you, after you said time out, and I'm looking at page 43 there, line 19 and down, you said time out, knowing the logistics, he might be confused. And because he was running away from Border Patrol, his logistics, where he was, because he doesn't know where he's at. You recall making that statement?
Yes.
So you're providing an explanation for something that this witness is telling you, right?
Interpretation.
So why do you provide that interpretation?
Because I believe he was confused.
Why did you believe he was confused?
Because his statement,
His statement didn't make sense. Is that what you're saying?
parts of it.
And so you were trying to provide an explanation for why it's not making sense.
I was just trying to get his information, not interpretation.
Or give his information.
Well, and you say that his logistics weren't making sense, right?
Yes.
And they weren't making sense, what he was saying, right?
As to
What wasn't making sense about what he was saying?
just the distance.
Meaning what?
I don't believe they were accurate.
Okay. So they weren't accurate based on your knowledge of the area, is that right?
Based on my experience.
Okay.
We've gone to volcano intensity.
Did you say
on the
at some
spice
point
meter.
that maybe his locations were not defined as you might think? I'm looking at the page that's in front of you, line 5. If you just go ahead and read that to refresh your recollection.
Okay.
And so you're telling him, or are you telling him that, or you're saying that his locations might not be as defined as you might think?
That's not what it says.
I'm looking at line 5 to 7.
Okay, 7 does say that.
Okay,
That's not what it
so,
says.
and this is a sidebar you're having with the prosecutor in this interview, right? You're not telling this to Daniel.
I believe so.
Okay, and then do you later you explain something to Daniel about what you're telling the prosecutor in this interview? And I'm looking at line 11 through 12. Do you recall that? I'm going to scroll up for you, okay?
Yes.
And you're telling him that he wasn't paying attention when he was fleeing.
I'm asking.
You're asking him if he was paying attention when he was fleeing?
Yes.
Is that what he said? Did he acknowledge that? Did he say, that's right, I wasn't paying attention? Do you recall?
I don't see it on this page.
Okay. I'm just asking if you recall. Do you remember him saying that?
Can you repeat the question, please?
Do you remember him agreeing with you and saying, yes, that's right, I wasn't paying attention because I was fleeing, or something like that?
More or less.
Do you recall at some point telling the prosecutor in this interview that Daniel's thought pattern is not like ours? Do you want me to pull up that page?
Please.
It even highlighted it for some reason. Okay, so just take a look at that and refresh your recollection.
Got to turn the volcano off. I need it for Chad Daybell.
Yes.
Okay, why did you tell the prosecutor that his thought pattern is not like ours? What did you mean by that?
As to our interview and his statement.
Meaning what? Tell me what that means.
He couldn't explain what occurred.
Why do you think he couldn't explain what occurred?
He wasn't in detail with his statement as to what occurred.
When you say in detail, what do you mean?
He was very brief. He was very nervous. It took a while to get him to be comfortable with the interview.
Well, so he did provide some details to you. For example, that 15-meter distance. That was a detail he provided to you, right?
Yes.
So it was detailed. It was just not correct. Is that right?
No.
He says this happened 15 meters away from the border wall, right? That's a detail he provided, right?
Yes.
And that detail, it's just not correct.
It's not correct.
It's not that it's not detailed. It's not correct. Did that ever concern you? So you have this whole interview. You provide him with some explanations. You're saying his thought pattern's not like ours. You take him outside to try to get him to narrow in his distance or to try to judge how good he is with distance. Did it ever concern you that what he said just didn't make sense?
No.
Why didn't that concern you?
Because he was a victim of a crime, and it was probably hard for him to interpret.
How do you know he was a victim of a crime?
Because I was briefed on this case, and he was identified as the victim.
By who? How do you know he was a victim of a crime?
Because he was mentioned as the victim of this crime.
Who mentioned him as the victim?
If I remember correctly, I read the reports.
Somebody can make a false report to law enforcement and claim to be a victim of a crime. That's possible, right?
Yes.
And before you had this interview with Daniel, you were aware of two other potential witnesses who had come forward. We've talked about that already, right? Miguel and Ramon, right?
That's correct.
Daniel doesn't ever mention Miguel and Ramon to you, right? Or he says, let me rephrase that. Based on what you hear from him, your understanding is Daniel's the only one present when this shooting takes place, right?
No.
Who else, besides Gabriel? Daniel and Gabriel.
Objection, Your Honor. I'm having a hard time figuring out how this isn't improper impeachment again, and what the purpose of this line of questioning is.
And, Your Honor, the purpose of the line of questioning is to explore how the detective treats a witness statement. He provides explanations, and he provides reasons, and he tells the witness the reasons why the witness is being incorrect, instead of pursuing this witness as a potential suspect or as a potential person who's making a false report. So it's about, thank you.
And Your Honor, the state's position is that this is just an end run around letting Daniel explain the statement. They didn't confront him with the statement, and this is just an end run around that.
Objection's overruled.
Thank you.
Andrea F., welcome to the gallery.
When you interviewed
email
Daniel, was it your understanding from him that he and Gabriel are the only two people present when this shooting takes place?
Not that I recall.
You don't remember if he said there were other people there or other witnesses? You don't remember?
He did mention there was other witnesses, but the way you presented the question is that there was never anybody other than them present.
Other than who?
Daniel and the victim.
You're saying that Daniel somehow told you that there were other witnesses present during the shooting besides him and Gabriel?
Based on his statement that when he crossed with a group of people.
I'm talking about when the shooting happens, not when he crosses.
I don't recall if he mentioned anything with other people there at the shooting.
You don't recall, okay. If he were to tell you he's the only witness to this event, but you know that there are 2 other statements out there, does that concern you?
Yes,
Why does that concern you?
because there's other witnesses.
And those statements are not consistent.
I don't know the other statement from the other witness.
If the statements are inconsistent, that's a concern,
If
right?
the statements are,
And why is that a concern?
it's something for the court to address.
What about you as a detective? Is it a concern as a detective when multiple people have different statements about an event?
Yes,
Why is it a concern to you as a detective?
because you want to elicit the truth.
And if multiple statements are inconsistent with one another, does that mean one or more of those statements might not be true?
Can you repeat the question?
If multiple statements are inconsistent with one another, does that mean that one or more of those statements might not be true?
That's possible.
What do you do to test a person's credibility? Let's say you're concerned. Let's say someone comes forward with statements, and those statements do not make sense according to the facts that you know about the case. What do you do to test that person's credibility?
There's various things that that you could do. By
What are some of those things?
what is his background? How long did he go to school? If he can properly describe something to me during a interview. There's a lot of factors that come into it.
Okay. So if he can properly describe something to you, what do you mean when you say that?
Exactly what you're asking me to do with you is that if you you ask a question, then I give you an answer to that question.
So let's say, for example, I'm in the interview. I know this happened east of Nogales. I ask this person, where did this happen? He says west. Could you possibly bring out a map and say, can you show me where this happened?
Yes.
That'd be one way to maybe test the person's credibility, right?
That's correct.
Did you do that with this witness?
No, ma'am.
Why not?
I didn't have a map.
Could you go on Google Earth and get one?
Not at the border.
Not at the border. They don't have Google
Did you
down
do
there.
any follow-up with this problem, this west versus east problem? Did you follow
No,
up with this witness?
I did not.
Why not?
I wasn't tasked to do the follow-up on this interview.
If a witness says, for example, somebody else was there was another person who was a member of the group, and if you know who an alleged other member of the group is, could you do a photo lineup to see if the witness could identify that person?
Yes.
That'd be another way to test this person's credibility, right?
Yes.
Did you do that?
No.
Did you try to have the witness do a photo identification of Mr. Kelly at any point?
No.
Why not?
I wasn't tasked to do that.
Not my job.
Do you know if anyone was ever tasked with doing that?
No, ma'am.
These multiple, I guess, these areas of concern. So you're talking to this witness, and what he's saying doesn't make sense. He's talking about distances to the border wall that don't make sense. He's talking about locations that are on the other side of town that don't make sense. When you provided him and the prosecutor in this interview with explanations, why did you do that instead of testing his credibility?
It was based on just the interaction I had with the victim at that point. I didn't think it was needed at that point.
And that's because you just assumed he was a victim?
Based on his statement.
I don't have anything else, Your Honor.
Okay. Thank you. Cross-examination from the state.
How are you
Your
going to rehabilitate your witness?
Detective, If the victim,
detective.
Daniel, had identified the defendant in court the following day after this interview, would it have been necessary to do a follow-up with a photo lineup?
No, it wouldn't be necessary.
Do you know if that occurred? If you know.
No, I don't know.
But if that occurred, you'd agree that wouldn't be necessary?
Objection asked and answered.
Sustained.
Defense counsel asked you about some photo lineups. Do you know if photo lineups were done to determine if some other individuals were with him that day? If you know.
I do not know.
You weren't tasked with doing one, but there were lots of other detectives on this case. Is that right?
That's correct.
We had one for the Mexico trip.
So if they did a photo lineup, you don't know about it?
No, ma'am.
You talked about the port and not having a map available. Do you recall why that was?
At the DeCasino port of entry, second floor.
I didn't hear what he said.
He said at the DeCasino port of entry, second floor. Right. So we were at the DeCasino port of entry, second floor. Were there issues? Were there reasons why we weren't able to connect?
Yes, it's kind of at the border. It's a no man's land. Cell phone service is not available.
It's kind of sketchy there? Cell phone service is kind of sketchy?
It's almost nil.
Okay. Now I want to go back to your interview with Daniel. Do you recall Daniel describing other things about the location where this incident occurred and where he was that day?
Yes.
Did Daniel describe for you crossing the border at the end of the border wall?
Yes.
Did he describe for you going to an area he called Washington?
Yes.
Are you familiar with an area called Washington Camp?
Yes.
Where is that in relation to the end of the border wall?
Approximately a mile and a half away.
And which direction?
Be due north.
So just north of the end of the border wall is the area called Washington Camp.
That's correct.
Did he also talk to you about an area called Keno Springs during your interview?
Yes.
And where is Keno Springs in relation to the end of the border wall?
Approximately 2 miles northwest of the border.
The end of the border wall.
The end of the border.
So, and where is Keno Springs and Washington Camp and the end of the border wall that are close to those in relation to Nogales?
It's east of Nogales.
So when Daniel told you he was at Washington Camp and Keno Springs and the end of the border wall, but that occurred west of Nogales, which thing did you think was correct?
That he was east.
Okay. So when Daniel described Keno Springs, do you recall him describing the area at all?
Yes.
What do you remember him describing?
Descriptions of the row of houses.
Did he describe some pine trees in the area?
In the hills.
If you recall.
Yes.
In the hills.
And would it refresh your recollection if I showed you the transcript?
Yes.
Showing the witness what's been marked as State's Exhibit 18 on page 133. If you could take a look at the bottom of page 133 and the top of page 134. Let me know when you want me to advance it.
Judge Carroll is the judge in the J. Hatch Kowalski trial, and Yes, Daybell just started, by the way. It's over on the other channel. And it's up and running. Let me know if the audio is good.
Go ahead.
In that case, they've just set a scheduling hearing. It's not going to make any decisions, but they are going to set some dates. Probably not a hearing we're going to follow because they're not going to talk about the substance during the 22nd hearing. But the dates they set will be very interesting.
Yes.
Does that refresh memory?
Yes.
And can you tell me what Daniel said about the houses with the pine trees?
That it was close where Gabriel died, or it was farther from Gabriel. That was line 9. And then you're on 135 now.
Yes. So what was the eventual answer about where the house with the pine trees were? After you were able to explain to him what your question was.
The house was farther away, as in reference to the pine trees.
Okay. So the house with the pine trees was farther away from where Gabriel died. Is that what the transcript says?
That's correct.
Tell me about what Daniel told you his educational experience was.
That he attended school up to 6th grade.
And what did he tell you he did for a living?
That he worked on farms.
As a farmhand?
As a farmhand.
Did you talk to Daniel about the sequence of events and have concerns as you talked to him about his ability to do distances?
Yes.
Did he describe for you running from the Border Patrol in Washington Camp to the Keno Springs area?
Yes.
And did he describe that he ran for about 30 minutes?
Yes.
And I want to go specifically to a page 31. Did you ask him about when he initially crossed the border wall?
Yes.
And when he talked to you about crossing the border wall, did you ask him where he went?
Yes.
And are you familiar with that area?
Yes.
And did he describe crossing the border wall and going up a hill?
That's correct.
And then did he describe that as 10 to 15 meters?
That's correct.
Was that accurate?
No.
And he said he was about halfway up the hillside, is that right?
That's correct.
And did he describe for you that there was a horse between him and the shooter during your interview?
Yes.
And then when you spoke to him, he said that the shooter was 7 meters away. Is that right? Not on this page, but on the previous one counsel showed you.
Yes.
Would that make sense if the horse is between him and the shooter?
Objection,
That it's only
argumentative.
7 meters?
Objection sustained.
Would it be possible for the horse to be between him and the shooter if it was only 7 meters?
It's possible.
It is possible?
It is possible.
Okay. Is
Wrong
that likely?
answer.
Yes.
Yes,
It's likely?
Oh my goodness.
He's that close and there's a horse in between?
Objection asked and answered.
Sustained. That's his answer.
That's what happens when your witness doesn't know the right answers.
And what did Daniel tell you about how he was feeling at the time he got shot at?
He was in fear of his life.
And before he got shot, did he tell you what his health was like at that point because of fleeing from the Border Patrol?
He was tired.
And did he indicate to you that he was sick?
Object, Judge. There needs to be a non-hearsay purpose for this.
Judge, the defense is challenging the witnesses' distances and whether this witness did something improper with suggesting that the witnesses' distances were off, when in reality there are a lot of reasons why this witness's distances were not appropriate. And that's what I'm eliciting. The witness was sick.
It's hearsay.
Let's do a brief bench conference here.
When I get a headache, I can't measure anything. Here we go. We're going to listen in. Is this thing on? It's on, Judge. Go ahead.
Go ahead. Go ahead. Sorry.
Cannot believe the witness completely missed the clues and the questions about the horse and answered the opposite way. Said, yeah, it makes sense. 7 meters between me and the gunman, horse in the middle. Saved my life. Saved my life. Does that make sense? Yes. Makes sense to have the horse in the middle in that short of distance? Yes. Yeah, but is it likely? Yes. Oh, man. So bad. So bad. Even the jury knows that was the wrong answer. Jury cannot hear them. Jury cannot hear this. State's still doing all the hand motions. Nearly speaking in sign language. Very animated this morning. There was zero prep. He's retired.
I understand why your argument about why it's relevant as responsive to the defense direct examination, but it is still hearsay. It's still offered to prove the truth of the matter asserted. Now, hold on a second.
Hold on.
Well, yeah, it's offered to prove.
They did it, Judge. Her little arm. That's the funniest little picture. When her arm reaches over and it gets really tiny.
You're allowed to respond to what they're doing in direct examination, but through admissible evidence. But is there some reason why parties do not want to play this entire? I mean, we're going through it in minute detail. I don't know how long it is. I've never heard it.
Judge says roll tape.
I'm vaguely familiar with it because it came up in some pretrial motions. But I mean, is there, since we're going into it in detail and you want to offer hearsay to prove the truth from that asserted, you're asking details about it from the defense, and you want to play the whole thing? And it's your witness.
Are they going to play it? Defense could play it if they want, but I think there's stuff in there that they don't want out.
Well, and to the extent that the defense, through this witness, who's their witness, offered statements about what Daniel said, I mean, it was my, as to those statements, it's, correct me if I'm wrong, but I interpret that as offering those statements with the assertion that Daniel's statements were not correct. So it wasn't offered to prove the truth. Yeah, I mean, so.
State with a little arm arguing again. Her little arm gets tiny. Big, and then tiny. So I guess you can't say the state has never extended the hand of cooperation to the defense. It's a small hand, but it's been extended. Camera angles are fun.
Objection sustained.
Objection sustained.
Excuse me. The objection is sustained. One more thing. Let's go on the headset. One more thing. I'm sorry, I forgot.
Judge is like, wait, I'm not done. There's the Steve Jobs moment.
Real briefly, I was about to do this just as Ms. Larkin passed the witness, but the court will exercise its discretion under Rule 611B2 when the defense does redirect examination, provides the court discretion to provide an exception to the general rule that on direct examination, the examination cannot include leading questions. Under 611B2, C2, the court can make an exception and allow leading questions when a party calls a hostile witness, an adverse party, or a witness identified with an adverse party. And this is clearly a witness who's identified with an adverse party. He's a former long-term employee with the prosecutor's office. This is also my observation through the record is this extremely difficult witness.
It's a hostile witness.
What the issue is.
You can lead.
I don't know whether he's intentionally not answering the questions directly, or doesn't recall what the issue is, but he's not answering the questions directly. It looks like he's being uncooperative, but I don't know if that's
He looks
intentional
uncooperative.
or not, what the reason is. But anyway, for those reasons, on redirect examination, the defense will be allowed to ask leading questions. You can continue with the cross-examination this one.
Boom. The judge just said, by the way, under this rule, I'm going to allow defense to lead up.
Detective, were there numerous times during this interview that it was very clear that Daniel's ability to judge distances was inaccurate?
That's correct.
Do you know anything about the other witnesses' statements that the defense asked you about, Ramon or Miguel?
No.
Were you tasked with assisting and tracking down Miguel and the number that was provided to 911?
Yes.
And what did you discover when you tried to call that number?
If I remember correctly, a person answered and didn't answer after I identified myself.
They hung up?
Yes.
And what about Ramon? Did you assist the Sheriff's Department in attempting to track down an individual named Ramon?
That's correct.
What did you do?
I believe Ramon was living in Nogales, Sonora. We called the number listed, and his mother answered.
When you interviewed Daniel, what was his demeanor like that day?
very nervous, very almost sick to the point of during the interview that he was not well.
What did you attribute that to?
He said that he was still suffering some mental issues because of the shooting.
Did he talk to you about nightmares?
Yes.
And did he talk to you about other physical ailments he was having as a result?
Yes, yes.
And what were the
Judge
physical
says yes or
ailments
no.
he talked about?
Objection, hearsay.
Sustained. Judge smelled that one coming.
That's all I had, Your Honor.
And here come the leading questions on redirect.
Redirect examination.
Thank you. Real quick, the state was asking you some questions about photo lineups and if you knew whether Daniel was ever presented with a photo lineup that included Ramon. And you said you didn't know about that, right?
That's correct.
If Daniel were provided with a photo lineup that included Ramon, and if Daniel was not able to identify Ramon, would that be an additional concern to you?
Again, Your Honor, this calls for speculation and foundation.
Overruled.
So you can answer.
Yes.
That would be an additional concern.
Yes.
The state was asking you about some pine trees or some of Daniel's statements regarding pine trees. And can you put this up in front of the witness, Validia? I'm just going to show you this portion of this same transcript involving pine trees. You go ahead, read that, and let me know if I need to scroll.
Which line?
Go ahead and start at line 4 and go until line 17.
And out of fairness, for what purposes this statement of Daniel being offered?
Your Honor, it's again not offered for the truth of the matter asserted. It's clearly not true. The statement is saying...
Okay, that's fine. You've said enough. Thank you.
Okay.
All right.
Did you get a chance to read that?
Yes.
So Daniel, when he talks about pine trees, do you recall he's telling you he is near some pine trees that are right up against the little road that goes right along the edge of the wall.
Your Honor, just for the record, this is a different reference, so if we could have the page reference for the record. This is a different time in the transcript and a different reference.
Page 118. Do you see that where he's saying there are pine trees that are right up against the little road that goes right along the edge of the wall? Do you see that?
No, I don't see it.
Line 6. It says, like some pine trees that were right up against the little road that goes right along the edge, and then there's that goes, line 12, that goes along all of the edge of the wall. And I went running along that edge, and then I was looking. I looked, I saw that person.
He on line 10, he says that he's going through where the wall is. And then he was running out to the edge, and that's when he saw that person. I don't see where he.
All right, let's publish this page to the jury. I think
Sure.
that this is. I'm exercising discretion in this regard because I think it's relevant to the examination.
May I publish?
Just this page?
Okay, fair enough.
Bring it in.
So Daniel is telling you that he sees some pine trees that are against the edge of the road that goes next to the wall. Is that fair to say?
On which line does that say?
Just one second. For the jurors, this again is another demonstrative exhibit. This is just to try to aid with your understanding of this examination of this witness on this point in the testimony. This is not evidence itself, but it's just demonstrative, so you can understand what the questions are directed to.
Your Honor, can we go on the headset, please?
Oh, yes. Let's do that. We object. Now, we won't get to hear this, so just one second. We don't get to hear her. The state objects to this being shown, I'm sure. She's counting off her reasons of what is not okay. I don't know. If I were this judge, I know he stepped out of line before, but I think he's come around, and he's looking at this case. And
Mrs. Kelly, when these questions were asked to Mrs. Kelly, she read the transcript, she understood the transcript, she understood the questions, and she answered the questions. I don't know what this witness's problem is. When this was throughout his examination, these things have been put up on the screen. I read them like 4 times. I'm a fast reader, but I read them like 4 times. I understood the questions. I understood.
He's mad about the
read
time.
what was on the page. I don't know what his problem is. He just appears to be obtuse, and that may be charitable in this particular situation. This is a waste of time if you can't effectively read what's on the written page and understand clearly understandable questions. And so, I think it's important that the jury understand what this witness is doing and is responsive to these questions. So that's the difference between him and Mrs. Kelly.
He's obtuse. The judge is livid with the witness. Hold him in contempt. The witness cannot hear the judge. The jury cannot hear the judge.
You're going to have a rebuttal case. You can offer it. I'll deal with it then. If you want to offer the full transcript and full recording, you can offer it then. I'll deal with objections at the time. But the problem is, as I said, I don't know. This witness is being uncooperative. If there's something the matter with them, or he's just being obtuse. I don't know. But
He's obtuse again.
He's saying he can't read what's plainly on the written page, and he can't understand basic questions. And I think it's important that the jury understand that. So that's the difference.
Wow. Judge says the jury can't see what's happening here, and I can, and the jury needs to know. Holy sheep dip. I've never heard of that one, Elizabeth. Misty Moon, welcome to the gallery. What a day to join us. It's incredibly spicy today.
Understood. Thank you.
You can go ahead.
Thank you. So you see line 6, where Daniel says, I mentioned before, like some pine trees that were right up against the little road that goes right along the edge. And then I'm going to line 12, that goes along all of the edge of the wall. And I went running all along that edge. And then I was looking, and I saw that person. So he's describing seeing pine trees on the edge of the border wall, correct?
No, it's 2 different issues there. He's describing the pine trees
head on a swivel.
where he was, and the mural is, if I look at it correctly, on line 10, he's saying that he's going through the edge of the mural.
He's running
and
along.
He's describing, if you don't mind, he's describing when he's at the wall, when he was at first talking where the pine trees were.
So when he
jumps-
says,
he jumps his statement as to where he was.
So I understand that's your explanation. But what he states is there are some pine trees that are right up against the little road that goes right along the edge of the wall. That's his statement. Right?
He didn't consider that. He's lying to you. He didn't consider that. He's lying to you.
That's what he says,
Let's
right?
have the certified court interpreter interpret those lines from English and from Spanish into English.
Judge, we're going to hear it again from the court interpreter now. We're getting all directions. The jury can see it on
That
the
would
screen.
be line 1 through 3 and line 10 through 11.
Right.
Okay.
We got to make sure you record it, and where's it? Give him the microphone, please.
Let's let everybody hear.
Interpreter needs clarification. You would like me to interpret line 1, 2, 3,
10 and 11.
and 11. Okay.
Correct, but we need to make sure you're projecting and you're recorded. So we need to.
Booming voice, best
Thank
voice.
Bueno. It was at the same time in the same area where I went up then when is it that I come out of the wash? I went up, there were some trees. What can I tell you the last time? When it was like pines that were next to the little highway that goes along the edge. That goes along the edge where the wall is, and I went running by the edge, and then I was looking, and then when I looked, I was looking at the person.
Thank you. All right, you can resume the questioning.
Do you guys notice the translation
So he's
differences?
describing running away from this shooting, looking back when he's at the end of the wall and seeing the person, right?
Yes.
And you know, based on your familiarity with the area and based on where that property is, that that's not possible, right?
That's correct.
It's not possible to be at the end of the wall and look back and see Mr. Kelly's property, right?
I wasn't there, ma'am. That's what he said.
Okay. Did you have concerns about that when you got this statement?
Not at that time,
Why not?
because we were conducting the interview.
Well, if a witness says something that's obviously impossible based on what you know about the evidence, that causes concern, right?
Yes.
And he's not just, making errors in distance. He's placing himself in a physical spot that he knows, the end of the wall, right? The road that goes along the end of the wall.
Yes.
That's not a mistake that you make because you have a 6th grade education, right? If I say I'm at the end of the wall, but really I'm up on a mountain somewhere, that's a big problem, right?
Yes.
So when you see this statement, you're not concerned that this person might be making a false report?
And that's why the interview continues.
Well, maybe this person wasn't there. Is that possible?
I believe he was there.
Even though he's making these impossible statements?
That's why we were having the interview.
Did it ever occur to you that maybe he wasn't there?
Yes.
Why did that occur to you?
For the same reasons that you're giving me.
And what did you do to explore that possibility?
We continue with the interview.
And during this interview, you came to the conclusion that he really was there.
That's correct.
Even though he says, I'm at the end of the wall when I look back and I see the shooter. And even though he says, I'm 15 meters away from the border wall when this shooting happens, you still think he was really there?
He couldn't articulate that point of view.
Well, he articulated 15 meters pretty well, right?
Yes, he did.
And he articulated the end of the wall pretty well, right?
Yes, he did.
He even mentioned the pine trees, so he's adding detail, right?
Exactly.
And yet you still think that he was there.
Correct.
Even when he says the shooter was 7 meters away from me, you still think he was there.
I believe so.
You said that he provided there were numerous times in this interview that you were concerned about his ability to determine distance, right? That's what you told the prosecutor, right?
That's correct.
But that's not because when you actually measured distance, he was very far off.
That's correct.
That's just because he's telling you things that you know are wrong based on the scene, correct?
Correct.
This is brutal.
I don't have anything else, Your Honor.
This is brutal.
Another limiting instruction I should have given it when you saw this page of the transcript. The statements of Daniel that are being offered by the defense are not being offered for the truth of the matter asserted. They're being offered for the opposite purpose. So therefore, as I've defined hearsay for you before, it's not hearsay because it's not offered for the truth of what Daniel said. It's offered to show that it's the opposite, not true. All right.
And Your Honor, based on counsel's argument, I want to again make the argument with respect to this transcript. And if the court wants to do that on the headset, I'm happy to do that. But based on the continuing questioning,
all right,
I need to make a record.
First, any questions for this witness from the jurors?
Are we done?
All right, seeing none, you can still think about it. We'll go on the transcript. Excuse me, we'll go on the headset briefly.
Okay. We're not going to get to hear her objection, but we'll hear the charge.
Okay, Ms. Hummel.
Can I turn it down while she makes her arguments just static?
Oh, I didn't see it. Yeah. Good for you, Denise. Keep it up.
All right, good for you, Denise. Keep it up. In the courtroom, the static you're hearing in the background.
Same argument we met before, but you made your record. Thank you.
You've made the record. Thank you. Done. Same argument as before, says the judge.
All right, we're back on. All right. You all right, Denise? All right.
Denise is the.
Oh, there's something else? I'm sorry.
Judge dropped his headset.
Hold on one second.
Brittany, yeah, the judge has.
So I'm going to, I'll excuse the witness. Can you talk to your client while I'm here? I can excuse the jury, and that way I don't have to come in and out. I don't know, Miss Lothar looks like she's trying to direct the airplane in or something. I don't know what your hand says.
Denise is the recorder.
All right, very well. All right, so you don't need Detective Barba, and for the purposes of whatever the offer of proof was that you made where I wasn't present, you don't need him to do that. Is that right? All right, very well. Okay, so what I'm going to do is excuse the witness, excuse the jury, and we'll clear the courtroom, talk to your client. Let me know when you're ready, and I'll come in and have the colloquy, and we'll bring the jury back in.
Okay, so that means defense is deciding right now if Mr. Kelly is going to take the stand in his own defense. I would say no. I would say don't testify.
All right, understood. Thank you.
All right, we're back on the record before the jury. No questions for this witness, ladies and gentlemen of the jury? All right, I see none. Then sir, you can step down, but hold on a second because we're going to take a recess. The lawyers and I have some work to do before we take the next step.
So it should be about maybe 15 or 20 minutes, don't know exactly, but we'll bring you back in. If it's close to lunch, we'll just recess for lunch. Hopefully we'll be able to come back and do something else before lunch, but there's a little bit of work we have to do. You know, there's just some things that the court, the judge, and I have to do with the lawyers, and they have to occur at certain points in the trial. Sometimes they're inconvenient points for purposes of taking a break, but they have to be done. It can't be done ahead of time. It can't be done later. It has to be done right now. So that's why we're doing this right now. So we will stand in recess for about 20 minutes to a half hour, I'm guessing, roughly. And as soon as we're ready to go, we'll have you come back in. We'll stand in recess, thank you. And then the witness afterwards will step down.
Rise before.
I don't know who's playing with the microphone. Might have a little break. Debbie, this trial has ramped up. The spiciness has been incredible. The judge's position has flipped. Look at defense with their arms folded. Or sorry, the state with their arms folded. That's a defensive posture. They just got beat. They got beat in court by the defense. They got beat in court by the judge. And I think they got beat by their own witness. And now, we're just going to go nurse our wounds. We'll be in the hall for a little while. Is that cool? Okay, let's see when the break comes back. Oh, that's the end of this one. Okay, so nice. Let's come back for afternoon. We're flying. We're catching up as quick as we can here. Oh my goodness! No time for breaks, guys. No time for breaks.
Thank you. Please be seated. All right, we're back on the record. The record has showed that jury is absent, counsel is present, counsel are present, as well as the defendant. The court has reviewed state's proposed exhibits 143 and 144. 143 is a transcript of a recorded interview with Miguel, who has been identified.
The other one should be 141.
141. Did I?
Okay, you said 144. I just wanted to make sure we were
all
talking
right.
about the same thing.
Oh, thank you. Appreciate that. Law enforcement interview between Miguel and who were the other participants? Was that from the sheriff's office?
141 was Detective Barba and witness Ramon Felix Gonzalez.
All right. And 141 was, well, it says Aaron Felix Gonzalez.
It's Ramon Aaron Felix Gonzalez, Your Honor.
And that was also with the Sheriff's Department. Yes. All right. State seeks to use these transcripts, play the recordings of the law enforcement interviews with these two witnesses. Neither of these two witnesses have ever been subject to cross-examination in any manner by the defense. Is that correct?
That's correct.
All right. So state seeks to use these statements for the purposes of redirect or rebuttal evidence. Neither the court's going to sua sponte raise an issue. Neither of the parties has raised it to the objectionability of these two particular interviews.
I'm sorry, Don.
In Crawford versus Washington, 124 Supreme Court, 1334, United States Supreme Court, 2003. The United States Supreme Court looked at a situation, a fact pattern, nearly identical to this situation. The court ruled that it's a violation of defendant's Sixth Amendment right to cross-examination to admit hearsay statements, even if they're under a well-founded hearsay exception under the rules of evidence. It's a violation of a defendant's Sixth Amendment right to introduce hearsay statements that are testimonial in nature, that are offered for the truth of the matter asserted, because it's not subject to cross-examination. It's a Sixth Amendment question. It's constitutional. It's the same fact pattern as this. The witness in that case in Crawford from the United States Supreme Court case gave a statement to law enforcement officers that was incriminating of the defendant, and the prosecution sought to use that and did use that. The court ruled that that statement is testimonial. It's very clear from the case law, from the Crawford case and all case law that has discussed it since then, as a statement of this nature to law enforcement is testimonial in nature. It falls squarely within the Crawford decision. The use of this particular statements would violate the defendant's Sixth Amendment right to cross-examine and confrontation of these two witnesses. It hasn't been raised. I'm raising it sua sponte because if the court were to allow this, and if there were a conviction, I have no idea what the jury's going to do. I'm not even speculating on that. But in the event that there were a conviction and the court will allow this, I think it's fundamental error that would result in a reversal and a remand back to this court. So for those reasons, and if the state wants to mark these and have these included as part of the court file but not exhibit, I'm happy to do so.
Yes, Judge, we'd like to do that, and that would be with exhibits 141, 142, 143, and I believe we have the 911 calls marked too, Your Honor. But before I get to that, and I'll give you
Well, what's 142?
It's the actual recording that the state intended to play.
Okay, very well.
That we have synced to the transcript. We also have the 911 calls, which we would have requested to play as well. I'll get to that in a minute. But with response to the Confrontation Clause issue, Your Honor, that was directly addressed in the Prazer-Fong case. And what the court said in that case, first of all, the state's not offering the statement itself for the truth of the matter asserted. We're offering the statement for the purpose of rebutting the defense's argument that the law enforcement officer's investigation was inadequate. That's the reason they indicated they offered them, for two reasons. Because they believed they were false and because the state's investigation was inadequate. And so that's directly on point with the Escalante-Orozco case and directly on point with the Prazer-Fong case. And what the Prazer-Fong case says is that when the defense offered part of the statement, they waived the Confrontation Clause issue. And that case is the 2005 case in Arizona, Your Honor. And so for that reason, the state believes that the statements should be admissible. And I'll get the other
Exhibit numbers.
number.
All right, well, I have 141 and 143. I'll give these to the clerk. These are not admitted exhibits, just to be clear, and they're to be made part of the court file.
And I have
for whatever
142.
purpose.
I have 142 here also, Your Honor.
Very well. But
Are we making that part of the record as well, just for the record?
that's the recording itself?
Yes.
142 can be made part of the record, but not
Thank
admitted.
you. And I'll find the recording for the 911 and let the court know what that is so we can make that part of the record as
Which 911 call is that?
They're all the dispatch calls with the individual known as, who identified himself as Miguel.
Oh, right. All right. But I mean, obviously, clearly that if either of these witnesses were here and subject to being called and subject to being cross-examined live in court, it would be a different thing because they'd be subject to cross-examination. Obviously, they're not here. I'm sure they're not here. One of them, or both of them are
Right, but the
parts
problem,
unknown. So,
right, but the problem is the defense offered the pieces of their statements that they wanted to offer. The state was never able to rebut that and then claimed the investigation was inadequate, and the state didn't get an adequate opportunity to rebut that. That's the state's argument. That's why we're arguing we're prejudiced in this case.
free to argue it, make your record, appreciate that. But I feel that this is a very clear, to admit these particular recordings and statements by these witnesses who are not here, not subject to cross-examination, and therefore we're not able to fulfill and accord satisfaction to the defendant's Sixth Amendment right to cross-examine and question these witnesses. And I've read these statements, and they contain a lot of information that is highly prejudicial. And for whatever purpose, if they're not offered for the truth of the matter asserted, I think it's even a larger violation of the defendant's Sixth Amendment right to permit that to be done. But you made your record. Court's ruled. I'm not going to permit those two recordings to be played, given the Crawford case and the Sixth Amendment analysis that the court's applied to the case.
Your Honor, and the other exhibit number is Exhibit 144, if that could be made part of the record as well.
So granted, so ordered. Okay.
Judges granting wishes today.
So, Mr. Jetty, you spoke before, so where does that leave us?
The state rests, Your Honor. No rebuttal witnesses, Your Honor.
No rebuttal.
Very well. So what we're going to do is I'm going to bring in the jurors. The state can rest, and then I'm going to tell the jurors we're going to need, I would estimate, about an hour to finalize final jury instructions get them copied and printed out. We'll come back. I'll give final jury instructions. That'll probably take, I don't know, well, what do you think, Denise? About 45 minutes? 45 minutes at the most. And then we will probably recess for the afternoon and come back tomorrow for closing arguments. Counsel, the court's going to limit time and closing argument to 90 minutes per each side. That should be plenty of time. And the state will have 90 minutes as well. The state can watch the clock and reserve whatever time from the 90 minutes for you think might be necessary for rebuttal. Fair enough?
Your Honor, I think since we have the burden, I'd ask that we have additional time for rebuttal. That would be our request.
All right, I'll take that into consideration.
Thank you.
I'll think about it.
All right, let's, anyway, that's the plan. Let's bring in the jurors, please.
Okay, wow, we just moved to the end of the trial. It's over.
And
Mary.
Your Honor, I think the further record on that is that this has been a 4-week trial. I don't think that 90 minutes is adequate to cover.
Well, I think this jury has had the facts presented to them.
Over and over and over.
The jury has had the facts presented to them, and they understand what the facts are. I think it's more about arguing the facts and how they apply to the law. I mean, all of the salient facts have been produced and repetitively, so let's just leave it at that.
Over and over and over. Mary M says, I bet you have many thousands of views on the judge walking out because I see a lot of people
Not to mention the
sharing
fact that the parties had opening statements that were somewhere between an hour and a half and 2 hours each, which basically laid out the entire case in the beginning.
Detail is terrible. It was so long. Mary, yes, we've had a lot of views. If you know who shared it, I did encourage that to be spread around as much because I wanted to get a lot of lawyers' takes on it. Send me a text message with different accounts. I'd like to just hear everyone's different take on it. I know I saw Lawyer and I saw Kurt, but if you've seen some other ones, I'd love to listen to what they think about it as well. So just shoot me a message on the burner phone with that, if that would be great.
Please be seated. The record will show the presence of all the jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. Let me tell you where we are, what's going on, and what's going to happen next. Well, first, I'm sorry. Does the state wish to present any evidence in rebuttal?
No, Your Honor, the state rests.
Okay. State's rested. What does that mean? All the evidence is now in. The state's presented its case in chief. The defense has presented its case. The state is not going to present any rebuttal case in chief. All the evidence is in. So what I need to do now is meet with the lawyers. We didn't do it over the lunch hour. We took a break. I need to meet with the lawyers. We need to finalize the final jury instructions. We've already been working on it. They have drafts, and they've reviewed them. We've been working on them. Once again, so I'm going to have to send you out, but I'm explaining why. Because this is, again, something I can't do with the lawyers until everyone's rested and all the facts are in. Couldn't do it before. We kind of started the process, with drafts of the jury instructions, but now we've got to review it to make final instructions. We'll have Jose here in the courtroom. We'll make those changes. He's been warming up his fingers. So that gets done efficiently. And once that's done, we'll copy them off. You'll come back in, and I'll redo the final instructions just the way I did the preliminary instructions. Then given the hour, what we'll probably do is recess for the day. We'll come back tomorrow at 8:30, and when we begin at 8:30, we'll begin closing arguments by the parties. And following the closing arguments, I'll give you some very brief final jury instructions about what to do when you go back there. And at that time, we'll pick the 4 alternates, assuming we still have all 12 jurors, and then you'll begin your deliberations. So the case will be submitted to you, likely for deliberations tomorrow afternoon. So I need to meet with the lawyers. So what I need to do, I'm sorry, we got a little bit of a gap here in time where you're going to be waiting in the jury room. It should take about an hour. Again, couldn't get it done before this moment, so apologies there, but we'll be in here working. I'm going to excuse you. Any questions about any of that, folks? Yes, ma'am. What'll happen? Allergies, sorry. What happens to the alternates is, yes, they do not participate in the deliberations. And I'll explain, but since you asked, that's okay. The alternates will leave. They will not participate in the deliberations. The alternates, however, will not be reduced from the court's admonition to not talk about the case unless and until a verdict has come in. The reason for that is that in case there are going to be 8 persons who are going to end up deliberating. In case any of those 8 persons who are actually deliberating cannot complete the deliberation process, maybe somebody gets sick or they have a family emergency and there's a deliberation and they can't complete it. What will happen then is we'll draw a name from one of those 4 alternates, and that alternate will come in and substitute in and be part of the jury deliberation process. Once a verdict has been rendered, we'll call whoever the alternates are and tell them case is over. We'll tell them what the verdict is and that they're released from the admonition. So you're not really, if you're an alternate, you're not really released from the jury service until we call you and tell you that there's a verdict that's come in for that reason. And that does happen. Sometimes people, for whatever reason, can't complete the deliberation, and we got to substitute somebody in. So that's what will happen. All right? So I'm going to excuse you. Please wait in the jury room, hopefully about an hour, and then we'll come back and we'll do final jury instructions. Any other questions? Good. All right, you're excused until further notice, and I'll stay here with counsel and we'll work on the jury instructions.
Didn't want him anyway. All right. I know everyone's saying try to take this live, go live. I don't have that yet. I don't have the live. What we watched, what the court provides in this view with this audio, which is really good, lets us see everything that's happening. It's not uploaded live. It doesn't happen live. So let's. I know everyone. I'd love to have it live as well, but it's
most recent final. Yeah.
Should we start passing that out?
Yeah. Just get somebody else to do it.
Get somebody else to do it.
All right, have a seat. I'm sorry. All right, to the public and the media, we have a legal discussion here about the proposed jury instructions. We do it off the record, and then we go on the record to preserve final objections that the parties may have. You're welcome to stay. You're welcome to go as well. This is usually not one of the more interesting parts about the process, but if you're interested, thank you. You're welcome to stay. And as I said, I told the jury it should take about 45 minutes or an hour to get this done. So we will we go off the record for purposes of the court reporter for now, and you're welcome to keep the camera running. You're welcome to stay, but fair warning if you do. Okay. Okay. We got Jose. We have counsel. And we have the proposed instructions.
Your Honor, may I ask a question?
Yes, ma'am.
Can we all participate or
Yes.
only one speaker?
You can all participate.
Thank you,
It's
sir.
very informal.
Thank you.
Thank you for asking. Okay. The first several pages are all standard instructions.
Can I
know there was
have a
this-
concern about the first page?
Okay.
And I know that I'm coming from a different jurisdiction, but I do have a issue with the fact that the jury is required to determine what actually happened. If we were to give them that instruction, then because of the uncertainty of a lot of facts in this case, they will be deliberating a long time trying to figure out who did what and trying to solve the case, which I don't think anyone can, in my personal opinion. And I feel like it's not the right burden.
I agree with you. Actually, no one's ever brought that up before.
Thank you. She looked at me really weird. I'm just kidding.
No, it's usually, but no, their job isn't to determine what happened. Their job is to determine what the facts are. So
Thank
it said we can change that to you as jurors are the sole judges of the facts.
Yes, sir.
Okay. Are you with us, Jose?
I don't know where we are, Your Honor.
First page.
Page 1.
One's lost.
Duty of jury.
Is this not the Raji?
It is, but she makes a good point. So Raji are recommended, and I think she makes a good point.
I would object. I'd ask that we use the Raji that we've used for decades.
Understood. Raji are, I think they're recommended. I think that's what the R stands for. So, or maybe it's revised. I don't know. Anyway, are you with us there? So it's the end of the second paragraph. You as jurors are the sole judges of the facts.
And actually, the first sentence of that second paragraph also says you have to determine what actually happened.
Okay.
Same objection, Your Honor.
Noted.
Noted.
So look at the second paragraph, the first sentence. It is your duty to determine what the facts are in the case by determining the facts instead of, and take out what actually happened. And then the same thing at the last sentence of that paragraph.
I don't even think that first sentence makes sense, Your Honor.
I think if we just cut it off at, I think if that
Yeah,
first
what
sentence
the
of the
facts
second
are.
paragraph,
Okay.
it is your duty to determine what the facts are in the case, period.
Good, okay. So that sentence, that sentence is your duty to determine what the facts are in the case, period. Okay, you got that? Good, all right. Anything else, let's say through pages 5?
And I was wondering in that, just on that same page, it just might be a little bit better, but not mandatory, but the last paragraph, the second sentence, as you determine, I just wanted to know if the court would consider review the facts.
We're on.
Pardon?
I think it's fine the way it is.
Okay, that's fine. I'm okay.
It doesn't change the content the way
Yes,
your
sir.
other, the meaning the way your other suggestions.
Thank you for listening.
Of course. So, let's see, through page 6, 7, or any, stop me if you,
Yes,
I know we had an extra.
the defense
we
attorney
had
next to the
Two
aisle
different instructions here,
is a
depending
mixed
upon whether the
martial art
defendant
fighter.
is going to testify or not testify.
Judge, and I think burden of proof,
This one.
I'm not sure if counsel's asking for the second half of that.
Tell
On
me,
page
tell me
10
what page you're on.
I don't know.
Four.
Did we? Oh, we're on page 4. Yeah.
I'm so
I got
sorry.
too far ahead.
Prayers for you and your sister.
What's the question about page 4?
I think this is 2 instructions in one. Is counsel asking for both? I don't care. I just want to make sure the record's clear.
Yeah.
Yeah,
we-
I'm asking for the whole thing.
All right, there's 2 different instructions on burden of proof, but we'll give them both.
It's fine.
All right.
I don't know.
Actions.
The one who's mixed martial art. She's the one that wears the cowboy boots. She's the one that got the spicy
I don't recall
cross
if
on
we had any
lead on
stipulations,
the
so I
last
don't know
witness.
if we need
We didn't, Your Honor.
defense.
the stipulation.
Nearest the aisle on the defense table. Opposite the table from
That's
Mr.
page
Kelly.
10.
Yes.
So, Jose, we can just take all of page 10 out. That whole instruction, stipulation.
They're already in
Agreed?
page 10. They're flying
Yes.
through this.
I also don't know if we have redacted exhibits.
We do.
We do. The text messages.
Oh, okay.
All right, so we'll leave page 11 in.
Kathy Lothbrok is the other attorney,
And
the
I
attorney in
think
pink.
just defendant's testimony needs to come out.
She was military
So-
police in the Army, police officer prior to becoming a lawyer.
Defense, I assume you want us to leave, well,
We
I don't want to
may
make any
reach out to
assumptions.
her.
Page
thank you,
16,
by the way, for
defendant
that.
need
I've got
not
her
testify.
information now.
Do you want
Leave
that?
that
She
in,
might
yes.
be willing to
Leave
talk
that
to
in.
us after.
Okay, sometimes people don't. And then we'll take out, so Jose, we're on page 17. That'll come out. Defendants, you must evaluate the defendant's testimony the same as any witnesses, right? That comes out. He didn't testify, right?
Correct.
Okay.
And the next one.
18 stays in, correct?
Oh, yeah, that's right. It's his statements. Came through other
Yes.
people. Yes.
Correct? Witness's prior conviction, cooperating witness had a prior conviction, correct?
Yes.
So we'll assume the state wants that in there.
Yes, Your Honor, they did.
That's page 19, so that stays in. All right,
You had
now,
a prior?
is there anything before that? I'm looking at page 20,
One of
There's
the
We don't
victims.
have page numbers.
We don't
What's
have
the heading?
page numbers.
What's the heading?
evidence for a limited
Yeah.
purpose.
I think we wanted one out and the other one in, right?
Right. I think this would both deal with the text messages, so I would prefer the next instruction on other acts.
Your Honor, I think we need evidence for a limited purpose for multiple reasons. Detective Barba's testimony regarding all of the other witnesses, the court allowed that only for the limited purpose of determining whether their investigation was appropriate. In addition, there were 9 photographs that were photo lineup that were admitted only for the purpose of determining whether law enforcement did an appropriate investigation. In addition, Your Honor, there was the impeachment of Detective Raul Rodriguez that, again, was only offered for the limited purpose of determining whether the investigation was appropriate. They were not offered for the truth of the matter asserted. Those are very important instructions for the state.
Right. I think there was a number of times I gave limiting instructions on hearsay and otherwise. So
what do you fill in?
So here's what. Let me tell you the language I propose to use. Okay. So I think we do need the instruction. During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose that the court stated at that time.
Judge, and I don't think you gave that limiting instruction with Detective Rodriguez, and I would ask that we are specific with the jury. I think the jury needs an instruction in the back reminding them of the limiting instructions. I would ask for that with respect to all of those issues.
Well, I mean, I gave limiting instructions. We just reviewed some of them. You did as well, in a number of different contexts and different types of limiting instructions, hearsay and the other things. I don't want to confuse the jury or give them excessive information by going through each and every example or situation where the court gave a limiting instruction. You can argue that to the jury if a limiting instruction was or was not given with respect to certain evidence. But I'm not. What are you asking me to do, to give an instruction that I did not give a limiting instruction for Detective Rodriguez?
I'm asking you to clarify for the jury what the purposes of the limiting instructions were, specifically with Detective Barba and Detective Rodriguez. I think they need that in writing specifically, and I believe it's very important for the state's case that we make it clear that that testimony was only for the purpose of determining whether the investigation was appropriate. And I don't think the court gave the limiting instruction during Detective Rodriguez's testimony, and so I believe that's extremely important with respect to Detective Rodriguez's testimony.
Well, if I didn't give it, no one asked for it. I'm not going to do that. You can state your objection on the record. I think that's more information, more detail than is appropriate for a jury instruction in a case such as this, 4-week trial, different types of limiting instructions. You're welcome to argue to the jury that the court gave you a limiting instruction or didn't give you a limiting instruction as to particular testimony, and when you argue the case, place it in that context for the jury. But I guess I haven't heard from the defense. Do you have any objection to the language as proposed?
No, that was good, Judge.
Right. And again, you'll be able to, when we go on the record, both parties will be able to make formal instructions. All right, so Jose, I'll give this to you when we break, okay? And you still want the other act, oh yeah, we kind of run out of page numbers. You still want the next instruction, which is other acts, correct?
I think that only applies to the text messages, but give us 1 sec, Judge.
Sure.
Sorry, well, this is
going on. I guess I haven't heard from the defense. Do you have any objection to the language as proposed?
No, that was good, Judge.
All right. And again, you'll be able to, when we go on the record, both parties will be able to make formal instructions. All right, so Jose, I'll give this to you when we break, okay?
We're going to keep the audio on. I'm going to show you the thumbnail.
And you still want the other act.
Which has grown quite a bit.
Oh yeah, we kind of run out of page numbers. You still want the next instruction, which is other acts, correct?
I think that only applies to the text messages, but give us 1 sec, Judge.
Sure.
There's a ton of stuff on here. This is something we need to make available for viewing for everybody. We may also add this to our list of items you can get in the magnet form, which we like. Thank you so much to the. Oh, why are we doing the? Let me go back to.
Could you reread one more time what you're proposing on the other one? Of course. Limiting instruction.
Evidence for a limited purpose. During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose that the court stated at the time.
He called in a couple days ago, Welsh lady. And how are you doing? Good to hear from you. I got your email. I couldn't respond.
Judge, I don't think we need this one since you already provided that one. I was just thinking of the text messages, but I think during trial you provided a limiting instruction regarding those as well.
You're talking about the other acts instruction?
Yes. So I think we could take that out.
State's position?
On the other acts evidence?
On the other acts instruction.
No, I think it needs to come in as well. I think they both need to come in.
All right, I think the other act, I'll give the other acts instruction. If you want to make an objection to that, then you can when we go back on the record. All right, separate counts. Then we go, then there's a couple of final instructions, the jury foreperson in closing.
Judge, there's one before that the state's requesting, and that's standard instruction 44, which is the motive instruction. I didn't see that the court included that, and I would like the motive instruction added. I can email it to your JAA if you'd like.
What's the defense position?
What's the defense
We're okay
position?
with that, Judge.
All right, if it's fine, then there's no objection by either side. I'll give it. Yeah, if you'll email that to Jose. It's a very
once
short.
we read it, of course. We like to read it, too.
Sure, it's really short. You know.
I'll
Well,
include
email
the
it.
defense, of course, as I'm ethically required to.
Okay. So what I was then saying is we go into, these need to be just reorganized. There's some closing instructions, and we'll take those out, and those will go, I'll read those, thing about the jury foreperson and the closing instruction, I'll read that after your closing arguments. So then we're going to go to the statutory definition of the elements.
There's the link right now in chat.
So I'm
So
looking
view
at the
thumbnail
first one
if
that
you wanna
says
see it
second-degree murder.
on the web. A little easier to view in detail than when I show it.
It's this packet, right?
Jump over there and put it on the screen as well.
Judge, the only thing we had on that were some punctuation issues. And it looks like the new second-degree murder, I think it now has some brackets. I'm looking at page 33. Is that what the court's looking at?
I am seeing
I'm
a
just
live
looking
feed
at
that's
the
not
one that says
transmitting the signal right now.
second-degree murder,
about
the crime of
case.
second-degree murder
I don't know where
requires
they're
proof
at.
of any of the following. It just says the elements. There's no
Your Honor, I would have had knowingly under number 2 instead of new, but that may be just your state. I don't know. But everything is intentionally, knowingly, or they're all recklessly, and that one just says no. I just thought knowingly would fit better.
And Judge, I think this tracks the statute.
Yeah, I think so too.
Okay, and that's something I'm not aware of.
That's fine.
And
All
Your
right.
Honor, we got a new set from the JAA for the end of your jury instructions. So I think they've been redone already. And he included some bracketed
And now-
language as well.
We're gonna get to that.
Okay, but it's
the one
the
that
same
the one that I have, the
instruction.
second-degree murder, is just the Raji, just from the.
Right, but
It's
he's,
got 1 or 2 or 3.
it's the same instruction, it's just later in your packet. It's the exact same instruction, it just has additional bracketed language.
Oh yeah. Let me see. All right. What do I?
It's on page 33 of what Jose gave us.
Yeah, but
Oh, what 33 is?
I understand. It looks like I'm
Go back there.
looking at something different.
Because I just want to make sure we were all on the same page.
Jose, I don't think I don't have that in this thing you just gave me.
Why don't we check right here? Which one? 33 is over here. We haven't gotten there yet.
Hey, Vicky, no, that's Sarah Boone. The court's still not playing nicely with us.
Get a clean copy.
We do have the pine tree air freshener on the
You can look at this one.
on the thumbnail to symbolize the pine trees.
Oh, good. Okay.
Remember, a lot of items are represented symbolically on that thumbnail when you look at it. So it takes a little bit of a scratching your head to figure out what things are.
See what's going on here.
And I sent that instruction to Jose, so he should be getting it in a minute.
Motive instruction.
Yeah, the
Jose
motive
is a
one.
busy man today.
All right, I see what you're talking about. I don't know what the difference is. Oh, it just substitutes the initials of the deceased, right, for another person.
Yes, Judge, and there were some typos and some
What about-
formatting issues as well.
What about
with
the
first
one, what about the first one that has GCB?
I think we could put
We're waiting
Gabriel's
for
name
Mafid
in
from
there,
court.
Gabriel Cuen Buitimea. I don't think it needs to say of another person, so I think putting the victim's name in is
What is time for a
appropriate.
poll? It's time for a poll. Let's do that.
And then there's
Defendant
some-
caused the crime of second-degree murder requires proof of one of the following. The defendant intentionally caused the death of GCB, or the defendant caused the death of GCB by conduct which the defendant knew would cause death or serious physical injury, or under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of GCB. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. I mean, that's
Yes.
the instruction.
Yes, I don't have any objection to the instruction, Your Honor, just some formatting issues. I just wanted to bring to the court's attention that we had this twice
Okay,
in the
good.
packet you sent.
All right, so that one's okay.
Just that I would ask that we move the "or" up to the first line, and that we would put a semicolon in the second line, at the end of the second line, the number 2.
All right. I'll go over that with Jose. We'll go over that later.
And then there should be a period at the end of number 3.
Good. Okay.
That was all I had on that one.
All right, and what about the next page, aggravated assault?
Your Honor, I feel like we left out the name of the victim in this, and I propose that we put it at the end of number 2. The assault was aggravated by the following factor: the defendant used a deadly weapon or dangerous instrument against, and then the victim's name. Well, nowhere in there are we identifying the victim, so the jurors will be confused which one's the victim in this one.
Okay.
I don't have an objection. I would add it to number 1, Your Honor. The defendant committed an assault on Daniel Ramirez.
But it's and.
On Daniel Ramirez, and the assault was aggravated by the following factor: the defendant used a deadly weapon or dangerous instrument. And then also under the assault definition,
Hold on, let's get to, how about that defense? The defendant committed an assault on Daniel Ramirez, comma, and, does that work?
Okay, listen very carefully. I'm about to put a poll up.
And the
I
assault.
always got people that say, oh, I clicked the wrong one. Get your hands off the keyboard. Read the question.
I'm just kind
read
of
the
off the top
answers.
of my head, I'm just thinking.
Then vote. Okay? You only get one shot at this. Don't screw it up.
It seems there
Don't screw
needs
it
to
up.
be something to
we go.
explain to the jury that he would have to use the deadly weapon or dangerous instrument against that particular person in order for that to be.
How about the defendant used a deadly weapon or dangerous instrument during the assault?
I don't have an objection to that, Your Honor. I don't think it tracks the statute. I think it's unnecessary, but I think adding on Daniel Ramirez is fine. And I also
Adding Daniel Ramirez, I mean, I take your point that it's, so they're not confused about who the victim was on that particular charge. But,
Right.
Can we
All
put
right.
the name in both?
All right,
And Your Honor, I think we could add it again down in the assault. I would ask that we not add it to the deadly weapon portion, but intentionally put, instead of another person, we could say Daniel Ramirez.
So what I'll say is then, under it says assault, the crime of assault requires proof that the defendant intentionally put another person, and then I'm going to put in parentheses, Daniel Ramirez, in reasonable apprehension of imminent physical injury. Okay?
Yes.
Then we have definitions: knowingly, intentionally, intent, recklessly, reckless disregard. Those are all.
And just, I'm sorry to go back, but I don't think we ever cleared up whether we were going to use Gabriel's full name in the second-degree murder. The state is requesting that we use his full name, Gabriel Cuen Buitimea, instead of the initials.
I'd leave that to the court.
Leave that to the court.
Okay, full name.
Judge is like, it's,
All right, and we'll go over these. Jose, we're going to go over these.
And if, just to be consistent, if we're going to use full names, when we go back to the aggravated assault, we'd ask for Daniel Ramirez Ruiz, AKA Daniel.
Oh, see, this is what starts to happen, okay? And we're trying to get this done so we don't keep these people waiting here all afternoon for changes in semicolons and stuff like that. If there's something really substantive, let's raise it. Otherwise, I really don't want to hear it. You know, if it's something that substantively changes, the actual instruction clarifies it in some way, but, you know, we're not going to, a lot of this is, I just put Daniel Ramirez, and we'll do that. It's just to make sure there's no confusion between the two victims. All right, and if you want to make an objection on that, you can do it. All right, so then we go into the definitions. Those are all standard.
Senator, we're missing physical force, the physical force definition.
also missing some evidence.
We have deadly physical force, but we don't have physical force.
All right, do you have that?
We're talking about lesser
I do,
included.
Judge.
Send that to Jose. Send it to
yes, there are lesser
defense
included
counsel.
on this.
It is in there? Where
I
is
see
that?
physical injury, but I don't see physical force.
A host of
Oh, yeah, it is.
lesser
Where is
included.
it?
It's on the top of the next page. Yeah.
Where?
After
page?
rec.
That's not a definition. That's actually the instruction on justification.
What's in the one I have?
Oh.
Definition of deadly physical force. Deadly physical force means either force which is used for the purpose of causing death or...
Right, it's not the deadly physical force we're missing. It's physical force we're missing.
Oh, I got you.
So would you like me to email that one?
Yes. Okay, so we need physical force akin to email. All right. Now, then,
The state
anything
walked
else
in
about
here
the definitions?
shouting
Until we get to
premeditated
causation,
murder.
ignorance of fact.
And then maybe walking out, getting
So the next
I don't think
intentionally
dangerous
series
misleading a police officer
I don't think
in a
dangerous
report.
offense should be here, Judge. That's for the aggravation phase.
Yeah, I agree.
Oh, okay.
So that one needs to come out.
Thank you. All right, out. Good. So the next series of instructions are all defense-requested instructions concerning justification.
Self-defense is in there. So it's possible the jury could determine that, yes, he did it, but he did it in self-defense, even though that hasn't been argued.
I've sent the physical force instruction, Your Honor.
Thank you. These are all defense instructions. There's one line to be filled in. I'm not sure what that is.
Is the causation, ignorance of fact, is that a Raji? I'm not familiar with that one.
The second victim would be Daniel. He was the gentleman who said he witnessed this. Ran for half an hour, looked back at the border, and saw
think we
Mr.
need-
Kelly standing over.
Yeah, I don't know that we need the
The body.
causation or ignorance of fact. I'm not sure why that's in there.
These are, if you don't want it, these were ones that you
Yeah,
suggest-
we can take that one out.
All right, causation, ignorance of fact, we'll take that out.
Great idea, Rona.
And Your Honor, I think so for the justification use of physical force, I don't think that one applies because I don't think there was physical force used in this case. If you look at the definition of physical force, what it says, this is the instruction I just sent to everyone. It means force used upon or directed toward the body of another person and includes confinement, but does not include deadly physical force. I don't think there's any facts in this case that Mr. Kelly physically assaulted anyone, so I don't think that definition comes in. It's duplicative of the deadly physical force one, and that one is the one that I think is applicable.
And Judge, I would just say that if Mr. Kelly is firing up into the air to try to scare people off of his property, then he is using physical force. He's not
Physical
using
force is
deadly
typically-
physical force. He's
context.
threatening deadly physical force, arguably, and also using physical force.
That's not physical force.
Let me say, I've read a lot of case law on jury instructions for justification and self-defense, and they consistently say that if there's, I think the word they use is a scintilla of evidence to support the defense, the court's got to give the instructions. So I'm going to give that instruction.
I just haven't heard what the scintilla is, Judge. That's the only thing I'm looking for. Is we have a defendant who shot his gun in the air. It's either threatened use of deadly force or deadly force, depending on whether you believe he shot it in the air or whether he shot it at them.
Got it. You can make your objection, formal objection, when you get to it. What about the rest of these? These are defense requested instructions. Do you want these instructions?
Judge, and I would argue that.
Can I hear from the defense, please, first?
Oh, sure.
Yes, Judge, we want justification for self-defense, involving physical force, and justification for defense of a third person, justification in defense of premises.
On that one, I'm just going to stop you. I don't know what, there's a blank there. I'm not sure what that was. Do you know what that was? Justification in defense of premises. It's, I don't have page numbers anymore, but it's in the middle of it's the bottom half of one of the pages. And the first line,
justification is talking about self-defense. And this would be. This would be when Mr. Kelly says,
you have those?
I'm getting shot at, I'm going to return fire.
What's in the brackets?
Threatening to use deadly force, deadly physical force, and using physical force, and attempting to use physical force, and threatening to use physical force.
Judge, can I approach? I can just give you my copy.
Yeah, that would be helpful. I appreciate that. I mean, I don't know why it's difficult to work off the same, different pages. Thanks. Thank you. All right, I got you.
And Judge, I would like to talk about the third person one as well before we, I know you're looking at this one right now, but I would like to discuss that one.
The third person is his wife.
Yeah, Judge, but she's inside the house. There's no indication that anyone ever threatened her, so there's no defense of a third person here.
Well,
she's inside the house. No one ever pointed a gun at her. No one ever pointed a gun at anyone.
He was in the house.
The case law, as I said, says any scintilla of evidence. I don't know what a scintilla is, but it's probably one half step above microscopic. I'm not going to commit error by not giving instruction if there's any evidence to support the instruction. That's what the case law says. That's what I'm going to follow. Now, what about on this justification of defense of premises? There's some bracketed in there. We've got to select
There's
one or
a
more.
lot of bracket even above that one, Judge. I'm on 31.
Oh, right. You're right.
That needs to be fixed.
And Judge, as to this one, this is completely inappropriate. There's currently legislation pending because the legislature recognized that this justification defense does not apply in this case. The reason is because it requires that the offense occur on the premises, which is defined as the residence.
Your Honor, that legislation that she's referring is just purely castle doctrine on shifting the burden of proof. It has nothing to do with giving the ability to shoot someone out in the property like a lot of the media is saying. It's a castle doctrine.
What is there, legislation pending?
Yeah, Judge, and obviously counsel hasn't looked at the legislation because the legislation specifically changes. Right, Judge, but what I'm saying is the reason why the legislature is changing it is because they recognize that this justification does not apply in this specific case.
Well, they haven't changed it yet, and the governor hasn't signed it yet.
I'm not saying that, Your Honor. I'm saying this one doesn't apply here because it's the definition of premises in the statute, which has been left out of the version that defense counsel provided. The definition of premises includes that it has to also include a house. So they have to be trying to get into a house in order for this justification defense to apply.
And, Your Honor, to remind you that the threat came to them while they were in their home.
Well, to me, that's a scintilla.
I had
And Your Honor,
All right. We're bouncing around too much. Part of it is my fault because
working off a different draft. Let's look above that on page 31. Ms. Lothar points out, says physical force, there's some brackets there. The brackets mean there's alternative language that can be used in the instruction. What is the, let's go through this more systematically. What is the defense position on which of those elements should be used that is bracketed?
I'm sorry, where are we?
Here's the problem.
Page
I
31,
think the live stream is
physical
past
force was necessary
the
to protect
closing
another's
statements.
use, attempted use, apparent attempted use, or threatened use of physical force against a third person.
I think we might need more than one of those, so could we do or? So physical force was necessary to protect against another's, I would say certainly attempted use, or apparent attempted use, or threatened use. Well, actually, I think we need use too. I think we need all of those, we just put an or of unlawful physical force against a third person.
Your Honor, obviously, we're going to continue to argue that there was no use of force, there was no attempted use of force, there was no apparent attempted use of force, there was no threatened use of physical force in this case, specifically with respect to physical force, under any scintilla of any facts.
We have evidence that was reported by law enforcement officers that Mr. Kelly said he was shot at. Now, you don't agree with that, whether it's proof or not, but, I mean, if there's evidence in the record that the defendant, that the jury heard that the defendant says he was shot at.
We may have a live
And then
stream.
6 minutes later, he said, I don't know, wasn't shot at. It was from another direction. I don't know what direction it came from. And then when he talked to Detective Ainsa, he said, no, I don't know where the shot came from. And he's inside his house. So that he's not shot at, he's inside his house. On all of the fact scenarios, he says he's inside his house.
Can he be shot inside his house?
Yes.
I mean, Ms. Hunley, I understand what you're saying, but I'm dealing with case law from Supreme Court of the State of Arizona, Court of Appeals of the State of Arizona that says if there's any, I mean, the case law is clear. The trial court must give these instructions if there's any scintilla of evidence to support it. You know, it's reversible error. I mean, and there's one interpretation of the facts that you're giving, but there's another interpretation of the facts that facts in the record that show or provide at least a scintilla of evidence that the defendant was being shot at. Whether the jury believes it or not, it'll be up to them. So, you know, I'm not going to get led into error I've done the research. I'm not going to get led into error because you have a separate interpretation of the facts. All right, let's move on. I'm going to put or use or attempted use or apparent attempted use or threatened use. We're going to remove all those brackets.
Okay, we're watching for.
All right, what about number 2,
court
Ms. Larkin?
feed.
Let me hear from you first.
Same thing, Judge, we'd ask for the ors.
Remove brackets.
I think right now the judge is regretting not granting the judgment of acquittal.
All right, now the next brackets is where we were before on justification. Let me hear from the defense. A defendant in lawful possession or control of the premises is justified in, and then there are 1, 2, 3, 4 alternatives there.
I think the same thing's appropriate, the ors, and keep all of them. And then there's a bracket at the bottom. It says the force used may not be greater than reasonably necessary to prevent the attempted criminal trespass. So I'd say the attempted or actual criminal trespass.
Okay.
And then on the next page, let's see, it's just reason criminal trespass was being,
I think she's
and
had
I would
some
say
sound
committed
arguments
or
today
attempted.
that the judge has sort of knocked down.
And Your Honor, I don't think there's, I mean, maybe counsel can explain to me how I'm missing it.
Well, tell me, first of all, hold on a second. Just let me tell me, show me where you're looking. What are you talking about?
I'm at the top of page 32, and there's the very first line, there are those brackets where it says committed, attempted.
Mr. Jetty, can I have your instructions again? Because I'm going to.
If we can get them live, we'll
32
do
is
it.
different.
We have a hard time getting a live feed out of this courtroom because of the cell coverage. Same reason they couldn't get Google
Sorry about
Earth
that.
down at the border.
Do we just want to make a copy of the whole set, Judge?
Let me have the
for
rest
you?
of those. You can just look over Ms. Huntley's shoulder thing. I'm sorry about that. Okay. All right, I'm with you now.
Committed, we just want to say committed or attempted. And then the other bracket where it says the defense ends when the attempted, I would say the attempted or actual criminal trespass ends.
Whoa, whoa, whoa. Hold tight, hold tight. Do we have anything? Do we have any audio? Hang on one second. Why do we not have audio here? Bring us audio. We have no audio from the live stream. Audio's turned off. Does anyone else got audio? You have audio? Just 1 second. We're waiting for... Seriously, guys, seriously.
Is that correct?
I am not seeing the live audio. I'm not getting it. No court audio. There's no audio. So we can listen to the other stuff first, but
All right, so we'll take out that redundant second-degree murder, right? And then we'll start with the crime of second-degree murder includes the lesser offense of manslaughter and negligent homicide. Manslaughter, negligent homicide. All right. Then on to 34. What about the criminal trespass? We don't.
Your Honor, and I think that what we'd need to do, these are just the lesser included portions. It doesn't, oh, no, they're in there. Never mind. No, I think we actually need to insert the manslaughter description right there where it says manslaughter on page 33. And then we would need to insert the negligent homicide instruction right under negligent homicide.
you guys hang
Oh,
on.
that one's actually there. But the manslaughter one looks like it's missing here, unless I'm just missing it.
We're trying to find a feed that has audio. My feed does not have audio.
And I think the only manslaughter that applies is the reckless, so I don't think we need to say it can be committed in two ways.
Jury's coming in. We're trying to get this
All
here.
right, I'll reorganize these. What about the criminal trial?
We're going to turn off that audio because that's not right. Let's try this one. Okay, here we go. Jury coming in. There we go. Keep this audio on. Let me. I don't know why that feed does not have audio. Yeah.
He's right.
Thank you. Please be seated. The record will show the presence of all the jurors, counsel, and the defendant. Ladies and gentlemen, the jury, thank you for your patience. Obviously, my projections yesterday about how long this would take us didn't turn out to be accurate. So thank you for your patience. But we are now ready to proceed with the final jury instructions. Each of you has a copy of the final jury instructions. There's a couple of typographical errors that I'll point out, I think, as we go along. You're welcome to follow in the instructions as I read aloud, or just listen to what I have to say, whatever you're most comfortable with. You will have one set of these final jury instructions with you in the jury room when you are excused to deliberate. So you'll have a set of these as well. All right, so the first page is a cover sheet with the caption of the case. Page 2 is where we start. It's called Duty of Jury. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide the case. It is your duty to determine what the facts are in the case. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as the jurors, are the sole judges of the facts. You must consider all of these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. The state has charged the defendant with certain crimes. A charge is not evidence against the defendant. You must not think that the defendant is guilty just because of a charge. The defendant has pled not guilty. The state, this plea of not guilty means the state must prove each element of the charges beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. It should be on the top of page 5. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means that the state must prove each element of each charge beyond a reasonable doubt. In civil cases, this is not, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt.
I'm going to try to fix the picture here.
There are
We're going to
very
keep
few
the
things
audio
in this
going,
world
so
that we know with
you can see me
absolute
for just a
certainty.
second.
And in criminal cases, the law does not require proof that overcomes every doubt. If, based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. There are 3 standards of proof that we use in our legal system. 1, preponderance of the evidence. 2, clear and convincing evidence. And 3, beyond a reasonable doubt. preponderance of the evidence is a party having the burden of proof by a preponderance of the evidence must persuade you by the evidence that the claim or fact is more probable true than not true. This means that the evidence that favors a party outweighs the opposing evidence. Clear and convincing evidence, a party having the burden of proof by clear and convincing evidence must persuade you by the evidence that a fact or a claim is highly probable. The standard is higher than the standard for proof beyond. The standard is higher than the standard for proof by a preponderance of the evidence, but it is lower than the standard for proof beyond a reasonable doubt. Now we come to the standard in this case, which is proof beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means that the state must prove each element of each charge beyond a reasonable doubt. Proof beyond a reasonable doubt is proof by the evidence that leaves you firmly convinced of the defendant's guilt. This standard is higher than the standard for either proof by a preponderance of the evidence or by proof by clear and convincing evidence. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. You must decide whether the defendant is guilty or not guilty by determining what the facts are in the case and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. You are to determine what the facts in the case are from the evidence produced in court. If an objection to a question was sustained, you must disregard the question, and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. The state must prove guilt beyond a reasonable doubt based upon the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. In their opening statements and in their closing arguments, the lawyers have and will talk to you about the law and the evidence. What the lawyers say is not evidence, but it may help you to understand the law and the evidence. Some of the exhibits that have been admitted into evidence have portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to decide the importance to be given to the evidence regardless of whether it is direct or circumstantial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness has testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before the trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of all of the other evidence. Consider all of the evidence in the light of your reason, common sense, and your experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. you are to consider the testimony of a police officer just as you would the testimony of any other witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all of the other evidence in this case. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant, acting with the advice of an attorney. You must not let this choice affect your deliberations in any way. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. You have heard evidence that a witness has previously been convicted of a criminal defense. You may consider this evidence only as it may affect the witness's believability. During the trial, the court admitted evidence for certain limited purposes. In connection with that evidence, the court gave you limiting instructions. That evidence was admitted only for the limited purpose that the court stated at the time, and therefore you must consider it only for that limited purpose and not for any other purpose. Evidence of other acts that have not been charged has been presented. You may consider these acts only if you find that the state has proved by clear and convincing evidence that the defendant committed these acts. You may consider these acts to establish the defendant's preparation. You must not consider these acts to determine the defendant's character or a character trait and therefore committed the charged offense. Each count charges a separate and distinct offense. You must decide each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proved beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdicts. The crime charged of second-degree murder requires proof of one of the following. One, the defendant intentionally caused the death of Gabriel Cuen Buitimea, thereafter abbreviated as GCB. Or two, the defendant caused the death of GCB by conduct which the defendant knew would cause death or serious physical injury. Or three, under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of GCB. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. The crime of second-degree murder, which I just described, includes the lesser offense of manslaughter and the lesser offense of negligent homicide. So now we're going to discuss the elements of the offense of those two additional lesser included offenses. Manslaughter. You may consider the lesser offense of manslaughter if either, one, you find the defendant not guilty of second-degree murder, or after a full and careful consideration of the facts, you cannot agree on whether to find the defendant guilty or not guilty of second-degree murder. Reckless manslaughter requires proof that the defendant recklessly caused the death of another person. Reckless manslaughter, the crime of manslaughter, requires proof that the defendant caused the death of another person and was aware of and showed a conscious disregard of a substantial and unjustifiable risk of death. The risk must be such that disregarding it was a gross deviation from the standard of conduct that a reasonable person would observe in the situation.
Switch things up just a little
Second-degree
bit.
murder and manslaughter may
I'm gonna
both
jump to
result
my
from
picture
recklessness.
again one more time. Just one
The
second. I'll
difference
keep hearing
is
stuff.
that the culpable recklessness involved in manslaughter is less than the culpable recklessness involved in second-degree murder. We should be at the top of page 24. If you determine that the defendant is guilty of either second-degree murder or manslaughter, but you have a reasonable doubt as to which it was, you must find the defendant guilty of manslaughter. You must unanimously agree that the state has proven manslaughter beyond a reasonable doubt before you may find the defendant guilty of manslaughter. The other lesser included offense is negligent homicide. Negligent homicide. You may consider the lesser offense of negligent homicide if either, one, you find the defendant not guilty of second-degree
I'll fix it here in
murder
just a second, guys. Give me a minute.
and not guilty of manslaughter, or after a full and careful deliberation of the facts, you cannot agree on whether to find the defendant guilty or not guilty of second-degree murder or manslaughter. The crime of negligent homicide requires proof that the defendant, one, caused the death of another person, and two, failed to recognize a substantial and unjustifiable risk of causing the death of another person. The risk must be of such a nature and degree that the failure to perceive it is a gross deviation from what a reasonable person would observe in the situation. The distinction between manslaughter and negligent homicide is this. For manslaughter, the defendant must have been aware of a substantial risk and consciously disregarded that risk, that his conduct would cause death.
Have a slight jump in the video.
Homicide only requires that the defendant failed to but you have a reasonable doubt as to which it was. You must find the defendant guilty of negligent homicide. You cannot find the defendant guilty of any lesser included offense unless you find the state has proved each element of the lesser included offense beyond a reasonable doubt. Now we go to, I think it's count 2 of the information, the second charge, which is aggravated assault. The crime of aggravated assault requires proof of the following. 1, that the defendant committed an assault on Daniel Ramirez. And 2, the assault was aggravated by the following factor, that the defendant used a deadly weapon or dangerous instrument during the assault. Now the definition of assault is as follows. The crime of assault requires the proof that the defendant intentionally placed Daniel Ramirez in reasonable apprehension of imminent physical injury. Now we have some definitions of some of the terms used in defining the elements of the offense. Knowingly. Knowingly means that a defendant acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean that a defendant must have known that the conduct is forbidden by law. Intentionally, or with intent to, as used in these instructions, means that a defendant's objective is to cause the results or to engage in that conduct. Intent and an inference. Intent may be inferred from all the facts and circumstances disclosed by the evidence. There should be a word it, and the final instructions will read, it need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Recklessly or reckless disregard means that a defendant is aware of and consciously disregards a substantial and unjustifiable risk that the conduct will result in death. The risk must be of such a nature and degree that disregarding it is a gross deviation from what a reasonable person would do in that situation.
Okay, we're going to pause this for just
Physical force means force used upon or directed towards the body of another person, and this includes confinement, but does not include deadly physical force. Physical injury means the impairment of a physical condition. A deadly weapon means anything designed for lethal use, including a firearm. Deadly physical force means either, one, force which is used with the purpose of causing death or serious physical injury, or two, force which is used, or two, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Justification. Use of physical force. A defendant is justified in using physical force as follows. The use or threat of physical force or deadly physical force is justified only while the use or threat of physical force or deadly physical force is justified only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that imminent physical danger appeared to be present.
Immediate physical danger, not imminent.
Okay, thank you. Let me correct that. If I misspoke, I'll start at that paragraph again. Thank you. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. Actual danger is not necessary to justify the use of physical force or deadly physical force. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. A defendant is justified in using or threatening physical force in self-defense if the following two conditions existed. One, a reasonable person in the situation would have believed that physical force was, and that should say, immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful physical force. And two, the defendant used or threatened no more physical force than would have been necessary to a reasonable person in the situation. A defendant may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of physical force or deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. Actual danger is not necessary to justify the use of physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that physical force was immediately necessary to protect against another's use, or attempted use, or threatened use, or apparent attempted use, or apparent threatened use of unlawful physical force, or you must measure the defendant's belief against what a reasonable person in the situation would have believed. The threat or use of physical force is not justified, 1, in response to verbal provocation alone, 2, to resist an arrest the defendant knew or should have known was being made by a peace officer or by a person acting in a peace officer's presence, or at the peace officer's direction, whether the arrest was lawful or unlawful, unless the physical force used by a peace officer exceeded that allowed by law. Or 3, the defendant provoked the other's use of unlawful physical force, unless the defendant withdrew from the encounter or clearly communicated to the other person the defendant's intent to withdraw, reasonably believing that the defendant could not withdraw from the encounter, and E, the other person nevertheless continued or attempted to use unlawful physical force against the defendant. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification.
That was
If
my
the
son
state fails
texting me
to
about his
carry this
wedding.
burden, then you must find the defendant not guilty of the charge. A defendant is justified in using or threatening deadly force in self-defense if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the defendant used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use or attempted use or threatened use or apparent attempted use or apparent threatened use of unlawful deadly physical force. You must measure the defendant's belief against what a reasonable person in the situation would have believed. A defendant has no duty to retreat before threatening or using deadly physical force in self-defense if the defendant, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in an unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. The next charge concerns the justification for defense of a third person, a different person. A defendant is justified in using or threatening physical force in defense of a third person if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect another's use or attempted use or apparent attempted use or threatened use of unlawful physical force against a third person. And 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect another's use or attempted use, or apparent attempted use or threatened use of deadly physical force. Defense of a third person justifies the use or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, physical force was necessary to protect against another's use or attempted use or apparent attempted use or threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, or apparent attempted use or threatened use of physical force against a third person. You must measure the defendant's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, you must find the defendant not guilty of the charge. The next charge relates to justification of premises. A defendant in lawful possession or control of the premises is justified in threatening to use deadly physical force, and there it should say, or in using physical force, or in, and it should say, attempting to use physical force, or in threatening to use physical force in defense of premises, if a reasonable person in the situation would have believed it immediately necessary to prevent or terminate the commission or attempted commission of criminal trespass by another person in or upon the premises. The use of force may not be greater than reasonably necessary to prevent the attempted criminal trespass. An actual criminal trespass is not necessary to justify the use of physical force in defense of premises. A defendant is justified in defending premises if the defendant reasonably believed that a criminal trespass was being committed or attempted. You must measure the defendant's belief against what a reasonable person in the situation would have believed. The defense ends when the attempted or actual criminal trespass ends. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Now here's some additional definitions. Criminal trespass is knowingly entering in or remaining unlawfully in or on a residential structure or in a fenced residential yard. Premises means any real property and any structure, movable or immovable, permanent or temporary, adapted for both human residence and lodging, whether occupied or not. A residential structure means any structure, movable or immovable, permanent or temporary, adapted for both human residence and lodging, whether occupied or not. Fenced residential yard means a unit of real property immediately surrounding or adjacent to a residential structure and enclosed by a fence, wall, building, or similar barrier, or any combination thereof. All right. The final two instructions are instructions I'm going to give you after the closing arguments and when I send you out to deliberate.
Closing arguments
so
are up.
That concludes the final instructions. Were there any corrections that the court must read? Anything else other than has been pointed out? by counsel?
No, not from the state, Your Honor. No, Your Honor.
All right, very well. So ladies and gentlemen, you put those aside. Again, you'll have corrected with those typographic errors, you'll have corrected the final instructions with you in the jury room when you retire to deliberate. With that, the state can begin its opening and closing argument. Mr. Jetty.
You have 90 minutes for an opening. Unless the judge gave them a little more. They did object to the 90-minute limit and said, we have the burden, we need more time. We'll see if the judge gives them some leeway or not. But defense definitely only has 90 minutes for their closing. These are live. These are live closing arguments. Live closing arguments. We're all caught up. Live, live, live.
Good morning. This is the first time I've been able to address you directly. Once again, my name is Mike Jetty, and I want to just echo what Ms. Hunley said at the beginning. We appreciate your attentiveness during the entire trial. It's been 4 weeks. So we appreciate the time and devotion you have, because it's a very important duty we have here. I'm going to start off by saying that I'm not going to go over every fact. I'm not. Our job here is to take the wheat from the chaff here and focus in on the important things in this case. Our goal here is to simplify. So if there's a fact that I didn't cover, don't read into that. You're the deciders of the facts to apply to the law the judge just read. Okay? State v. Kelly, this occurred on January 30th of 2023. Oh, I'm sorry, was this? The whole thing was not. I'm sorry, Lydia, that's my bad.
This counts against your time.
Like I said, my job here is not to go over every fact in this case. State v. Kelly, it's an event that occurred on January 30th of 2023. Gabriel and Daniel were in the U.S. seeking the American dream. Yes, both were undocumented migrants. Both were escaping extreme poverty. Defendant sees Gabriel and Daniel running back to Mexico. Not just running back to Mexico, 115 yards from his property, beyond 2 fence lines. And they're running because earlier they found Border Patrol. The group scattered and the 2 took off. The defendant sees them beyond the 2 fence lines, 115 yards away, picks up his AK-47 that he keeps by the patio door, steps outside of that patio, on that patio door, or the patio area, and without verbal warning, without a shout, without any indication to both Gabriel and Daniel, points that weapon at these 2 men and shoots over and over and over again, 9 times. Gabriel was judged that day and sentenced to death by the defendant. This picture of Gabriel. And that's a picture of the AK-47, the weapon used. That weapon can fire 30 rounds in 6 seconds. You were out there. We had jury review. I forget which week it is now. I think it was last week. And that's a view from the patio and the gravel. This is 14 months ago. So obviously there's new growth out there. We were all out there. You see, that's an individual out there. This is the site view for the patio and gravel. You saw this picture earlier in opening. And that is Detective Barba out in the distance. Question you have to ask, is that a threat? Is that a threat to you? The answer is no, it's not a threat to the defendant. That's a picture of Gabriel in the high grass. Lights in the background. of the Kelly's home. The position of the body, orientation of the body, the injury, matches up directly with the defendant's home. That's the injury wound caused by the projectile, which matches up with the defendant's home. That's a picture rolled over, Gabriel rolled over, hand clenching his chest, I've been shot, falls forward and dies. That injury breaks 3 ribs, perforates the right lung, 3 lobes of the right lung, and severs the aorta. You're not moving after severing the aorta. You're done. Life is over. It's a picture of a drone. We're going to walk through it. Saw the cones? That's estimated by Detective Bunting where the shooter was standing. We're going to go past one fence line. We're going to pass a second fence line. This is a distance here. 115 yards. We're going to see some red cones here where the victim's body was located. And we all stood out there on that site. Camera's going to pivot.
Amateur drone operators here.
We heard from GPS that they took the drone footage and put it on a mapping of some sort, and it gives us this GPS mapping. The blue line on the left-hand side, that's the north-south directional line. The red one, east and west. And that green line is the patio to the victim's body. And that's the orientation of the victim's body. And we'll say it again. Matches perfectly from the patio to the victim, the orientation of the body. The defendant shot 9 times. He's been charged, secondary murder, and aggravated assault with a deadly weapon. Secondary murder, you heard from Ms. Hunley in the opening, is a unified offense. There's 3 ways to prove it. You don't have to agree on all 3 ways, but you have to agree on secondary murder. First way, Kelly intentionally caused Gabriel's death. You walk out on a patio and point a gun at someone and shoot 9 times. That's intent. Kelly caused Gabriel's death by conduct Kelly knew would cause the death or serious physical injury. An AK-47 is a serious weapon. It's no play toy. When you fire it 9 times at a human being, it's a serious activity. Third, under circumstances manifesting extreme indifference to human life, Kelly recklessly engaged in conduct that created a grave risk of death and thereby caused Gabriel's death. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. 2 men walking southbound, no danger to you, and you don't even give a warning? Hey, get off my property. Get off my property. Or just sit back and let them continue on. Facts of this case. Gabriel and Daniel were shot at. Gabriel is dead, killed by a high-powered weapon. An AK-47 is such a weapon. Kelly wound is to the right side back. Exit wound, the chest. consistent with the direction of the defendant's home. Defendant's words on his dispatch or BP to dispatch to officers and during Detective Ayden's interview, inconsistent. Every single time the story changed. Every single time the story changed. Daniel's words, consistent. Heard an AK-47, horse saved his life, heading southbound. I just want to repeat real quick since we're on Daniel. Daniel's the only one in this courtroom, on this hill, and likely in the city of Nogales, who's ever been shot at with an AK-47 9 times and be next to a friend who just died. So maybe, during his testimony, distance and time is a little skewed. Just maybe. But he knows it's an AK-47, he knows it's a red horse who saved him, and he's heading southbound. Defendant steps out, no verbal warning. Defendant shot his AK-47 9 times. There's shell casings found with the ejection pattern that matches what DPS forensic scientist Burnell is consistent with the ejection patterns and position orientation of the body. Once again, matches up with only one known shooter. You've heard instruction, there's also a lesser included. So if you do not find, beyond a reasonable doubt, the defendant caused secondary murder, you can consider manslaughter. And manslaughter, as a judge read, and you'll have jury instructions, and won't spend too much time on this, it requires proof the defendant caused the death of another person, and the defendant was aware of and showed a conscious disregard of a substantial and unjustifiable risk of death. Stepping on a patio with an AK-47, shooting at 200 men walking southbound, no danger to you. And if you don't find secondary murder, and you don't find manslaughter, you can consider negligent homicide. Negligent homicide requires proof of the defendant caused the death of another person, the defendant failed to recognize a substantial and unjustifiable risk of causing the death of another person. Aggravated assault, second charge. Aggravated assault with a deadly weapon. The defendant committed an assault against Daniel, and the defendant used a deadly weapon, an AK-47. Assault requires the defendant intentionally puts Daniel in a reasonable apprehension of imminent physical injury. Steps outside with an AK-47 and shoots that gun. And that's the horse. According to Daniel, saved his life.
May it
He
rest in
recognized that
peace.
horse. He identified that horse. That's the defendant's horse.
It's P
And
to
that
the picture
horse
and back.
was between him and the Kelly's residence. Defendant's words. I'm not admitting to anything I've done, but all those things tend to add up. And they do. Removing the wheat from the chaff here. Agent Marcel, first witness for the state.
Thank you, Al.
2:30 phone
Welcome
call.
to the jury.
I'm going to summarize these for you. First phone call, I'm being shot at. I'm shooting back. There are 5 people, all packs, with packs running southbound. I'm being shot at, and I'm shooting back. 5 individuals in this story. That's at 2:30 in the afternoon. 6 minutes later, defendant changes that story. I had an altercation with someone. I heard a gunshot in his direction, in my direction. Inspected his horse while they spoke. I'm going to argue he inspected his horse because he shot his gun 9 times. He wanted to make sure he didn't shoot his own horse. We were too far to tell if any of them had firearms. And that's probably the most truthful thing he says here. Because you were out there, 115 yards is pretty dang far away to see a firearm on an individual. 2:40, 10 minutes after that first phone call. And what's happening in the background with 2:30 is BP is now communicating to SO Dispatch. And SO Dispatch is doing a code 3 alert, and lights and sirens going off, and all SO people are responding to scene because to them, they think it's an active shooter. And we want law enforcement to believe, when we call them, we want them to believe the story. They're not here to second guess it. So lights and sirens are going. And 10 minutes after that phone call, respond, active shooter response. You heard testimony. Goal is number 1, preservation of life. BP locates a defendant near his barn. And you heard Agent Heredia on the stand. He appeared calm. 10 minutes after being shots fired, I'm shooting back, the defendant is calm. He's calm. He's carrying an AK-47, walking with his 2 labs. No one located on the property on a security sweep. No one. 3 p.m., defendant says people were possibly carrying rifles. Possibly now. We went from, I'm in a shootout, to too far to tell, and now maybe not, maybe so. They were 100 to 150 yards away from his property. Castaneda told the defendant that if anything like this happened again, don't do anything, call 911, stay in your house. And his response, understood it. He said, I want to do what he had to do to protect his property. He was conscious of the consequences. He would take responsibility for his actions. Talking to BP and SO, the defendant never admits that he shot his AK-47. We've got Border Patrol and agents on scene for an active shooter situation, and you failed to tell them that you shot your own weapon? Never told law enforcement that anyone pointed a gun at him. Didn't tell anyone. This just happened. This literally just happened. And you're not telling a single soul that people are shooting at you? Never told law enforcement he was in fear of his life. 423, he's calling. I think this is a thank you call for Agent Marcel to get a quick response to him. In this call, he says, now, instead of 5 folks, we have 10 to 15, all loaded with AR-style rifles. We're getting exaggerated statement here now. 523, this is the second wave of phone calls. That was the first wave, active shooter call, and now we got the calls and dispatch recording related to Gabriel's body. Jeremy, this is Alan Kelly. You need to call me immediately. This is serious. Call me immediately. I can't say more on the phone. Why can't you say more on the phone? Why can't you say more on the phone? 526, he sends that text message. 535, here comes the 4th phone call. This is worse than you can imagine. This is bad. Marcel told Kelly, call 911 and talk to SO. He never does. He never calls the SO. The SO calls him. Because Marcel does what a Border Patrol agent is supposed to do. If there's an immediate emergency, he routes a call to the local law enforcement, which is the SO. And the SO then, without him calling, calls him to find out what's going on, what's so serious, and why immediate response again. You know how shots were fired earlier? Something was possibly struck. Just say, there's a body on my property. Just say it. When Marcel asked for additional details, Kelly said, I can't tell you over the phone. Ask Marcel if this was being reported. That's a noteworthy question right there. This is that dispatch call. Do I have my microphone? Let's see if we can play it.
Lawyers are doing tech things. This usually ends badly.
Hello?
Hi, sir. I'm calling from the Sacramento County Sheriff's Office.
Yes.
Hi. I'm just calling because we received the report from Border Patrol.
Yes.
So I was just calling to get more information. So what happened?
You're going to have to send an officer out here.
Okay, what's going on?
I can't.
I'm sorry?
It's very serious, ma'am, and I can't. I'm not going to talk over the telephone.
Okay, I understand it's serious, but I need more context in order to send a deputy.
Okay, fine. It's going to be,
Go ahead,
well,
you can talk to me. What's going on?
yeah, I know I can talk to you, but you're responsible for what I say, and I'm responsible for what I say.
Can you give me a little context of what happened? What's going on? You told them that
I'm not
you
sure.
shot at. What did you shoot at?
I didn't shoot at any. I haven't said I shot at anything.
Okay, well, that's what Border Patrol told us, so that's why I'm just asking you.
Yeah. Y'all guys, the Nogales Sheriff Department had 4 or 5 guys out here this afternoon investigating a Border Patrol drug running incident. And I don't know if I can't remember the officer's name. There was 2 gentlemen and 2 young ladies. Maybe third. Do you know who I'm talking about? They came out to 100 Willer Cross Circle.
You mean for my deputies, correct?
Yeah, they were Nogales.
Yes, aware of what happened earlier.
You're aware? Okay, then they're aware of what happened, and I don't want to get you in trouble, and I don't want to get me in trouble, but I don't want to break the law or anything like that. So what I'm telling you is that we need a sheriff deputy out here, 100 Willer Cross Circle, immediately, and that's all I can say, ma'am.
Okay, is anyone hurt? I need to know, because if someone's hurt, I need to send an ambulance too.
There's no.
Okay, do you feel more comfortable talking to a deputy over the phone?
Well, in other words, okay, you know the thing. You have the right to remain silent, and anything you can.
I understand.
Anything you say can and will be held against you. In a court of law. I'm not admitting to anything I've done, but all those things tend to add up, and I don't know what happened. I just know what I just saw about 15 minutes ago, and it's something that an ambulance cannot help. EMTs cannot help. There's nothing out here that can be aided by EMT or emergency services.
Okay, I understand you don't want to give me a lot of details, but what you are requesting an officer from me, so I needed to know for their own safety and your safety a little bit of what's happening, what's going on.
Okay, I'll put it like this. Last spring out here, there was a pickup found on East Sagebrush with a dead lady in it. I don't know if you knew of that or not.
Yes, sir. I'm aware of what happened.
Okay, it's a situation similar to that. How's that?
Okay.
You follow it? You understand what I'm saying? It's a situation. exactly like that.
Okay.
And so that's going to require the sheriff to come out here.
Okay, can you tell me a description of, does it
No,
involve a vehicle?
I don't have a description. There's not a vehicle.
Okay.
The only thing that I was referring to in conjunction with that accident was the body.
Okay.
You got it?
Okay, all right. Okay, can I have your name?
Yes, George Kelly.
George Kelly. Okay, George, would you, if my deputy goes over there, would you take him to whatever it is that you found?
Yes, I have it marked. I have a flashlight on over it, because it's going to be dark when he gets here probably, but I'll take it to him.
And you are sure an EMT cannot help?
I am positive. I have a medical background. An EMT cannot help.
Okay. Do you know whoever it is that you saw?
No, I do not know. I didn't say it was anybody. I just said it was a body.
Okay. All right. Okay. All right.
I'm not trying to be smart, ma'am. I'm just trying to.
I understand. You're trying to be careful, and I get that. However, I hope you understand that on my end, I have to take care of my deputies too. So I just needed a little bit more context as to why you needed a deputy to head out there.
Now you know that there is a body here.
Okay. All right. Does it look somewhat?
It's not alive. So you asked, did you need EMT? I said no.
Okay.
I'm sure a coroner will be involved sooner or later.
I just said, George, can you tell me something? Is it discolored from somewhere?
Is it discolored?
Yes.
What does that mean?
Has it been there for a while? Can you tell?
From what? In that I only approached the body to make sure that the animal, it's not a vegetable or a mineral, the animal wasn't alive and it was not alive.
Okay.
There were no signs. There was no signs of blood. There was just an animal laying face down.
An animal?
An animal, and you know what an animal is. It's not a vegetable or a mineral.
Okay.
It's a body, and you know what I'm talking about.
I understand what you're talking about, George. Okay, I'm going to send the deputy then over to your house so you can lead them over to wherever you found what it is.
Okay.
You found, okay?
And now, maybe one of the deputies are out here. They know how to get here because it's 100 Willacross Circle, and it's kind of hard to find. It's a rat right on the border.
So I have one of my deputies that responded earlier going over your way.
That's good. You do that. They know how to get here, and I'll have the gate open.
Okay, sounds good, George. Thank you. Thank you for
I appreciate your help and your patience, and I'm sorry if
No problem. I accept.
Okay.
Okay.
Bye.
Thank you.
That's a phone call SO had to make to the defendant. And it says it's very serious. Recap. Very serious. Can't tell, am I going to talk over the telephone? I don't want to get me in trouble. I'm not admitting to anything I've done, but all those things tend to add up. Detective Lopez gets on scene. That's Exhibit 38. I'm not going to play that for you, but that's admitted into evidence. That's that recording that Deputy Lopez recorded. He says in that, quote, defendant, I have no idea, I have no idea, I have no idea. And you know, if you were me, you got no idea. You know what I'm saying? You literally shot your gun 9 times, and you've got no idea what possibly could have happened. Sergeant Rodriguez gets on scene, 6:15. Sergeant Rodriguez is the one that pronounces Gabriel dead. That's not the time of death. That's the pronouncement of death by law enforcement. No pulse, extremities are cold, but his torso was still a little warm. Importantly, there's no drag marks, blood trails, or foot traffic evidence anywhere. It appeared as though Gabriel fell where he was shot. And at this point, Sergeant Rodriguez does not know Dr. Tim's autopsy results, a severed aorta. That's a drop shot. You're going down. The entry wound lined up with the east patio of the Kelly residence. Again, entry wound and orientation lines up. And then the defendant has an interview with Detective Ayden. In that question, he says, question, did you shoot? I have no reason to believe I shot this person. Ayden, what does that mean? Defendant, it means I have no reason to believe I shot him. That's simple. Question, did you shoot? No response.
He used half an hour
No
of that
response.
time.
Detective Ayden, at this stage, has already talked to Border Patrol, he's already talked to dispatch, and he's already talked to SO. So Detective Ayden has information. In doing an interview, he's not going to disclose the information. He wants the defendant to talk to him. Defendant does not say he shot his weapon. And until 30 minutes into this interview, a 50-minute interview, he finally does. And this is the interaction. Look at me. I can see it in your eyes. Defendant, I haven't said I didn't shoot. Did you shoot? No response. Towards these gentlemen. No, I did not shoot at those gentlemen. Did you shoot? All Detective Ayden is trying to figure out is, did you shoot? And finally he says yes. Then he says, I shot over their heads. Shot over their heads. He shoots in their direction, says at this time, Ayden asks if it's 100, 150 yards away. He affirms that, and he says they were armed. Remember an earlier statement, too far to tell? You were out there. And I shot 100 yards over their heads. I didn't shoot at them, I shot over their heads. Angie, you shot towards the direction of their heads? Yes. Does not admit he shot his AK-47 until 30 minutes into that interview. You saw pictures of the shell casings, you're out unseen. Right next to, if I'm on the patio, they're right to my right. 8 shell casings found. And those are the 9 total. 1 in blue, found by the ATF K9. K9 alerted the evening of, that's around 12:30 in the morning. And the next day when it's light out, they found the other 8 shell casings in yellow. And that ejection pattern, as we're going to see in a second here, is consistent with the ejection pattern of DPS forensic scientist Brunel's review of that weapon shooting the exact same rounds. When we get to the AK-47, where was this gun? Where was this gun that he keeps by the patio door? It was hanging up on a coat rack on a bedroom door behind a sweatshirt. And the only reason it was found was Sergeant Flores opens the door stops its momentum, but the gun continued and bumped the back of the door. He looks behind the door and sees this weapon. What's not true in this case? What's not? There is no evidence of a mysterious shot. None. The only person in this courtroom who has ever said anything about a mysterious shot is the defendant. His wife doesn't even say she heard a shot. And you heard when Ms. Hunley had Ms. Kelly on the stand, you wonder why we asked the question, what were you watching? I was watching a news show. What was the volume? It was on 20 out of a range of 100. You're in your living room. Your husband's in the kitchen. He hears a gunshot and you don't. And you're watching and listening to news at a medium volume. That's a mysterious, magical gunshot in this case. No evidence that it exists. None. The other one is the boogeyman. We've got a lot of armed men on the property. It went from 5 to 10 to 15, all carrying packs, all with rifles, walking this property. And they changed the number, they changed the distance. They're creating a fear here of the boogeyman being there. There's no evidence. None. We have 2 migrants coming to the U.S., heading back to Mexico, who get shot at. Defendant under fire. No evidence whatsoever. They did a search with a metal detector from the house to the victim, no other shell casings, and from the victim out, no round or other shell casings. None. No damage to the house. If you're being shot at, if you're in your house and you're being shot at, where's the damage to the house? No evidence of drug packs or drugs. No evidence of robbery or theft. No evidence of struggling or dragging. None. Someone else must have shot the victim because the victim stumbled over. This is a severed aorta. You don't stumble around. You heard Dr. Tim. You may take 1 or 2 steps and may utter a gasping phrase or two, and you're done. During voir dire, I think it was mentioned by counsel that this is a shoddy, I'm paraphrasing, this is a shoddy investigation. Here's everyone involved in this investigation. Local law enforcement, we've got Border Patrol agents, we've got DPS, we've got outside experts, medical examiner, we've got a guy from Washington, Mr. Wyatt, we've got Mr. Telsel from the East Coast, and we have the FBI. This is a thorough investigation.
Oh, man.
This is Agent Douglas, who you heard on the stand testify about downloads from the defendant's cell phone. You saw that? AK getting a lot of work. 33 dealt with this week. AK hot. AK hot again. It's either fight or run. I'm too old to run. There's BP cameras out there. Anything like this? Expert witness you saw, I mentioned him earlier, DPS forensic scientist Brudenell, talked about the functionality of that AK-47. It works, it's operable. Talked about the ejection pattern, which is consistent with his testing with the results on the scene. Rounds coming out to the right. Doesn't matter if you're right-handed or left-handed. No matter. The projectiles are coming out of the right-hand side of the gun. The injury is consistent with a long-range shot. Why do we know that? Well, we have 2 things we got going on here. We have GSR, we have that cloud from a gun. When you shoot a gun, there's a cloud of particulars that come out. And you heard testimony that usually within 20 feet, some of that cloud dust is going to come on to the person. Well, there is no GSR in this case, which means only other reason is you're further than 20 feet from the victim. That's what it means. This ain't no close-range shot, holding a backpack and doing a gangster-style shot. That's not what's going on here. Because there would be a cloud. There'd be gun residue all over that person, all over him. There's none. You heard the witnesses. They damped the clothes all around and submitted to Ms. Tossell. You heard testimony. No GSR found, which means further than 20 feet. I think it's easy to say that 115 yards is further than 20 feet. We also heard from DNA and fingerprint analysts from DPS. The reason we did is we're doing a thorough investigation here. We're demonstrating to you, you deserve to know that the government is doing a thorough investigation. That's our job. And there is none. Not surprising. There's only 2 people involved in this case. Or 3, counting Daniel. Rick Cuen, expert from Washington, talk about ballistics, talk about the wound, the bullet used is consistent with the wound, shooting reconstruction, and he talks about the bullet being in yaw. I call it a wobble. It hit something on its way. It hit something on its path. So instead of being like a nice little spiral, it's like a duck, like someone throwing a duck football. There's a little spiral off. When it hits that body, that's why the entry wound's a little off. And you saw the scene. Mesquite trees all around. Can hit a branch anytime. It was Rick Cuen who asked SO to go cut that branch. Just to double check. There's no evidence on the branch. It was an indication to you all why the bullet is in yaw. It hit something before it hit. And that's why there's no bullet wipe. Which means when the bullet's carrying some of that particulates on its way, on its journey, and when it enters the body, it's going to leave what we call a bullet wipe. And there is no bullet wipe in this case. Because that bullet is in yaw, because it hit something before hitting the victim. There's no mystery to that. Ms. Telsell talked about no GSR found. You heard from Dr. Tim, cause and manner of death, homicide, bullet wound, injuries consistent with an AK-type weapon, from collapse to possible step or 2, there is no walking with that injury. There is no walking, stumbling around. There is not. Then I just want to talk about the skeleton because that was demonstrative used in this case where defense counsel put the rod, the trajectory rod, through the skeleton and said that must have been the trajectory of that round. That's kind of like a gangster style shooting where you're trying to take the backpack and you're coming up from underneath and you're shooting. You heard Dr. Tim talk about this and you heard Daniel. Possible reason number 1, when someone shoots a weapon at you, what's your reaction? To duck. And the moment you duck, you line that body up. You line that body up. And second, you heard Dr. Tim say, once it hits that rib cage, it gets deflected inside the body. There's 2 reasons why that is the way it is. Not because there's a robbery, not because there's 5 guys out there trying to take quote-unquote drugs off the victim. Entry wound, like I said, in yaw. Exit wound, coming out of the body. It's interesting. Had my gun, shot my gun. He says that at 2:30 to Border Patrol. Doesn't tell Marcel ever again. She had a couple conversations with Marcel after that. Does not tell him. Does not tell BP Heredia on scene. Had my gun, shot my gun. Does not say that. Does not say to Deputy Monreal on scene. Does not say had my gun, shot my gun. Does not say it. Castaneda on scene. Does not say had my gun, shot my gun. These are officers who are responding to a code 3. This is lights and sirens. This is an emergency. Does not tell Deputy Lopez had my gun, shot my gun in this event. Does not tell Sergeant Rodriguez, who's the one who pronounced the victim dead, I had my gun and shot my gun. Does not say anything. Nothing. And you wonder why no one's looking for shell casings around the property? Because no one knows, quote, he shot his gun. No one knows that. Because the only person who's talking to Border Patrol is going to be Detective Ayden, and he's here at the station. The defense never says, had my gun, shot my gun. Never. And Ayden, after 30 minutes, he finally admits, had my gun, shot my gun. Dispatch Supervisor, Ms. Huerta. Defense Exhibit JJJ. At 3:05, Border Patrol contacted Wanda Kelly. And Wanda Kelly, according to dispatch, says, my husband's giving chase. Okay. Husband's giving chase. And to their story, there's 5 armed gunmen with AR-style weapons on my property. There's a shootout, and you're going to take your weapon and go chase them. You heard it on the dispatch log. It's Exhibit JJJ. You guys can pull it up. Canines and the defendant and the canines are on scene first. And it says, there's a quote, canines disturbing the scene. Canines are at the body. 6:42, Rodriguez is trying to confirm with Border Patrol the subject struck something. There's no jumping to conclusions. None whatsoever. He's asking for confirmation and he gets confirmation. Deputy Castaneda, this is Wanda's statement when he's on scene. 5 individuals, some carrying rifles. Defendant grabs his rifle, he keeps by the door, not hanging in the bedroom door under a sweatshirt, keeps it by the door. Went outside, heard shots outside. Does not say the shots she heard were the defendant's shots. And then he takes off and leaves her to go chase the marauders.
He's used 46 minutes so far.
Defendant states that they were running south in pursuit. Importantly, Castaneda on scene, no rifles, no backpacks, no signs of a large group of 5 people passing through. None. Agent Marcel, it's important. Agent Marcel told you there's no rip crews in the past 10 years. No AR-15 rifles ever found in the past 10 years. And if this is being reported, that quote, he said it meant to him, he thought it meant, is this being brushed under the rug? Undocumented migrants, you heard testimony. Migrants, not drug dealers, not gun-carrying, toting drug guys, but undocumented migrants coming here to the United States for a better life make up 98% of all apprehensions. 98%. They all wear camo because migrants also don't want to be detected. And they all carry backpacks with food and water. There's no mystery here. 0, because you have a backpack. None. Migrants use radios for pickups. When they come into the country, they're going to get picked up in a car to get transported. Yes, this is all arranged. We're not dummies here. We know how this works. But having a radio does not mean you're a drug dealer. Having a radio means you're communicating with someone so you can get picked up later on the side of the road. So you can be traveled to Tucson or Phoenix or wherever you're going. Defendant was reluctant to have the SO respond. And cartels, when they get involved, they make things messy. There's no single shot with a cartel. None. Daniel, the victim, an eyewitness. From Honduras, extreme poverty.
Counsel?
Yes,
What
ma'am.
about due for, I think the jury's been in here since about 9 o'clock, so it's been about an hour and a half. Well, I'm sorry to interrupt you, but
No problem.
we have to take a recess. So we'll take a 20-minute recess. We'll be back here in about 10 to 11. We'll stand a recess until 10:50, 10 to 11.
We rise to the floor.
Okay, so as they're on break and we're waiting for the feed to come back that's live, we cannot fast forward through it. Interesting close. They've used, by my count, just shy of 50 minutes of his time. We think it's 90 minutes. The judge initially said they were going to get 5 minutes or 90 minutes. The state objected and said, "Judge, we have the burden of proof. We need more time than that." Judge says, "I'll consider it." Haven't heard if they actually changed that, but we're watching, because initially it was it was a 90-minute limit. Judge Interruptus strikes again, says Idaho Mom. For those who have followed this case from the beginning, I know we've missed a few days in the middle because of the Apple River trial. It's fairly obvious that the state, in presenting their evidence to the jury in this closing summation, their closing argument, that they're both picking and choosing what testimony they're accepting from each witness that testified, as well as being generous with the facts in their favor. The fact of the matter is, this isn't clean. We don't have witnesses all that corroborate and say, yes, this is the set of facts as they occurred and we all saw it and agree, or we don't even have physical evidence that matches what the witnesses who say they saw it agree. There's a mess here. It's not clean. Unfortunately, and I've said this before, there is a likelihood, and I would even go as far as say as a high likelihood, that Mr. Kelly shot this man. But there is not beyond reasonable doubt, because there is no evidence to put it. The evidence they have, if you take it in totality, everything they have, it contradicts itself. How can you have someone who gets the location wrong, gets the happenings wrong, yet, I mean, the physical evidence of what he observed standing right there describes it wrong completely. He fell over on his back, eyes rolled back in his head. I watched him. I jumped over his body. Do you think there would be footprints if you jumped over your body? And there aren't any. They don't have any evidence that he was even at the scene. The state said it themselves. We have no evidence that anyone else was there around that body. But what they do describe, what Daniel does describe, doesn't match what happened, what they found on the scene. The state's saying there's no evidence of drag marks. There's no evidence of any robbery. They've got backpacks unzipped with like nothing inside. Fanny pack broken, ripped off, unzipped, nothing inside. The backpack pulled up over his body. When you fall, I just don't think that this happened the way that they're saying. They're saying there's no evidence of any struggle. There was no evidence there. I'd say, yeah, there is. There's evidence that your witness was lying to you, but you believe him wholeheartedly, even so far as that your investigator, translator corrected his statements to make it match the situation. It's rough. It's rough. The whole physics. Yeah. We have this shot. It lines up perfectly. We can go out the body. It's like we can look down the trajectory rod of the body and it points to Mr. Kelly at the other side. Yeah, that's one of their arguments. It's the only way it could happen. He's got a gun. That guy got shot. Must have happened that way. We can line it all up. But then we actually look at the body. It's like, now let me explain why the bullet hole in the body doesn't match that trajectory. First of all, he was crouching down when it happened because, he had time. We can fire 30 rounds in 6 seconds, okay? But in that time, in that 9 seconds, he was able to crouch down or those 9 shots were fired, which if you do the math, that quickly, it could have been really, really quick. He crouches down, and when he gets struck, the bullet comes in at a weird angle because it struck something else first, probably because it wasn't aimed at him. I don't know. And then it changes the trajectory and goes in a funky way through the body. They're trying to have it both ways, saying that this is evidence that Mr. Kelly did it, and the reason the evidence shows that it might be something else is because it happened in this interesting little scenario. They did have one footprint. They weren't sure what it was. Wait, do you not believe this was a drug run? Original Sin, I have trouble believing that Daniel, who I believe has crossed the border in an illegal method, 10 times before, just can't get up the nerve to actually he'll pay the money. He'll pay the $2,500 to cross the border. But as soon as Border Patrol comes back, he's like, hang on, I'm running back to Mexico. I'm going to give this another try. I'm going to save up some more money and try again tomorrow. That I'm looking for a better life. I'm looking for, escape from the abject poverty that I live in. And every time I cross the border, it's just, That dang Border Patrol truck, I get the heebie-jeebies and I got to turn around and head back to Mexico. I don't buy that. I don't buy that these two people are they gave up on their dream. It doesn't make sense to me that that's what happened. It doesn't make sense. $25,000 worth of crossings. One of them, he was convicted for carrying drugs. That was 10 years ago. Served time. The U.S. didn't say when he first talked to the cops that was true. As a matter of fact, he gave a different name than what he served time under. Tracy Fagan says, if it was a robbery, would they leave the stuff in the pew-pew? Nope. But they say we have no evidence that it was drug related or even smuggling related because there's no money or drugs. But they got a dead guy and bags that are unzipped, and they're headed back to Mexico. Hey, you need to go over that direction? Okay, go ahead. Kids are like, turn off the camera. I need to get something behind there. How's school going? Good? What was for lunch? You're still eating. Okay. All right. Because they stole it. They're trying to tell the jury one of the big things that we're hearing about is that the investigation was thorough. That this was the best it could be. The state, using your taxpayer dollars, is functioning at the highest level of efficiency and effectiveness. I guess I'm not sure if those are similar. That we had the FBI involved. Of course, it's not a shoddy investigation. Look at all these people. We called 2 experts. This isn't a shoddy investigation. But I have to, when he says that, I'd like to believe him. At the same time, I have a hard time hearing all his detectives say it wasn't my job. Someone else was going to do that. Nope. I'm not the one I'm the investigator asking the guy the questions. Okay. I'm interviewing a witness, and he says stuff that isn't true, and I know it's not true. It's not my job to question him and try to figure out why. That's not me. Somebody else is going to do that. And then you throw the sheriff's involvement in here, that he steps in of all the cases. Okay. And they have a lot of cases that involve, border issues. Of all the cases, he's like, this is the one. I'm just gonna run down to Mexico real quick to express my condolences to the family. We'll talk to them. I'll talk to them on my own. We'll just head down there. I've got friends. I've got some connections. We'll go down. We'll talk it over. And while he's down there, they're like, oh, and funny thing. While I'm there, this guy came in. The girls are like, oh, that's my uncle. The uncle said, yeah, I'm the uncle. I can get you a witness. Oh, really? That would be great. Let's schedule another time for me to cross international borders and come down as the sheriff and interview the witness. And he does it. He shows up, and it's surprised the witness is there. I had no idea. It was this ad hoc situation. I wasn't prepared for an interview. Didn't even think about recording it. It's like, oh man, we're here. We might as well do it. Yeah, he tells his buddy, his detective buddy, who was there to vouch for him, 2 weeks on the job, right? Brand new detective. He drags him along for this international investigation. Says, don't bring your badge. Don't wear your uniform. Don't bring a gun. We're going to go under the radar here. Has the interview. 45 minutes, maybe an hour. The last 6 minutes of it, he's like, all right, now let's film this one more time. We're going to record this. If you can say what we talked about. And they get a 6-minute interview. And he thinks that's good. He thinks that's right. He thinks that's good police work. I have questions. I don't have any evidence that the sheriff wants Kelly's ranch. I know the family has land, but I don't know if it's borders, but it's very close to each other. The sheriff's family has like a 1,000-acre ranch. It's a big ranch down there. Mr. Kelly's ranch, 172 acres. I'm not sure any of it could be considered prime real estate. It's tough land. It's dangerous land, just because of the weather. It's rugged. It's so sparsely the vegetation is so sparse on it that on Mr. Kelly's land, I think he could handle 25 cows or something like that as a max. There's just not enough foliage. Look, I said it right the first time. Foliage to sustain that. It's not. This is not your beachfront property. All right. How long till they're back? A few minutes. We don't know because it's live. If the judge takes longer, it takes longer. What I think the jury is not buying is when defense is spinning the truth, or let me say this: the defense is spinning the evidence, because I don't know what the truth is. Okay, I don't. But thankfully, the jury is the one that gets to decide who was telling the truth and who wasn't. But the defense is spinning what we heard to make it fit their theory. But almost every single witness they called, and this includes expert witnesses, contradicted their theory in one way or another. Almost every single one. Some witnesses didn't know what the right answer was and flipped. Like we saw at the end of the trial. Literally, they'd say, "Is it likely? Is it likely? And is it possible for the defense for Daniel to say he was 7 meters away with the horse between when the shooting started for Mr. Kelly?" Witness was like, "Yep." Investigator, "Yep." They're like, "Seriously? You think it's 7 meters away with horse between them? That horse only 7 meters? You think they could be that close?" "Yep." "Is that likely?" "Yep." No, it's not. They have struggled throughout this entire case with getting witnesses to confirm their theory. And what does it add up to? I think it adds up to probable doubt. Probable doubt. Reasonable doubt. Now, it's also possible that Mr. Kelly did this. He has a gun. He has an AK-47. He admitted to shooting, but there's just no evidence. We don't have a bullet. We don't have a match. We don't even know if the caliber was the same as Mr. Kelly's gun. All we have is a witness who doesn't even know which side of the town he was on, thinks he was right next to the border when he was a mile and a half away, if he was actually there. On the west of the town or the east of the town, doesn't make sense. And says that he heard AK-47 rounds. Now, some firearms experts, and I can tell you talk to Ian Runkle, he can probably say, I can hear an AK-47. I've got that sounds, I can pick it out. They do sound somewhat distinctive. Most people would not be able to tell you if it was a shotgun or a rifle. Now, I think I could do that pretty easily, but most people would not be able to say, "Oh, that's a pistol, that's a shotgun or a rifle," from the sound of it. So for him to be able to say it's an AK-47, I'm surprised. I'm a little surprised. All right. Melissa, you are just chuffed beyond belief that we're on the same page. Let's see. How would lack of gunshot residue be explained if the victim was shot at close range? Great question. Gunshot residue, there are concerns about gunshot residue because where the bullet entered, they try to say, they want to say he was shot in the back, right? He was wearing a backpack. They tested the clothes he had under the backpack. The backpack did not have any damage on it. And the whole 20 feet that the prosecutor is saying, this shows that he was shot from more than 20 feet away because you'd have this cloud of gunshot residue. Most experts say it's between 2 to 7 feet that gunshot residue is possible to be picked up. Not sure. See, I think the witness answered the horse distance correctly. It just wasn't the answer the prosecutor thought she'd get. Yeah, a horse can fit between two people, 7 meters apart. If the bullet really did come in the direction from Kelly's house, isn't that significant, though? How do we know it came from the... Here's the problem. For us to know it came from the direction of Kelly's house, we need to know what it traveled through and in what direction, right? We need to be able to draw a ray back towards the Kelly house. Where the body fell, the state is saying it fell just like that. That's the way it would fall, in that direction. Unfortunately, their witness, who's the one who says it was Mr. Kelly who shot, says he shot And my buddy, Gabriel, says, oh, I'm hit. He grabs his chest. Oh, I'm hit. And he falls backwards and his eyes roll back in his head. That's not the evidence on the scene. The eyes roll back in his head. He's not going to be like, oh, let me come to again, shuffle around, lay down on my tummy. Okay, line up the line. There we go. It doesn't work like that. You can't have him be dead on his back and also dead on his stomach. And because of that, I can't trust the angle. I can't say because of where the body fell, I can tell where he was standing when the shot was fired. They don't have the bullet. They weren't able to recover the bullet. Why were they not able to recover the bullet? Okay, because they used metal detectors. They went beyond because it was a clean through shot, right? The bullet went clean through Gabriel's body. And they checked on the other side with metal detectors and couldn't find the bullet. Now, it's possible they just missed it. But is it also possible that the body was rotated a different direction? That the bullet, where they should be looking down the range from that shot is a completely different location? Could that also not be a reasonable explanation as to why they didn't find a bullet? Does Daniel still get citizenship if Mr. Kelly's acquitted of all charges? I believe so. I believe Daniel gets citizenship for participation and being willing to testify. He held up his end of the bargain, and to his credit, the deal's on. The deal's on. So I believe Daniel does get citizenship and possibly family as well, as the way the law is written. We may hear about that in the defense closing. Let's see. Was the body moved? Jenny, we didn't have any evidence. The state says there's no evidence that the body was moved. Don't see this being long with the jury. Does it get citizenship or residency? I believe it's citizenship. I'll have to look at the rules, and I don't know the actual agreement with him. Could the bullet have come from the hill? Well, Tracy, if you believe the state that the victim, that Gabriel, was in a stance other than standing when he was shot, the bullet could really have come from anywhere. What happened to the 6 liters of water ever found? They didn't find any evidence of that. Did Daniel take the bullet? Daniel was standing right behind him, according to his testimony, and was not struck. But he says he was prevented from being shot because the horse took the bullet for him. The horse, by the way, did not sustain any injuries. Daniel says the horse died. Another small detail that just didn't add up. It's a U visa, I think, says Ariel. Dee, this gets into some of the political side. We're trying not to get into the political side of immigration and the border. I realize it's woven through this case. But I think as far as I want to go to on this topic with this case is that we know Daniel has crossed over like 10 times and been caught every time. I don't know why he would have turned around and run. He just paid $2,500, which, let me just say, is a lot of money for someone in abject poverty in Mexico. It is a ton of money. He just paid $2,500 for the 10th time or 9th time if he carried drugs once for his fee. It just doesn't make sense that it's like as soon as they saw a Border Patrol truck, and this is like off in the distance, right? So they've got scouts. As soon as they saw a Border Patrol, group splits up. And these two, Gabriel and Daniel, who happened to have the radio, head back for Mexico. He gets a U visa after cooperating with prosecution. He can get permanent residency, which can lead to citizenship. Still on break here. We'll bring back as soon as it comes back from break. Sheriff said he went to Mexico to give his condolences, and the family said there was a witness. The sheriff didn't know that was the first time he went. Questionable, in my opinion. I think the sheriff is 100% a politician. We saw politician level answers out of him. I'm not saying which political side. That doesn't matter. We saw political type answers to his questions, which were dodging the question and avoiding the issue throughout his testimony. And it got spicy. Let's see. I live by a busy street. You're seeing cars go by. I think Daniel did it, said Corell. Sheriff was the most sus witness of all, and that is saying a lot. Red Pen, man, I agree. He was one of the sketchiest witnesses, in my opinion. Mathis, the problem I'm having is we tried to use Google Meets, and it gives away my personal phone number. I can't do that because it's not a burner phone. Cops see what they want to see. This is an interesting point because we do have what the defense is saying in their presentation over and over. They're saying, Mr. Kelly, the first time he says this, the second time he says this, the third time he says this, and what they are is those are reports from officers. And some of those officers arrived on the scene having heard already false information, whether from dispatch or from another officer who reported falsely and was proven on the stand that what they reported was not the actual fact. So they're given a set of facts as the scenario, as the backdrop for their investigation and their involvement on the scene. They're told that Mr. Kelly admits to shooting him. Or they've got that as their backdrop, and then they do their investigation. Of course, they're going to find things that support what they think is true, what they think is a given in the situation. And he's using those officers' statements in their reports as what Mr. Kelly said. They're twisting, they're convoluting some of the things according to the defense. And for me, even though they've got these statements that come from the police officers, I have a hard time believing it. It looks like we're back in court. Give me just 1 second. Let's come back to let's do 8, shall we?
Defense counsel, have you seen the proposed draft verdict form from the state?
I did, yes.
Okay, we don't have to talk about it. I just want to we'll talk about it later. Just want to make sure you have it.
The bullet will need to be found by a metal detectorist, and it could take many metal detectorists a lot of time to find it. After traveling through a body, it could still travel several hundred yards, and there's just a big area to search. I don't think there's any way Mr. Kelly could have found the bullet after shooting him.
He's right.
Braxton, you binge watched the trial. That's awesome. Congratulations on 2 months, by the way. We're returning to the state's closing arguments, which have been going for about 50 minutes, as soon as the jury's back in.
The record has shown the presence of all the jurors, counsel, and the defendant. And as soon as you're ready, Mr. Jenny, you can continue with your closing argument.
Thank you, Your Honor. We left off with speaking about Daniel, the second victim and the eyewitness. What happened? What Daniel is not part of a drug organization. He's not. He doesn't work for the cartel. He does not. 6th grade education. And he knew Gabriel for about a year. There's a picture of him in testimony. I'm talking about consistent statements. AK-47 shot. Red horse. He also nailed it on how the victim died. Clutching his chest, arm up. And that is the picture we see of Gabriel.
What?
They crossed. No weapons or drugs. No one in the group had weapons or drugs. No one. Returned to Mexico, and the shots were fired. These are 2 unarmed migrants heading back to Mexico. shots coming from the defendant's property. It tells you shots were coming from the right-hand side, and the horse is saving his life. Heard 8 to 10 shots. There were 9 shell casings found. Consistency. And he is scared. Being shot at with an AK-47 is serious. Seeing your friend die in front of you is serious. Grabbed his chest and said, "I'm hit." Agent Heredia, first on scene at 2:40. No people, no tracks, looking for the defendant. Remember, this was an active shooter response. Saw no rifles, no backpacks, no drugs. And the defendant was calm. Kelly said, when he met up with him, he said that 5 to 7 people were carrying bundles. He went from 5 people to 10 to 15, back down to 5 to 7. But never mentions, with Agent Heredia, never mentions he said he was shot at. Never mentions he was shot at. Never mentions he saw a weapon. Never mentions a weapon was pointed at him. He's calm. Never mentions he even fired that weapon. It's 10 minutes after this shootout event. Unreal. Miss Kelly saw 5 armed men. Kelly went after them, heard 4 shots. Those are the 4 shots, 4 of the 9 shots by the defendant. The defendant said, "This baby is always by the door." That's an AK-47, which is behind the bedroom door, hanging up on a coat rack behind a sweatshirt. That's the same AK-47 that he always keeps by the door. And he says they were possibly carrying rifles. Officer asked, did the armed men shoot at him? Didn't know what direction they shot. Justification instructions. There's a litany of those in your packet. You got one for use of physical force, one for self-defense, one for use of deadly physical force, defense of a third person, and defense of premises. That's your homework. I'm going to tell you, cheat sheet is always a reasonable person standard. So when you see 2 unarmed migrants walking southbound beyond 2 fence lines, and you take your AK-47, you walk out and don't say a word, point it at them, and you shoot, would that be what a reasonable person would do in that situation? The answer has to be no. The answer has to be no. No evidence of any armed gunmen. No one found on BP footage. No foot traffic. No other shell casings. And they used I think they used up to 3 metal detectors on 2 different days. No other shell casings found. No one heard the mysterious shot, the made-up shot the defendant now claims started this entire event. He has to give you something. They got to give you something to justify why he shoots 9 times at a migrant. He has to give you something. It gives you this, quote, mysterious shot that even his wife does not hear. No evidence of drugs, guns, a struggle, a robbery, anything. And when the cartel gets involved, they leave things messy. They also don't leave evidence. No evidence of any rip crew in the area. And you heard Agent Marcel on the stand. Not in the past 10 years. Not in the past 10 years. no justification for stepping on your patio with an AK-47, not giving a warning, and shooting 9 times at 2 men who are southbound away from your property. No justification at all. Reasonable doubt? You got jury instruction on that? I want to talk about is your common sense and experience. We're in this is a magical area we're in. This is what democracy is about, sitting in a jury, listening to a case, and determining the guilt and innocence of an individual. This is what our democracy is about. But you still use your common sense you use in everyday life.
What?
You still use it. I'm going to give you an analogy. I think the judge used the analogy for direct and circumstantial evidence with the rain outside. He told you if you didn't see it, you have no direct evidence of it. If you go outside, there's circumstantial evidence of rain. I want to use the same thing for reasonable doubt. We're sitting inside this courtroom, and you go outside, the facade's all wet, the pavement's all wet, people are carrying umbrellas. You were here all day long for the past 4 weeks, but you're here all day long. You don't hear it rain, you don't see it rain, you don't smell it rain, you don't smell anything. You don't smell the bushes and the wonderful odor, you don't smell any of that. However, is it beyond a reasonable doubt it rained? Yes. Is it possible that a truck came by, a fire truck came by and sprayed the facade and the ground? Yeah, it's possible. That's a ridiculous doubt. Use that same standard here. That same standard. There is no bandits out there threatening the defendant. None.
I like the fire truck spraying everything.
Facts again, Gabriel and Daniel were shot at. Gabriel is dead. Killed by a high-powered weapon, an AK-47. Entry wound, right side, exit wound, chest, lines up perfectly with defendant's property. We're calling the wheat from the chaff here. Defendant's words, inconsistent. Defendant's words actually were consistent with some of the physical evidence. Shot 9 times. Eventually he says he shot 9 times. And now we have show casings. Consistent there. And Daniel's words, always consistent with the physical evidence. Steps out, no verbal warning. Defendant shot his AK-47 9 times. Shell casings found. Ejection pattern consistent with what Brunel did on a test of that same weapon with the same rounds. Position and orientation of the body lines up with the defendant's home.
This guy is spinning
his
wheels in the
we'll
same
come back
circle.
second time and we'll find him guilty of secondary murder. But you also can decide if you're not satisfied with secondary murder, you can consider manslaughter. And if not satisfied with either secondary murder or manslaughter, you can consider negligent homicide. And find him guilty for aggravated assault with a deadly weapon against Daniel. I'm going to leave you with this. Detective Ianza says in the interview, the moral of the story is you shot and someone is dead. And his answer is yes. That's all I have.
So clearly, who needs evidence? Finishes 59 minutes. Preserving 30 minutes for the rebuttal.
Good morning.
Good morning, Ms. Larkin.
I'm the quiet one. Can you hear me? Okay. If I speak too quietly, just wave at me and I will do something about that, all right? So I just want to start off by telling you this about this case. And it's first in your jury instructions when you go back to review them. They're going to tell you don't guess. You're not supposed to make guesses about what happened in this case, and you're not even supposed to solve the mystery or discover all of the facts that were left out of this case. Don't guess. We have this very high standard in criminal cases. The standard here is proof beyond a reasonable doubt. Not is this questionable, not is this suspicious, not even is this likely, Not even is this really darned likely. The standard is proof beyond a reasonable doubt. And I'm going to come back to that standard, but we have that standard for a reason. This is the most serious type of courtroom that we ever get in any kind of case in this country, is a criminal case. And for the most serious type of courtroom, we have the most serious standard of proof. And it's your job as jurors to hold the government to that standard of proof. We don't guess when we're dealing with criminal law. We don't guess when we're dealing with criminal charges. So please don't guess. I'm going to ask you to assess the facts of this case. We have two competing versions of events in this case. We have the state's idea, and the state says that Mr. Kelly walks out of his house one day with no provocation whatsoever. He takes aim at a great distance at people who are unarmed on his property, and he fires shots intending to hit those people. That's their version of events. Mr. Kelly and his wife tell something very, very different. And I'm going to talk about what they say happened here, but I want you to ask yourselves while I'm going through that, is what Mr. Kelly and his wife says consistent with the facts, the known facts of this case, the known evidence that has been presented to you? Not, is this consistent with somebody's subjective interpretation of somebody else's words? Those aren't facts, those are guesses. I want to ask you if what Mr. Kelly said happened is consistent with the facts. And it is. The evidence has showed that Mr. Kelly comes from Montana with his wife, and they eventually settle here, and they begin ranching. The evidence showed you in this case that they had a long time on this ranch before anything, happened. They've been here for decades. They are locals at this point. We heard from Wanda about the increased activity that took place on their property that we talked about in the opening statement. Wanda testified to that. You heard from Mr. Kelly about different instances where he was shot at. When he was interviewed by Detective Ainsa, he described those instances. We heard from Gary Wisdom, one of Mr. Kelly's neighbors who's in that same area, the same thing. When he originally started ranching there, he saw small family groups and didn't feel any danger. Gary Wisdom later says, eventually I started seeing bigger groups of men carrying weapons. And he called Border Patrol to report that at times. Border Patrol came out. He has no idea if they ever caught them or not. We heard from Border Patrol that this is a high trafficked area. There's a lot that comes through here. It's just north of that area where the wall ends. There are people who come through. There are drugs. There are vehicles. We heard from Border Patrol that it's impossible to distinguish nowadays really who's carrying drugs and who are just groups of migrants, because the drugs have gotten smaller as time has gone on. We have heard from Border Patrol that there are things that exist called rip crews. There are bandits. There are people who will rob migrant groups, who will kidnap migrants, who will steal drugs, and who will get into violent altercations with other people who are engaged in criminal activity in this area. That's not Mr. Kelly's imagination. That's what you heard from Border Patrol, who are out there every day on the ground dealing with what goes on out there. Border Patrol also talked about how there are a lot of unknowns. We know the cameras are not that effective. We know people know where to avoid detection. They know how to avoid detection. They know where our cameras are. So there's a lot that goes on that goes unseen and unknown by Border Patrol. They see signs of it, they know it's out there, but they're not able to respond, and they're not able to make apprehensions all the time. And this is what's going on in Mr. Kelly's life during the lead up to this incident on January 30th. The state talks about text messages that Mr. Kelly sends between himself and his friend, Gary Miller, a very close friend who he's known for a very long time. This is somebody who Mr. Kelly trusts and who understands where Mr. Kelly's coming from. Those messages come in that context. Those messages also come in the context of Mr. Kelly receiving continuously information from Jeremy Morcell, the Border Patrol Ranch Liaison. Jeremy Morcell is continuously communicating with Mr. Kelly about large groups on his property. They're nearby. Be careful. We're working a group of this size. It's in your area. It might come your way. They might be carrying narcotics. Narcotics trafficking has picked up around Keno Springs. This is the communication that Mr. Kelly is receiving on a regular basis from Border Patrol. Border Patrol knows what they're talking about. Mr. Kelly relies on that information. The level of fear and concern that Mr. Kelly experiences on his own property is increasing as a result. He chooses to arm himself in case he ever has to defend himself. And he expresses that to his friend, Gary Miller. He talks about the fear. He talks about what's happening on his property. He does it in an over-exaggerated way to help him blow off some steam, to help him feel a little bit better, and to help assuage some of the concerns that he has, because he never knows when something is going to happen. And ultimately, something does happen on January 30th of 2023. Mr. Kelly is in his kitchen eating lunch. It's a day like any other. He's been out about on his ranch. He's planning to do some more chores for the rest of the day. He has no idea that he's about to be in a life or death situation. He doesn't ask for it. He's minding his own business in his own house. When suddenly he sees something. He sees people carrying rifles, carrying backpacks out the kitchen window. He does the right thing. He calls law enforcement. He is not some sort of vigilante who decides he's going to take matters completely into his own hands. He calls for help. He calls the guy who has the badge and the gun. He calls Jeremy Morcell. And he tells him, I hear a shot or something's shooting. I might have to return fire. Immediately, he tells law enforcement that he may have to fire. When he's walking outside, he has heard a shot. This is not a mystery shot, as the state describes. This is a real shot. Mr. Kelly hears it, and the whole situation completely changes in that moment. A gunshot outside of your home is not something you hear every day. And it's not something you hear in the same context with people running with rifles and backpacks across your property. This is a frightening, scary situation. And in frightening, scary situations, people flee, people freeze, or people act. And Mr. Kelly acted. He is being confronted on his own property, in his own house, with criminal activity involving guns in his yard. And he doesn't know what's going to happen next. He knows he needs help, so he calls Border Patrol. But he doesn't know how long it's going to take them to get there. And he doesn't know what these people are going to do in the meantime. The state would have you believe that you have to stay in your house in a situation like that. You do not. The law does not require that you stay inside of your house. In fact, that is not the smart thing to do. Mr. Kelly, when he walks outside with his rifle, his intention is to stop this threat. His intention is to make these people go away. Because if you stay inside your house, you don't know what they are going to do. They're going this direction right now, but after you lose sight of them, who knows where they're going to go? Who knows what they're going to do? This isn't a conscious thought process that Mr. Kelly went through at this time either. This was a split-second decision. He sees a threat, he responds to the threat. Mr. Kelly is the man of his house. His wife is there. He needs to protect himself, and he needs to protect his wife, just like every man should do. And he is 100% justified in walking outside to meet this threat. When he walks outside, he sees people. He sees that they are carrying rifles. He walks out onto his porch. The metal door bangs behind him. It makes a noise. The person in front looks at him and points his rifle at him. Mr. Kelly tells this to Detective Einstein. He points his rifle at me. Under those circumstances, Mr. Kelly is 100% justified in firing his weapon at that person. He doesn't need to fire warning shots. He is justified in firing at that person in that moment. Again, split-second decision. Mr. Kelly doesn't think, now I'm going to fire some warning shots in the hopes that I will have to avoid doing something else. There is no thought process. This is an immediate life or death scenario. It's an immediate decision that Mr. Kelly makes, and he chooses to not take that shot. He chooses not to fire at that person. Instead, he raises his rifle up above the tree in front of him. And you all have seen the tree. You've been to the patio. You know what this looks like. He raises it up. He fires warning shots. The state said he could have emptied this magazine. He doesn't. He stops shooting because these people start to run away. He has some more conversations with Agent Morcell about this. These folks are going somewhere. They're gone. The threat is over. He goes out to check on his barn, and he encounters Border Patrol. He has already told Agent Morcell that he was going to fire shots. As far as Mr. Kelly knows, Agent Morcell has passed on that information to everybody else who's responding. He is not required to tell every single law enforcement member every single thing that happened to him that day. He assumes that they already know because he already reported it, and that is why they're there. During this encounter, sheriff's deputies have some communication with Mr. Kelly. They have some communication with Alan, Mr. Kelly, and they start to search this area east of the house. You heard testimony from these deputies. They're searching this area east of the house. Border Patrol is traveling south. Everybody says, we're looking for Mr. Kelly. And Wanda said that he went south. And yet, the sheriff's department are searching east of the house. Why are they searching east of the house? They say they're just looking for Mr. Kelly. It's because Wanda told them this is where we saw those people. And so they're searching east of the house to try to find evidence of the folks who Mr. and Mrs. Kelly described. They comb through that area. They go over the two fences. They spread out. They're looking for people. They're looking for weapons. They're looking for people who might be injured or who might be hiding. And they don't find anybody. They don't find anybody. Ultimately, they come back and they talk to Mr. Kelly and his wife. And Mr. Kelly and his wife say, this is the area where we saw people. Mr. Kelly tells them, I heard a shot. He hears a shot and he sees people running with backpacks and rifles. And law enforcement chooses not to go and look again. They don't think it's important. They don't think it's worth it to try to go see if they can find something else now that they have more information. They don't sit down with Mrs. Kelly. They don't tell her, slow down a minute, let's walk through this one step at a time. Tell me what you saw, tell me what you did, tell me where you were. They don't do that with Mr. Kelly either. They don't bother to slow down and get the information. They describe Wanda as being upset. Castañeda, Deputy Castañeda, who talked to Wanda, said she seemed upset, she seemed confused. She was distraught by what was happening. And yet, nobody took the time to ask her to take a breath, to slow down. Let's talk through this. Same thing with Mr. Kelly. He's just had this encounter. Imagine you're sitting in your kitchen and you hear a shot and you see what's happening and all this happens. Your adrenaline goes up. Your whole body is on alert when something like this happens. And when law enforcement gets there, it's still sort of coming down. It's still kind of washing out of you. Under those circumstances, people can't be expected. People who are victims of crimes, like Mr. and Mrs. Kelly were that day, they can't be expected to fully and clearly, from beginning to end, articulate to law enforcement exactly what happened. Law enforcement is trained to deal with that. Law enforcement should recognize that and talk to someone. Talk me through it slowly. That's all they had to do. Nobody did that. And now the fact that Mr. Kelly made some omissions because he's in that state of fear and agitation and adrenaline and excitement, that's being held against him. And that shouldn't be held against him. That should be held against the officers who didn't properly recognize the situation, who didn't ask questions of witnesses. You heard the state argue this was an emergency call, lights and sirens, active shooter. Law enforcement was on high alert when they came to the scene. They had their rifles out. And yet they failed to recognize that Mr. and Mrs. Kelly might be in a state of emotional agitation, to put it mildly. They don't recognize that. They don't do a slow walk through of the information. They don't take their time. They don't even go do another search. And now we are left with questions. We do not know if Gabriel Cuen Buitimea's body was there when law enforcement arrived. It's a question that's outstanding. We don't know the answer to it, and now we never will. Ultimately, law enforcement leaves, and later in the evening, Alan finds this body on his property. This is the second time this day that things have gone from normal and regular to high anxiety, high stress, extreme situation happening here. I've never discovered a dead body on my property. You folks probably haven't either. But who's to say how any of us is going to react when we come upon something like that? How are we supposed to feel? What are we supposed to think? What is an appropriate response to finding a dead person on your property? And imagine what must be going through this man's head. He knows what happened earlier. He knows what he saw. He knows what he did. He knows he fired shots up over the tree in front of his patio, and now he's stumbling upon a person. And he doesn't know what happened. He's a smart man, and he can put two and two together. And any intelligent person who's in his situation, imagine being in a situation where you fired shots and you know you didn't shoot this person, but you know you fired shots. That is scary. Anybody in Alan's shoes is going to be thinking, oh my Lord, what are they going to think when I call this in? It's a terrifying scenario for Alan. What would a guilty person do? What would someone do who's come across this body and who thinks, I probably shot this guy? What would a guilty person do in Alan's shoes? Someone with a huge, expansive property, someone who knows law enforcement was already here and they left, someone who knows that's where I was standing when I fired these shots. A guilty person had every opportunity to cover this up, and he would have been able to do so effectively. He could have disposed of the weapon. He could have picked up the shell casings. He even could have disposed of the body on this property. He didn't even need to do that. He could have just picked up the weapon, hid it, buried it somewhere, buried the shell casing somewhere, and never made a phone call and just left on a trip for a while. That's all he had to do. That's all a guilty person had to do. That's not what Alan did. Alan, even though he's standing there and even though he knows this looks bad, I don't know what's going to happen, he does the right thing. And he does the right thing because it's the right thing. You can tell when he's having these phone calls. In the state, they pull up some excerpts and they read them in their tone of voice. I encourage you to review these phone calls and listen to Alan's tone of voice. Listen to his demeanor. Hear what he's saying. Is this a person who knows that he's guilty and is trying to cover things up, but nevertheless is calling law enforcement, which is what the state wants you to think? Or is this a person who is completely scared and shell-shocked because he knows he didn't do this, but he knows that calling it in is the right thing to do? And he trusts that law enforcement is going to do the right thing. He trusts that they are going to listen to him. And so he calls it in. He calls the Border Patrol, the guy with the badge and the gun, the guy who he called earlier, the same guy who sent all the deputies out earlier and who sent Border Patrol out earlier. There's no possibility that Alan thinks the Border Patrol is going to sweep this under the rug. No possibility whatsoever that he thinks that. He's still in a distraught state. He still doesn't know how he feels. He's still communicating in a vague way to Agent Morcell because he is in shock. What's the appropriate response when you find a dead body on your property? Can anyone say, here's how you're supposed to act, and if you act differently, then that's wrong? People act in all sorts of ways when confronted with shocking and frightening scenarios. And Alan couldn't form the words. He called for help and he tried. He tried to communicate what he was finding, and he did. You cannot listen to these phone calls with, well, there aren't phone calls recorded with Border Patrol, unfortunately. You can't listen to the phone call that Alan has with the Sheriff's Department and conclude that he's not communicating that there is a dead body on his property. He makes it very clear with the words that he can call to mind in that moment, which is a terrible moment for Mr. Kelly. There's a lot made about the phrase animal, or the use of the word animal. Agent Morcell testified that he used that word first. He asked Mr. Kelly, what is it, Mr. Kelly? You're not telling me what's going on. Is there an animal? And Mr. Kelly responded to him and said, well, as opposed to a vegetable or a mineral, if you know what I mean, he's clear. He's making himself clear. And then he does the same thing when he's on the phone call with the Sheriff's Department. Something that else goes to Mr. Kelly's mind when he's talking with the Sheriff's Department is the Sheriff's Department dispatcher tells him, you said you shot something. The dispatcher tells that to Mr. Kelly when he has never said anything like that. Again, imagine, how must somebody feel knowing I fired shots earlier, I know I didn't hit this person, here's a dead body, oh, I'm afraid to call this in, but I have to call it in. And then when dispatch talks to him, dispatch says, you said you shot something. That is terrifying. That is a terrifying mistake that dispatch made, and it's terrifying for Alan to hear that. That's all in his mind when law enforcement is responding to his property. That's also all in the minds of all of the law enforcement personnel who are going to this property. They are being told incorrectly that Alan stated he struck something or he shot something when Alan never made that statement. And it's nobody's fault. Alan's on the phone with Agent Morcell. Agent Morcell is on the phone with Agent Tercy. Agent Tercy is relaying that to Agent Layugan. Agent Layugan is relaying that out to the Sheriff's Department. So you have all of these layers of telephone. And of course, things get lost in translation. It's not necessarily anybody's fault, but it is a crucial, crucial defining factor in this case. The investigators go out there already believing that this guy has confessed. They already have their suspect before they arrive at the scene. When they're at the scene, Lopez, the first person who comes out, he talks to Alan. He finally records a conversation. And his recording shows that his report was wrong. This is a theme that comes up repeatedly in this case. Law enforcement documents statements, especially Alan's statements, especially Wanda's statements, incorrectly. We have 2 reports from the first call from 2 different officers who both at the same time talked to Mrs. Kelly. And they both say that she said 2 completely different things. None of these conversations are recorded. Documentation is unreliable. The conversations between Mr. Kelly and Agent Morcell, not recorded, unreliable documentation. Finally, when we have a recording, it's Lopez, first person on the scene. He records him. And Lopez documents that conversation incorrectly in his report as well. According to Lopez's report, he says to Mr. Kelly, "Do you know if you shot him?" And Mr. Kelly says, "I have no idea." That sounds pretty bad. Sounds like Mr. Kelly's admitting he might have shot this person. That is not what Mr. Kelly said. When you listen to Lopez's recording, the recording says, "Do you know who shot him?" And Mr. Kelly says, "I have no idea." Very, very different. The documentation of the statements made in this case is really concerning to anybody who's worried about law enforcement being objective. You have Omar Rodriguez, who gets out and stands near the body. He's looking at the body. He's got this in his mind, and he speculates about the angle of the shot, the same way that you heard the state speculate in their argument to you about the angle of the shot. He says this shot comes in here, goes out here, there's the house over there, aha! The shot must have come from there. That's not what any of the experts say. The experts say you have no idea, based on this evidence, where this shot came from. And we're going to get to them in a minute. But the initial investigators feel very free to speculate. You have Sergeant Flores, who takes photographs of the body. There's no note that the backpack is unzipped. Nobody raises that as an issue in any reports. Nobody raises the issue about how the backpack's pulled up over this person's head. Nobody raises the issue about how the fanny pack buckle is broken and the fanny pack is lying next to this person. There are photographs, we can see those things, but nobody seemed concerned about that. Nobody seemed to think maybe there are other crimes that have taken place here besides the obvious crime of this person's been shot. Nobody ever considered that there was any other evidence of any other crimes. Sergeant Flores on the stand specifically said, "No, I didn't see any evidence of any crime. None." Amazing. It's amazing. Think more about the emotional aspect of this. These are human beings. Alan's a human being, Wanda's a human being. We're not robots. We all react differently in different situations. Alan's on scene. Nobody's talked to him. Still, nobody's asked him, walk me through what happened. Show me where you were. Nobody does that. And then they put handcuffs on him. And they put him into a police car. Imagine what he must be thinking in that moment. Imagine just that feeling of oh my gosh, this is really real now. They're taking me away in handcuffs from my house. I don't know if I'm coming back. That's an unbelievable moment for anybody to have to go through. Imagine Wanda. She's been sitting in the back of a police car. They don't ask her what happened. They don't walk her through the scene. They don't ask her anything. They put her in the back of a police car. Wanda, a person who has obviously never done anything wrong, who's obviously the victim of a crime. They put her in a police car. They take her to the station. That's an arrest. They arrest Wanda. They don't have any reason to do that. And right before they drive away with her, she sees her husband walking past the car in handcuffs. How does she feel when she's being taken to this interview? How does Alan feel when he's being taken to this interview? Would it be reasonable to be scared? Of course it would be. Would it be reasonable to be really concerned now? Maybe I don't really trust these investigators. I'm in handcuffs when I called them. That's a big concern. This is what's going on emotionally when Alan and Wanda are interviewed by law enforcement. And again, there's no slow walkthrough. There's no show me on a map where this is. What did you do? Describe this to me. Wait, let me back you up a little bit. Tell me more about this. They don't do any of that. There's browbeating. There's tactics used to try to scare this man into confessing. Detective Einsa tells him, you shot this person. That's pretty scary, especially if you know you didn't shoot this person. There's, we're going to find that rifle and we're going to do ballistics. By the way, what's Alan's response to that? He says, you don't need a search warrant. I will show you where the rifle is. I will show you where the rifle is. This rifle that's supposedly not in its proper place, according to these guys. Alan says, I will show you where this rifle is. Detective Einsa says, no. Fair enough. Okay? Then we get to significant issues of words being changed. And this starts with Alan. He's in this interview with Detective Einsa, and watch it. Don't pick out a line here or there. Watch it. You have the whole interview. Look at the whole thing beginning to end. Listen to the context. Listen to the tone of voice, the body language. It's a whole. Don't pick out a line and decide what it says. Watch it. Repeatedly, Detective Einsa says, you shot this person. You shot at these people. Alan says, no, I never did that. The state talked about a part in that interview where he was asked, did you shoot? And he doesn't answer. Watch the interview. Detective Barba asks him, did you shoot? Alan pauses, and then Detective Einsa jumps in with a different question, and Alan answers that question. He never denies having shot his rifle, ever. He's asked, he says, yes, I shot this rifle. I shot it up. I shot it over. Detective Einsa says, at, over, same thing. Alan says, no, it's not the same thing. It's a different thing. And there's back and forth about that a lot. Alan obviously thinks at and over are two different things. Alan also repeatedly says, I never chased anybody. I never went after anybody. I don't know where you're getting that. Watch the interview. It's there. In spite of this, law enforcement essentially fabricates a confession. They write down on the booking form. That booking form is their statement of probable cause. Here's what happened. Subject, he was chasing people. He shot. He admitted he shot at multiple subjects. That was not true. Alan never said that. Law enforcement wasn't listening, and they didn't care. They already decided that he was guilty, and they were perfectly fine inventing words for him. Words that were the opposite of what he said and putting those down as if he said them. There's a lot made about Wanda. The treatment of Wanda in this case was just disgraceful. They're trying to say that she's lying to protect her husband. She said 5 and then she said 2. They come up with these extremely nitpicked, not recorded, supposed inconsistent statements to say that she's lying. I would just submit to you that if Wanda were lying about what happened in this case, all she would have to do would be to say, I saw these guys, he pointed a rifle at my husband. That's all she would have to say. She didn't say that because she didn't see. But if she wanted to lie about something to protect Alan, very easy for her to do. That's all she would have to say, and nobody could contradict her. She didn't do it. So confirmation bias is a big thing that runs through this case, and it's the tendency to interpret new information and new evidence to confirm pre-existing beliefs and conclusions. And that plays a very big role in this case too. They do this interview with Alan, they don't listen to the words he says, they make up new words, and they arrest him. They don't wait until they can do ballistics. They don't wait until maybe they can find some witnesses. They don't wait until they can do forensic testing or any drone footage or anything. They don't wait, they just go straight for this guy. And every single thing that they do after that, they design to confirm the decision that they've already made. It's natural. Human beings, we like to confirm that we're right. It's really uncomfortable to say I might have made a mistake, maybe I was wrong. And so when they get a phone call from somebody calling himself Miguel, who says he's related to the family, they don't question it. And then when it turns out that that's false, well, oh well. They're not concerned that people are coming forward making false statements about this case, even though apparently they've talked about it, I don't know. But it doesn't bother them. Then there's this person, Ramon, and he says something different. He comes forward under different circumstances too. Does anybody bother to analyze his statements? Does anybody bother to compare his statements against Miguel's statements or Mr. Kelly's statements? Does anybody bother to compare Ramon's statements to the physical evidence in this case? No, of course not. They don't need to. They have their guy. They have their conclusion. Then we get to Daniel. The state says he makes consistent statements. And remember, if you're inconsistent, that means you might be lying about something. Well, Daniel doesn't even tell investigators what his name is in this case. He comes forward under very suspicious circumstances. He comes forward after this has all been out, after they know that Mr. Kelly's been arrested. His picture's been all over the place. Their version of events is out there for anyone to read, for anybody to think about, for anybody to make something up about. And here comes Daniel. And he lies about his name because he doesn't want to get deported back to Honduras. And he lies about his criminal history. He's asked, have you ever smuggled drugs in the United States? He says no. That is not true. He's telling a lie. The state says he's not associated with any criminal organization. He's not a drug smuggler. Daniel says, I'm not a drug smuggler. Well, except for when he is, because he took a plea in federal court under oath to smuggling drugs. Lied about his name to federal court also, by the way. You hear from law enforcement that you can't just accept a statement as the truth just because it's a statement. You have to test its credibility. You have to see if it matches up with other statements, with physical evidence, with known facts of the case, with forensic evidence. And that's how you can assess the reliability of a witness statement. I'm not going to get the whiteboard out again. You guys have seen me do it already, but you've got a body found 115 yards east of Mr. Kelly's house. You've got that body lying face down. You've got Daniel stating, we were 10 meters away from the house. We were to the west of the house. We were facing the border wall. Border wall is 2 football fields away. The shots were coming from over there, away from the house. That is impossible to believe. It could not have happened that way. We know for a fact, we're not guessing, we know for a fact that it did not happen the way that Daniel said that it happened. We know for a fact that Daniel previously told investigators he was 15 meters away from the border wall when this happened. We know that for a fact. State says he's consistent. How is that consistent? It's not. We know for a fact that Daniel claims he gets right up to that road that goes by the border wall where the pines are. I look back, I saw the person. We know that for a fact. We know that that is impossible. You all have been out there. You know what the end of the wall looks like. You know what this road looks like. That is impossible. We are not guessing about that. That is a fact. We know that the body's not on the west side of the house. Fact. We know that the body is not 10 yards away from the house. Fact. We know that there is no Border Patrol road that goes through this property that goes directly to the end of the wall, like Daniel said it did. Fact. We know he is wrong. What does that mean? It means he wasn't there. It means he is telling a story. Why? We don't know. But you can't be there and get it this wrong. It is not possible. I don't care if you have a 6th grade education. My kid has a 3rd grade education, and she can describe a place. It's not that hard. Nobody questions this either. Forget what Daniel says for a minute and how obviously false and concerning that is. What is wrong with the investigators in this case? Raul Rodriguez interviews Daniel, and he says things that Raul Rodriguez, Detective Rodriguez, admits these are not making sense. Instead of pursuing that, for example, he says this took place west of Nogales. No, it didn't. We know that for a fact. It took place east of Nogales. Instead of pursuing that as a possible problem, as a possible, maybe this person's not so credible, maybe they have another motive for coming forward, law enforcement doesn't bother asking any questions. Instead, they provide explanations. They provide help. They provide suggestion. They say, well, are you sure you were that close? That sounds pretty close. Are you sure? Well, maybe you don't know because you were running and maybe you were scared and so you didn't really know where you were, right? They make suggestive statements to this witness in an interview when really they should be suspicious about this and they should do some detective work to find out what the truth is. Not to bolster what they've already decided they want the truth to be. That's not how an investigation should work. And let's remember, Daniel first comes forward because the sheriff goes into...
Oh no, we're getting some feed cutouts. Let me check. Both feeds are frozen. It's frozen from the courtroom, guys.
Why is the sheriff going into Mexico? Why? He doesn't wear a uniform because if you wear your uniform in Mexico, they get picky about that. That's what he said. It's quite the euphemism.
She's used 45 minutes of her time.
And then they don't record this interview, and then they record part of it, and they've got no good reason for why they did that. That is sketchy. And that sets the tone for this whole investigation. So that's some of the facts, that's some of the evidence that you've heard from this witness. Let's talk about the forensics. The medical examiner's report essentially says there's no way to determine the time of death. This is a very significant fact in this case. What was the time of death? Because if his body wasn't there when the sheriff's department searched this area, then Alan has nothing to do with this. We have evidence that Omar Rodriguez examined the body. He says the torso is still warm. This is significant information. He could have passed that on to a medical examiner to get some sort of scientific determination of time of death. Didn't do that. They put the body in a cooler. They destroy any possibility of accurately determining a time of death scientifically. And the medical examiner's report proves that a gunshot wound is the cause of death. It doesn't prove which gun, doesn't prove which type of gun, doesn't prove which type of ammunition, doesn't prove even long gun or handgun, doesn't prove anything other than gunshot wound. Okay, great. The ballistics. Let's talk about that. See what can be proved in this case, what they did prove forensically. They talk about this as a long-range shot. I recall the ballistics experts testifying that what that means is this shot was fired from a distance of 6 feet away or further. That's a long-range shot. So they've proven that this shot was taken from 6 feet away or further. Anything in between is a guess, and we are not supposed to guess. The ballistics, obviously there's no bullet, so they can't prove which weapon this came from. They can't prove which type of weapon this came from. They can't prove, again, which type of ammunition this came from. The shell casings, we heard testimony about shell casings that are found on the patio. They can't prove which direction the shooter was pointing. You make a circle around the shell casings. The shooter could be standing anywhere in that circle. They can't prove if the shooter was pointing straight or up or something else. Interestingly, the ballistics experts testified that had they known, had they been told that there was a possibility that this rifle was shot in an upward direction, they could have done testing on the shell casing pattern. And they might have been able to come to a conclusion about that. Yes, it was pointing up, or no, or it's inconclusive. But they didn't do the test because they were never asked to by the state. The investigators in this case never tested their own theory. They never considered that what Alan said might actually be supported by some evidence, and maybe we should look for that evidence too, not just evidence that shows that he's guilty. They didn't do that. And now we'll never know. Imagine if this were a sexual assault case and there was DNA of the perpetrator involved, and the investigators said, well, we could test that DNA, but it'll probably be inconclusive, so we're not going to test it. That's outrageous. That is outrageous. We have a right to expect that people who are investigating people for serious crimes are going to examine and test every piece of evidence that they can, even if it might not tell them something. What if it could? What if they did that test? What if it showed that an expert could say this rifle was pointed in an upward direction? It could do that. We would want to know that, wouldn't we? Before we decide what happened in this case. They didn't do it. The ballistics also, you've got this field of obstacles in between the porch and where this body is eventually located. You've seen the photographs, you've been to the scene, you know how many things are in between there. What I didn't hear the state address is the problem of the point of aim and the point of impact for this rifle. I'm not going to rehash all of that, but ballistics experts said that if that entry wound, and this is assuming the person's just standing there, we have no idea where this person was when he was shot. The ballistics experts testified that they could not possibly determine that based on the evidence that they saw. But the point of impact on this person was about 4 feet off the ground, which according to the experts means Alan would have to been aiming, if he took the shot, at a spot that's about 3 feet off the ground, which means he's aiming down. And you saw everything that was in the way. You saw the smoker, the pergola, the patio, the table and the chairs that's on there that's made out of cement. If he were firing in that manner, there would be evidence. The fact that there's no evidence of any bullet impacting anything in that entire field
is evidence that supports what Alan said happened. If he fired where he said he fired, of course you don't expect to see bullet evidence in that field of obstacles, and you don't. The physical ballistics evidence is consistent with what Mr. Kelly said happened in this case.
Ms. Larkin?
Yes.
It's about 5 to noon. I think it's appropriate. It looks like you moving into a new area, so it's a good time to break. We'll take our noon recess.
The city of New York waiting breathless.
Sorry, we got some commercials coming in. Let's come in over
Jury
here.
room at 1:30, at which time the defense will continue with its closing argument. We're on recess until 1:30 in the afternoon.
So we're in recess till 1:30, which means we get a lunch. We have to take a lunch because the court is taking a lunch. Miss Larkin is 51 minutes in to her 90 minutes of time. 51 minutes into 90. So they get a recess every hour and a half. Pretty much what happens is they start late. They take a break halfway to lunch. They take a lunch break. They take a break halfway to dinner, and then they take a dinner break. Well, the end of the day break. That's what they're going to do. As far as presentation goes, I realize we've got people on both sides of the fence here, and that's great. I appreciate that. Thanks for sharing your opinions respectfully in chat and discussing things like adults, like the adults we are. I appreciate that. When it comes to defense case, I think all of us can probably agree that her delivery style on defense is pretty smooth, that it's pretty logical, it's pretty easy to follow. So that is something that might benefit her, the jury, if she's keeping pace with them. She doesn't have any visuals. She has chosen not to use the whiteboard. She doesn't have a PowerPoint projection going behind her, and she's not. It doesn't sound like she's reading PowerPoint points. Great storytelling. She's doing a great job. So it's good. It should benefit the jury. I think it will help. Obviously, this is not evidence. This shouldn't go into the consideration for the jury to determine what is true and what they should believe and what they don't. But it does help to sort of put all the pieces together.
People do not get to have it their way.
Nobody gets to have it their way. Pauline says, I believe Mr. Kelly did not mean to kill, and so why put an old man in jail, leaving his wife behind? It's not going to bring back Gabriel. May he rest in much love and peace. Pauline, great point. If I'm going to read something into this, it sounds to me like you believe that Mr. Kelly shot Gabriel, whether intentionally or not. If he did, here's my question to you. If he did, do you feel that he would have justification in shooting in this scenario based on the other information we have? And I guess this means you have to believe Mr. Kelly and Mrs. Kelly that there were multiple people and they had firearms. There was another shot and that he was defending himself. Do you feel that even if he did shoot him in self-defense, that he was justified? Even if he didn't knowingly shoot him? Interesting question. I'm not sure if you thought that one through or what your thoughts would be on that. Let's see. I'm ready for lunch. It's been we've been live here for 6 hours and 27 minutes. So we're going to go ahead and take a break. I know, Mathis, I know you want to call, and I'm trying to figure out how to do that. We do have the something on my face, like a little hair or something that's bugging me. We do have, sorry, I have no filter. We do have the burner phone as an option. I realize that's a very expensive option. I can't figure out Discord yet. I can't get the audio to work properly to make that work. So Lee says I ate 3 hours ago. What's lunches for the week? I didn't eat breakfast. I had zero breakfast, so I'm a little bit hungry this morning. I slept in. That's my fault. So let's see. Over on the Daybell side, we're at 4 hours and 30 minutes. I think they are still at lunch, right? I think they're at lunch. So we're going to head and wrap up. Now tell me when I can show you the huge thing I noticed, Mathis. Okay, so let's do it now. Mathis, do you want to call? Yeah, I know. I'm past the 6 hour limit. 1 second past is too much. So we're past. We are what we are. It just means I can't make any edits if I have to remove something. So sometimes I might have to delete a whole video, but I don't think we had anything. I think there was some some images from the medical examiners that was a little bit more than we saw during trial, but it wasn't. I think there was one image of him on the ground as well. Yeah, there was some stuff. Hopefully, it doesn't ding us too badly. Let's see. Where's the burner phone? Is it working? Not seeing any calls coming in. Is it? Can't use that one. Buffer. I'm missing it here, Mathis. I don't think the burner's working. I might have to check and see if it's turned on. Settings. Incoming calls. Oh, there we go. Helps if I turn on the burner phone. Try that one now. Amber's calling. Amber, I hear you, and I hear me in the background.
I just turned it down. I just wanted to make sure it was working.
I
Troubleshooting.
just turned it on. So we'll give Mathis a quick second, and then we're going to go take lunch. Is that cool?
Yep.
All right. We'll see you.
Yep.
Bye. Okay, burner phone's on just for Mathis. If we give him a minute, and remember, he's paying like £5 a minute. What is it in German? German marks? 5 marks a minute? I don't know what it is. Euros? Mathis, I have no idea what the currency is in Germany right now. It's expensive. Okay, here we go. And there he is.
Call from
Mattis.
Hello, Mathis. How are you doing? I'll let you talk fast because I know you're paying dearly for this.
So I don't know the correct timestamp, but if you look at the Zoom feed's timestamp, at 1 hour, 28 minutes, 44 seconds, that's timestamp shown on the Zoom feed. The judge cites a Supreme Court ruling that I think overturns the Crumbly case.
Ooh, give me what day was that? This is day 15?
In this very stream, whatever.
So day 15 is what we watched on Zoom today. And give me the timestamp again, 1 hour.
In the Zoom feed, it says the current time is 1 hour, 28 minutes. So it says April 17.
Okay.
1 hour, 28 minutes. 1 hour, 28 minutes, 45 seconds, PM.
That works. That's
not
PM.
necessarily the Zoom feed.
So he cites, now, did you look up the Supreme Court ruling? Was it Arizona Supreme Court
read it.
Or the U.S. Supreme Court?
Yeah, that's a U.S. Supreme Court opinion from 2004, written by Scalia.
Okay.
So the key thing is, we all know, we have watching up trials that we know about hearsay. There's hearsay exceptions. Did you know what testimonial hearsay is?
Testimonial hearsay. That's some of the stuff that was ruled out right at the end when the judge was citing this, saying that that even though the hearsay might come around, it might be admissible through one of the hearsay objections. In this case, he kept it out because of the Sixth Amendment to the Constitution, the right to confront your accusers.
Yeah. So there are times when you can admit hearsay when someone is not available for cross-examination, and that's when the hearsay is not testimonial. Testimonial, something that's not testimonial is, I just went to the store and I bought whatever. Do we know what testimonial hearsay is? Because I did not know this.
What's your definition? What do you have?
Testimonial hearsay is basically that a statement that makes you think, that sounds like trial testimony. One of the definitions is a reasonable person would think that sounds something you would use at a trial. For example, anything you tell to the police. But another thing is, he's shooting at us, he's killing me. Because that's something you would use at a trial.
Mm-hmm. I think we get into trouble when we have any sort of test that has to be reasonable person. Because I think we
Correct.
can all agree that the only reasonable person we know is ourselves, right?
Correct.
And we all come to very different conclusions. And so when we tell somebody, or we tell the jury, and like we're doing here, like the judge did, this is a reasonable person would conclude this. Basically, it's do you agree? Do you agree with what he did?
So the reason why he ruled out that particular stuff was those were police interviews. You would think, and a reasonable person would think, oh, you told this to police? That sounds like something you would use. Then those statements sound like something you would that would be used at a trial. So therefore it's testimonial. So therefore you can't introduce this hearsay, even when there is a hearsay exception, unless that witness is available for cross.
And hearsay is anything that was said outside of court. I mean, you could have said it, could have been somebody else who said it, anything that's a statement made outside of court, whether it's on tape, whether it's on paper, whether it's in a report, and then there are exceptions to let that in. The jury is only supposed to consider the evidence that presented in court. So I'll have to look at that and see how that applies to the Crumbly case, which seems like so many months ago.
Yeah. So the thing is really that one of the examples is really his journal. There's a statement in his journal that says, my parents aren't getting me any mental help, and that is causing me to shoot up the school. That's a criminal accusation. That's accusing his parents that they are making him do this. They're causing him to do this. That's a test that falls under testimonial. A reasonable person would hear that and sounds like something you would use against the parents at trial.
That's
an accusation.
It's an interesting situation. This goes back to Crumbly, and it's a tough case. But there are other factors where the judge says, if we bring this in, we're bringing it all in, right? And the defense is like, I don't want all of it in because, and so there were some other factors. I don't know how that's going to go on appeal, but we'll have to see. Mathis, thank you very much. I'll have to look into that one. I'm not sure if I can do it on lunch because I'm starving.
You might want to ask him civil about it. He might understand it better. But to an amateur, to me, this ruling is like, I knew a case like that had to exist, and that's the Supreme Court case.
That's the one. This judge just spouted it in his,
he knew
findings, which is great, which is wonderful. All right, Mathis, thank you very much. Good hearing from you. Sorry about your phone bill. We'll see if we can get the other ways fixed. So we'll catch you later, my friend.
Okay.
All right.
Have a great day.
Bye.
Bye.
Love it. All right, we are going to we're going to go to lunch over on the Chad Daybell side. For those that are watching, they're just getting back after lunch on that. They're just barely sat down, I think. So we'll see why is it not? I don't think they even have audio yet. But. All right, we have T-minus 24 minutes before we are back. That means I have to be really, really short. Are you serious? That's a quick lunch. Okay, I've got 15 minutes. You guys, we have to go. Tonight, when you go home, please hug the people you love, smile at someone, make their day better, and please stay safe till we go live again in just a few minutes. Remember, tonight we have the podcast as well. So we will be back with the rest of the defense closing arguments, and then we're also going to have the rebuttal from the state. Then this goes into the hands of the jury. It's possible we could have a verdict today. Not sure. Not holding out for that, but it's possible. It would be a very, very quick verdict. I'm thinking the very soonest we could expect it is tomorrow. But we'll be back in just a little bit. You guys be good to each other. Be nice. I'll put the thumbnail up in chat for the next video, and then I'm going to go eat. So that's what I'm going to do. Thank you all. We'll catch you on the flip side. We'll see you. Thanks for the clarification. We get a full lunch. Special guest on the podcast tonight. Don't miss it. We'll see you guys after. Bye-bye.
All right. Thank you, Mr. Bannon. Please be seated.
Alex stolen as well.